Chapter 14, Part 2 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 14th of Homicide, Part 2. Let us next take a view of those circumstances wherein these two species of homicide by misadventure and self-defense agree, and those are in their blame and punishment. For the law sets so high a value upon the life of a man that it always intends some misbehavior in the person who takes it away, unless by the command or express permission of the law. In the case of misadventure, it presumes negligence, or at least a want of sufficient caution in him who was so unfortunate as to commit it, who therefore is not altogether faultless. And as to the necessity which excuses a man who kills another se defendendo, Lord Bacon entitles it necessitas culpabilis, and thereby distinguishes it from the former necessity of killing a thief or a malefactor. For the law intends that the quarrel or assault arose from some unknown wrong, or some provocation either in word or deed, and since in quarrels both parties may be and usually are in some fault, and it scarce can be tried who was originally in the wrong, the law will not hold the survivor entirely guiltless. But it is clear in the other case that where I kill a thief that breaks into my house, the original default can never be upon my side. The law besides may have a farther view, to make the crime of homicide more odious, and to caution men how they venture to kill another upon their own private judgment, by ordaining that he who slays his neighbor without an express warrant from the law to do so shall in no case be absolutely free from guilt. Nor is the law of England singular in this respect. Even the slaughter of enemies required a solemn purgation among the Jews, which implies that the death of a man, however it happens, will leave some stain behind it. And the Mosaical law appointed certain cities of refuge for him who killed his neighbor unawares, as if a man goeth into the woods with his neighbor to hew wood, and his hand fetcheth a stroke with the axe to cut down a tree, and the head slippeth from the helve, and lighteth upon his neighbor that he die, he shall flee unto one of these cities and live. But it seems he was not held wholly blameless any more than in the English law, since the avenger of blood might slay him before he reached his asylum, or if he afterwards stirred out of it till the death of the high priest. In the imperial law likewise casual homicide was excused by the indulgence of the emperor signed with his own sign manual ad natione principis. Otherwise, the death of a man, however committed, was in some degree punishable. Among the Greeks, homicide by misfortune was expiated by voluntary banishment for a year. In Saxony, a fine is paid to the kindred of the slain, which also, among the Western Goths, was little inferior to that of voluntary homicide. And in France, no person is ever absolved in cases of this nature without a largesse to the poor and the charge of certain masses for the soul of the party killed. The penalty inflicted by our laws is said by Sir Edward Coke to have been anciently no less than death, which, however, is with reason denied by later and more accurate writers. It seems rather to have consisted in a forfeiture, some say of all the goods and chattels, others of only part of them, by way of fine or weregild, which was probably disposed of, as in France, in pios usus, according to the humane superstition of the times, for the benefit of his soul who was thus suddenly sent to his account with all his imperfections on his head. But that reason having long ceased, and the penalty, especially if a total forfeiture, growing more severe than was intended, in proportion as personal property has become more considerable, the delinquent has now, and has had as early as our records will reach, a pardon and a writ of restitution of his goods as a matter of course and right, only paying for suing out the same. And indeed, to prevent this expense in cases where the death has notoriously happened by misadventure or in self-defense, the judges will usually permit, if not direct, a general verdict of acquittal. 3. Felonious homicide is an act of a very different nature from the former, being the killing of a human creature of any age or sex without justification or excuse. This may be done either by killing oneself or another man. Self-murder, the pretended heroism but real cowardice of the Stoic philosophers who destroyed themselves to avoid those ills which they had not the fortitude to endure, though the attempting it seems to have been countenanced by civil law, yet was punished by the Athenian law with the cutting off the hand which committed the desperate deed. And also the law of England wisely and religiously considers that no man hath a power to destroy life but by commission from God, the author of it. And as the suicide is guilty of a double offense, one spiritual in invading the prerogative of the Almighty and rushing into his immediate presence uncalled for, the other temporal against the king who hath an interest in the preservation of all his subjects, the law has therefore ranked this among the highest crimes, making it a peculiar species of felony, a felony committed on oneself. A felo de se, therefore, is he that deliberately puts an end to his own existence, or commits any unlawful malicious act, the consequence of which is his own death, as if attempting to kill another he runs upon his antagonist's sword, or, shooting at another, the gun bursts and he kills himself. The party must be of years and discretion, and in his senses, else it is no crime. But this excuse ought not to be strained to that length which our coroners' juries are apt to carry it, viz., that the very act of suicide is an evidence of insanity, as if every man who acts contrary to reason had no reason at all. For the same argument would prove every other criminal non compos as well as the self-murderer. The law very rationally judges that every melancholy or hypochondriac fit does not deprive a man of his capacity of discerning right from wrong, which is necessary, as was observed in the former chapter, to form a legal excuse. And therefore, if a real lunatic kills himself in a lucid interval, he is a felo de se as much as another man. But now the question follows, what punishment can human laws inflict on one who has withdrawn himself from their reach? They can only act upon what he has left behind him, his reputation and fortune. On the former, by an ignominious burial in the highway, with a stake driven through his body. On the latter, by a forfeiture of all his goods and chattels to the king, hoping that his care for either his own reputation or the welfare of his family would be some motive to restrain him from so desperate and wicked an act. And it is observable that this forfeiture has relation to the time of the act done in the felon's lifetime, which was the cause of his death. As if the husband and wife possessed jointly a term of years in land, and the husband drowns himself, the land shall be forfeited to the king, and the wife shall not have it by survivorship. For by the act of casting himself into the water he forfeits the term, which gives a title to the king prior to the wife's title by survivorship, which could not accrue till the instant of her husband's death. And though it must be owned that the letter of the law herein borders a little upon severity, yet it is some alleviation that the power of mitigation is left in the breast of the sovereign, who, upon this, as on all other occasions, is reminded by the oath of his office to execute judgment in mercy. The other species of criminal homicide is that of killing another man. But in this there are also degrees of guilt which divide the offense into manslaughter and murder, the difference between which may be partly collected from what has been incidentally mentioned in the preceding articles, and principally consists in this, that manslaughter arises from the sudden heat of the passions, murder from the wickedness of the heart. 1. Manslaughter is therefore thus defined: the unlawful killing of another without malice either express or implied, which may be either voluntary upon a sudden heat, or involuntary but in commission of some unlawful act. These were called in the Gothic constitutions Homicidia vulgaria, quae aut cosu, aut etiam sponte comituntur, sed in subitaneo quodam irrecondie calore et impetu. And hence it follows that in manslaughter there can be no accessories before the fact, because it must be done without premeditation. As to the first or voluntary branch, if upon a sudden quarrel two persons fight, and one of them kills the other, this is manslaughter. And so it is if they upon such occasion go out and fight in a field, for this is one continued act of passion. And the law pays that regard to human frailty, as not to put a hasty and a deliberate act upon the same footing with regard to guilt. So also, if a man be greatly provoked, as by pulling his nose or other great indignity, and immediately kills the aggressor, though this is not an excusable se defendendo, since there is no absolute necessity for doing it to preserve himself, yet neither is it murder, for there is no previous malice, but it is manslaughter. But in this and in every other case of homicide upon provocation, if there be a sufficient cooling time for passion to subside and reason to interpose, and the person so provoked afterwards kills the other, this is deliberate revenge and not heat of blood, and accordingly amounts to murder. So if a man takes another in the act of adultery with his wife, and kills him directly on the spot, though this was allowed by the laws of Solon, and likewise by the Roman civil law, if the adulterer was found in the husband's house, and also among the ancient Goths, yet in England it is not absolutely ranked in the class of justifiable homicide, as in case of a forcible rape, but is manslaughter. It is, however, the lowest degree of it, and therefore in such a case the court directed the burning in the hand to be gently inflicted, because there could not be a greater provocation. Manslaughter, therefore, on a sudden provocation differs from excusable homicide se defendendo in this, that in one case there is an apparent necessity for self-preservation to kill the aggressor, in the other no necessity at all, being only a sudden act of revenge. The second branch, or involuntary manslaughter, differs also from homicide excusable by misadventure in this, that misadventure always happens in consequence of a lawful act, but this species of manslaughter in consequence of an unlawful one. As if two persons play at sword and buckler, unless by the king's command, and one of them kills the other, this is manslaughter, because the original act was unlawful, but it is not murder, for the one had no intent to do the other any personal mischief. So, where a person does an act, lawful in itself, but in an unlawful manner, and without due caution and circumspection, as when a workman flings down a stone or piece of timber into the street and kills a man, this may be either misadventure, manslaughter, or murder, according to the circumstances under which the original act was done. If it were in a country village where few passengers are, and he calls out to all the people to have a care, it is misadventure only. But if it were in London or other populous town where people are continuously passing, it is manslaughter, though he gives loud warning, and murder if he knows of their passing and gives no warning at all, for then it is malice against all mankind. And in general, when an involuntary killing happens in consequence of an unlawful act, it will be either murder or manslaughter according to the nature of the act which occasioned it. If it be in prosecution of a felonious intent, it will be murder. But if no more was intended than a mere trespass, it will only amount to manslaughter. Next, as to the punishment of this degree of homicide. The crime of manslaughter amounts to felony, but within the benefit of clergy, and the offender shall be burnt in the hand and forfeit all his goods and chattels. But there is one species of manslaughter which is punished as murder, the benefit of clergy being taken away from it by statute, namely the offense of mortally stabbing another, though done upon sudden provocation. For by statute 1 James I, c. 8, when one thrusts or stabs another, not then having a weapon drawn, or who hath not then first stricken the party stabbing, so that he dies thereof within 6 months after, the offender shall not have the benefit of clergy, though he did it not of malice aforethought. This statute was made on account of the frequent quarrels and stabbings with short daggers between the Scotch and the English at the accession of James I, and being therefore of a temporary nature, ought to have expired with the mischief which it meant to remedy. For in point of solid and substantial justice, it cannot be said that the mode of killing, whether by stabbing, strangling, or shooting, can either extenuate or enhance the guilt, unless where, as in the case of poisoning, it carries with it an internal evidence of cool and deliberate malice. But the benignity of the law hath construed the statute so favorably in behalf of the subject, and so strictly went against him, that the offense of stabbing stands almost upon the same footing as it did at the common law. Thus, not to repeat the cases before mentioned of stabbing an adulteress, etc., which are barely manslaughter as at common law, in the construction of this statute it hath been doubted whether, if the deceased had struck at all before the mortal blow given, this takes it out of the statute, though in the preceding quarrel the stabber had given the first blow, and it seems to be the better opinion that this is not within the statute. Also, it hath been resolved that the killing a man by throwing a hammer or other weapon is not within the statute, and whether a shot with a pistol be so or not is doubted. But if the party slain had a cudgel in his hand, or had thrown a pot or a bottle, or discharged a pistol at the party stabbing, this is a sufficient having a weapon drawn on his side within the words of the statute. End of chapter the 14th, part 2. Chapter 14, Part 3 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 14th of Homicide, Part 3. 2. We are next to consider the crime of deliberate and willful murder, a crime at which human nature starts, and which is, I believe, punished almost universally throughout the world with death. The words of the Mosaical law, over and above the general precept to Noah that whoso sheddeth man's blood, by man shall his blood be shed, are very emphatical in prohibiting the pardon of murderers. Moreover, ye shall take no satisfaction for the life of a murderer who is guilty of death, but he shall surely be put to death. For the land cannot be cleansed of the blood that is shed therein, but by the blood of him that shed it. And therefore our law has provided one course of prosecution, that by appeal, of which hereafter, wherein the king himself is excluded the power of pardoning murder, so that were the King of England so inclined, he could not imitate that Polish monarch mentioned by Pufendorf, who thought proper to remit the penalties of murder to all the nobility in an edict with this arrogant preamble, Nos divini juris regorum madurantes, etc. But let us now consider the definition of this great offense. The name of murder was anciently applied only to the secret killing of another, which the word moerda signifies in the Teutonic language, and it was defined homicidium quod nullo vidente, nullo sciente, clam perpetrator, for which the vil wherein it was committed, or, if that were too poor, the whole hundred was liable to a heavy amercement, which amercement itself was also denominated murderum. This was an ancient usage among the Goths in Sweden and Denmark, who supposed the neighborhood, unless they produced the murderer, to have perpetrated or at least connived at the murder, and according to Bracton was introduced into this kingdom by King Canute to prevent his countrymen the Danes from being privily murdered by the English, and was afterwards continued by William the Conqueror for the like security to his own Normans. And therefore if, upon inquisition had, it appeared that the person found slain was an Englishman, the presentment whereof was denominated Inglesherry, the country seems to have been excused from this burthen. But this difference being totally abolished by Statute 14 Edward III c. 4, we must now, as is observed by Staunford, define murder in quite another manner, without regarding whether the party slain was killed openly or secretly, or whether he was of English or foreign extraction. Murder is therefore now thus defined, or rather described, by Sir Edward Coke: when a person of sound memory and discretion unlawfully killeth any reasonable creature in being and under the king's peace, with malice aforethought, either express or implied. The best way of examining this nature of crime will be by considering the several branches of this definition. First, it must be committed by a person of sound memory and discretion, for a lunatic or infant, as was formerly observed, are incapable of committing any crime unless in such cases where they show a consciousness of doing wrong and of course a discretion or discernment between good and evil. Next, it happens when a person of such sound discretion unlawfully killeth. The unlawfulness arises from the killing without warrant or excuse, and there must also be an actual killing to constitute murder, for a bare assault with intent to kill is only a great misdemeanor, though formerly it was held to be murder. The killing may be by poisoning, striking, starving, drowning, and 1,000 other forms of death by which human nature may be overcome. Of these, the most detestable of all is poison, because it can of all the others be the least prevented either by manhood or forethought. And therefore, by the statute 22 Henry VIII c. 9, it was made treason, and a more grievous and lingering kind of death was inflicted on it than the common law allowed, namely, boiling to death. But this act did not live long, being repealed by 1 Edward VI c. 12. There was also by the ancient common law one species of killing held to be murder, which is hardly so at this day, nor has there been any instance wherein it has been held to be murder for many ages past. I mean by bearing false witness against another with an express premeditated design to take away his life, so as the innocent person be condemned and executed. The Gothic laws punished in this case both the judge, the witnesses, and the prosecutor. Peculiari poena judicium poniunt, peculiari testis, quarum fides judicium seduxit, peculiari denique et maxim actorem ut homicidum. And among the Romans, the lex Cornelia de Sicaris will punish the false witness with death as being guilty of a species of assassination. And there is no doubt but this is equally murder in foro conscientiae as killing with a sword, though the modern law, to avoid the danger of deterring witnesses from giving evidence upon capital prosecutions if it must be at the peril of their own lives, has not yet punished it as such. If a man, however, does such an act, of which the probable consequence may be and eventually is death, such killing may be murder, although no stroke be struck by himself, as was the case of the unnatural son who exposed his sick father to the air against his will, by reason whereof he died, and of the harlot who laid her child in an orchard, where a kite struck it and killed it. So too, if a man hath a beast that is used to do mischief, and he, knowing it, suffers it to go abroad, and it kills a man, even this is manslaughter in the owner. But if he had purposely turned it loose, though barely to frighten people and make what is called sport, it is with us, as in the Jewish law, as much murder as if he had incited a bear or a dog to worry them. If a physician or surgeon gives his patient a potion or plaister to cure him, which contrary to expectation kills him, this is neither murder nor manslaughter, but misadventure, and he shall not be punished criminally, however liable he might formerly have been to a civil action for neglect or ignorance. But it hath been holden that if it not be a regular physician or surgeon who administers the medicine or performs the operation, it is manslaughter at the least. Yet Sir Matthew Hale very justly questions the law of this determination, since physic and salves were in use before licensed physicians and surgeons, wherefore he treats this doctrine as apocryphal and fitted only to gratify and flatter licentiates and doctors in physic, though it may be of use to make people cautious and wary how they meddle too much in so dangerous an employment. In order also to make the killing murder, it is requisite that the party die within a year and a day after the stroke received or cause of death administered, in the computation of which the whole day upon which the hurt was done shall be reckoned the first. Farther, the person killed must be a reasonable creature in being and under the king's peace at the time of the killing. Therefore, to kill an alien, a Jew, or an outlaw, who are all under the king's peace or protection, is as much murder as to kill the most regular born Englishman, except he be an alien enemy in time of war. To kill a child in its mother's womb is now no murder, but a great misprision. But if the child be born alive and dieth by reason of the potion or bruises it received in the womb, it is murder in such as administered or gave them. But as there is one case where it is difficult to prove the child's being born alive, namely, in the case of the murder of bastard children by the unnatural mother, it is enacted by statute 21 James I, c. 27, that if any woman be delivered of a child which if born alive should by law be a bastard, and endeavors privately to conceal its death by burying the child or the like, the mother so offending shall suffer death as in the case of murder, unless she can prove by one witness at least that the child was actually born dead. This law, which favors pretty strongly of severity in making the concealment of the death almost conclusive evidence of the child's being murdered by the mother, is nevertheless to be also met with in the criminal codes of many other nations of Europe, as the Danes, the Swedes, and the French. But I apprehend it has of late years been unusual with us in England upon trials for this offence to require some sort of presumptive evidence that the child was born alive before the other constrained presumption that the child whose death is concealed was therefore killed by his parent is admitted to convict the prisoner. Lastly, the killing must be committed with malice aforethought to make it the crime of murder. This is the grand criterion which now distinguishes murder from other killing, and this malice prepense, malitia praecogitata, is not so properly spite or malevolence to the deceased in particular as any evil design in general, the dictate of a wicked, depraved, and malignant heart, un disposition a fare un male chose, and it may be either express or implied in law. Express malice is when one with a sedate deliberate mind and formed design doth kill another, which formed design is evidenced by external circumstances discovering that inward intention, as lying in wait, antecedent menaces, former grudges, and concerted schemes to do him some bodily harm. This takes in the case of deliberate dueling, where both parties meet avowedly with an intent to murder, thinking it their duty as gentlemen and claiming it as their right to wanton with their own lives and those of their fellow creatures, without any warrant or authority from any power either divine or human, but in direct contradiction to the laws both of God and man, and therefore the law has justly fixed the crime and punishment of murder on them and their seconds also. Yet it requires such a degree of passive valor to combat the dread of even undeserved contempt arising from the false notions of honor too generally received in Europe, that the strongest prohibitions and penalties of the law will never be entirely effectual to eradicate this unhappy custom, till a method be found out of compelling the original aggressor to make some other satisfaction to the affronted party, which the world shall esteem equally reputable as that which is now given at the hazard of life and fortune, as well as of the person insulted as of him who hath given the insult. Also, even if upon sudden provocation one beats another in a cruel and unusual manner so that he dies, though he did not intend his death, yet he is guilty of murder by express malice, that is, by an express evil design, the genuine sense of malitia. As when a park keeper tied a boy that was stealing wood to a horse's tail and dragged him along the park, when a master corrected his servant with an iron bar, and a schoolmaster stamped on his scholar's belly, so that each of the sufferers died. These were justly held to be murders, because the correction being excessive, and such as could not proceed but from the bad heart, it was equivalent to a deliberate act of slaughter. Neither shall he be guilty of a less crime who kills another in consequence of such a wilful act as shows him to be an enemy to all mankind in general, as going deliberately with a horse used to strike, or discharging a gun among a multitude of people. So if a man resolves to kill the next man he meets, and does kill him, it is murder, although he knew him not, for this is universal malice. And if two or more come together to do an unlawful act against the king's peace, of which the probable consequence might be bloodshed, as to beat a man, to commit a riot, or to rob a park, and one of them kills a man, it is murder in them all, because of the unlawful act, the malitia praecogitata, or evil intended beforehand. Also, in many cases where no malice is expressed, the law will imply it, as where a man wilfully poisons another. In such a deliberate act the law presumes malice, though no particular enmity can be proved. And if a man kills another suddenly, without any or without a considerable provocation, the law implies malice, for no person, unless of an abandoned heart, would be guilty of such an act upon a slight or no apparent cause. No affront by words or gestures only is a sufficient provocation so as to excuse or extenuate such acts of violence as manifestly endanger the life of another. But if the person so provoked had unfortunately killed the other by beating him in such a manner as showed only an intent to chastise and not to kill him, the law so far considers the provocation of contumelious behavior as to adjudge it only manslaughter and not murder. In like manner, if one kills an officer of justice, either civil or criminal, in the execution of his duty, or any of his assistants endeavoring to conserve the peace, or any private person endeavoring to suppress an affray or apprehend a felon, knowing his authority or the intention with which he interposes, the law will imply malice, and the killer shall be guilty of murder. And if one intends to do another felony and undesignedly kills a man, this is also murder. Thus, if one shoots at A and misses him, but kills B, this is murder, because of the previous felonious intent which the law transfers from one to the other. The same is the case where one lays poison for A, and B, against whom the prisoner had no malicious intent, takes it, and it kills him. This is likewise murder. It were endless to go through all the cases of homicide which have been adjudged either expressly or impliedly malicious. These therefore may suffice as a specimen, and we may take it for a general rule that all homicide is malicious and of course amounts to murder, unless where justified by the command or permission of law, excused on a principle of accident or self-preservation, or alleviated into manslaughter by being either the involuntary consequence of some act not strictly lawful, or, if voluntary, occasioned by some sudden and sufficiently violent provocation. In all these circumstances of justification, excuse, or alleviation, it is incumbent upon the prisoner to make out to the satisfaction of the court and jury, the latter of whom are to decide whether the circumstances alleged be proved to have actually existed, the former how far they extend to take away or mitigate the guilt. For all homicide is presumed to be malicious until the contrary appeareth upon evidence. The punishment of murder and that of manslaughter were formerly one and the same, both having the benefit of clergy, so that none but unlearned persons who at least knew the guilt of it were put to death for this enormous crime. But now, by statute 23 Henry VIII c. 1 and 1 Edward VI c. 12, the benefit of clergy is taken away from murder, though malice prepense. In atrocious cases it was frequently usual for the court to direct the murderer, after execution, to be hung upon a gibbet in chains near the place where the fact was committed. But this was no part of the legal judgment, and the like is still sometimes practiced in the case of notorious thieves. This being quite contrary to the express command of the Mosaical law, seems to have been borrowed from the civil law, which, besides the terror of the example, gives also another reason for this practice, viz., that it is a comfortable sight to the relations and friends of the deceased. But now in England it is enacted by statute 25 George II c. 37, that the judge before whom a murderer is convicted shall in passing sentence direct him to be executed on the next day but one, unless the same shall be a Sunday, then on the Monday following, and that his body be delivered to the surgeons to be dissected and anatomized, and that the judge may direct his body to be afterwards hung in chains, but in no wise to be buried without dissection. And during the short but awful interval between sentence and execution, the prisoner shall be kept alone and sustained with only bread and water. But a power is allowed to the judge, upon good and sufficient cause, to respite the execution and relax the other restraints of this act. By the Roman law, parricide, or the murder of one's parents or children, was punished in a much severer manner than any other kind of homicide. After being scourged, the delinquents were sewn up in a leathern sack with a live dog, a cock, a viper, and an ape, and so cast into the sea. Solon, it is true, in his laws made none against parricide, apprehending it impossible that any one should be guilty of so unnatural a barbarity. And the Persians, according to Herodotus, entertained the same notion when they adjudged all persons who killed their reputed parents to be bastards. And upon some such reason as this, we must account for the omission of an exemplary punishment for this crime in our English laws, which treat it no otherwise than as simple murder, unless the child was also the servant of his parent. For though the breach of natural relation is unobserved, yet the breach of civil or ecclesiastical connections, when coupled with murder, denominates it a new offence, no less than the species of treason called parva proditio, or petite treason, which, however, is nothing else but an aggravated degree of murder, although, on account of the violation of private allegiance, it is stigmatized as an inferior species of treason. And thus, in the ancient Gothic constitution, we find the breach both of natural and civil relations ranked in the same class with crimes against the state and the sovereign. Petite treason, according to the statute 25 Edward III c. 2, may happen in three ways: by a servant killing his master, a wife her husband, or an ecclesiastical person, either secular or regular, his superior, to whom he owes faith and obedience. A servant who kills his master whom he has left, upon a grudge conceived against him during his service, is guilty of petite treason, for the traitorous intention was hatched while the relation subsisted between them, and this is only an execution of that intention. So if a wife be divorced a mensa et toro, still the vinculum matrimoni subsists, and if she kills such divorced husband, she is a traitress. And a clergyman is understood to owe canonical obedience to the bishop who ordained him, to him in whose diocese he is beneficed, and also to the metropolitan of such suffragan or diocesan bishop, and therefore to kill any of these is petite treason. As to the rest, whatever has been said or remains to be observed hereafter with respect to wilful murder is also applicable to the crime of petite treason, which is no other than murder in its most odious degree, except that the trial be as in cases of high treason, before the improvements therein made by the statutes of William III, and also except in its punishment. The punishment of petite treason in a man is to be drawn and hanged, and in a woman to be drawn and burned, the idea of which latter punishment seems to have been handed down to us from the laws of the ancient Druids, which condemned a woman to be burned for murdering her husband, and it is now the usual punishment for all sorts of treasons committed by those of the female sex. Persons guilty of petite treason were first debarred the benefit of clergy by the Statute 12, Henry VII, c. 7. End of chapter the 14th, part 3. Chapter 15, Part 1 of the Commentaries on the Laws of England, Book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 15th of Offenses Against the Persons of Individuals, Part 1. Having in the preceding chapter considered the principal crime or public wrong that can be committed against a private subject, namely by destroying his life, I proceed now to inquire into such other crimes and misdemeanors as more particularly affect the security of his person while living. Of these, some are felonious and in their nature capital, others are simple misdemeanors and punishable with a lighter animadversion. Of the felonies, the first is that of mayhem. 1. Mayhem, mahemium, was in part considered in the preceding volume as a civil injury, but is also looked upon in a criminal light by the law, being an atrocious breach of the king's peace and an offense tending to deprive him of the aid and assistance of his subjects. For mayhem is properly defined to be, as we may remember, the violently depriving another of the use of such of his members as may render him the less able in fighting either to defend himself or to annoy his adversary, and therefore cutting off or disabling or weakening a man's hand or finger, or striking out his eye or foretooth, or depriving him of those parts, the loss of which in all animals abates their courage, are held to be mayhems. But the cutting off his ear, or nose, or the like, are not held to be mayhems at common law, because they do not weaken, but only disfigure him. By the ancient law of England, he that maimed any man whereby he lost any part of his body was sentenced to lose the like part, membrum pro membro, which is still the law in Sweden. But this went afterwards out of use, partly because the law of retaliation, as was formerly shown, is at best an inadequate rule of punishment, and partly because upon repetition of the offense the punishment could not be repeated. So that by the common law, as it for a long time stood, mayhem was only punishable with fine and imprisonment, unless perhaps the offense of mayhem by castration, which all our old writers held to be felony, et sequitur aliquando poena capitalis, aliquando perpetuum elixium, cum omnium bonorum ademptioni. And this, although the mayhem was committed upon the highest provocation. But subsequent statutes have put the crime and punishment of mayhem more out of doubt. For first, by Statute 5 Henry IV, c. 5, to remedy a mischief that then prevailed of beating, wounding, or robbing a man, and then cutting out his tongue or putting out his eyes to prevent him from being in evidence against them, this offense is declared to be a felony if done of malice prepense, that is, as Sir Edward Coke explains it, voluntarily and of set purpose, though done upon a sudden occasion. Next in order of time is the statute 37 Henry VIII, c. 6, which directs that if a man shall maliciously and unlawfully cut off the ear of any of the king's subjects, he shall not only forfeit treble damages to the party grieved to be recovered by action of trespass at common law as a civil satisfaction, but also £10 by way of fine to the king, which was his criminal amercement. The last statute, but by far the most severe and effectual of all, is that of 22 and 23 Charles II, c. 1, called the Coventry Act, being occasioned by an assault on Sir John Coventry in the street, and slitting his nose in revenge, as was supposed, for some obnoxious words uttered by him in Parliament. By this statute it is enacted that if any person shall of malice aforethought, and by lying in wait, unlawfully cut out or disable the tongue, put out an eye, slit the nose, cut off a nose or lip, or cut off or disable any limb or member of any other person with intent to maim or to disfigure him, such person, his counselors, aiders, and abettors shall be guilty of felony without benefit of clergy. Thus much for the felony of mayhem, to which may be added the offense of wilfully and maliciously shooting at any person which may endanger either killing or maiming him. This, though no such evil consequence ensues, is made felony without benefit of clergy by statute 9 George I. c. 22, and thereupon one Arnold was convicted in 1723 for shooting at Lord Onslow, but being half a madman was never executed, but confined in prison, where he died about 30 years after. 2. The second offense more immediately affecting the personal security of individuals relates to the female part of His Majesty's subjects, being that of their forcible abduction and marriage, which is vulgarly called stealing an heiress. For by Statute 3 Henry VII c. 2 it is enacted, that if any person shall for lucre take any woman, being maid, widow, or wife, and having substance either in goods or lands, or being heir apparent to her ancestors contrary to her will, and afterwards she be married to such misdoer, or by his consent to others, or defiled, such person and all his accessories shall be deemed principal felons. And by Statute 39 Elizabeth c. 9, the benefit of clergy is taken away from all such felons except accessories after the offense. In the construction of this statute it hath been determined, 1. That the indictment must allege that the taking was for lucre, for such are the words of the statute. 2. In order to show this, it must appear that the woman has substance, either real or personal, or is an heir apparent. 3. It must appear that she was taken away against her will. 4. It must also appear that she was afterwards married or defiled. And though possibly the marriage or defilement might be by her subsequent consent, being won thereunto by flatteries after the taking, yet this is felony if the first taking were against her will, and so vice versa, if the woman be originally taken away with her own consent, yet if she afterwards refuse to continue with the offender, and be forced against her will, she may from that time as properly be said to be taken against her will, as if she never had given any consent at all, for till the force was put upon her she was in her own power. It is held that a woman thus taken away and married may be sworn and give evidence against the offender, though he is her husband de facto, contrary to the general rule of law, because he is no husband de jure in case the actual marriage was also against her will. In cases indeed where the actual marriage is good, by the consent of the inveigled woman obtained after her forcible abduction, Sir Matthew Hale seems to question how far her evidence should be allowed, but other authorities seem to agree that it should even then be admitted, esteeming it absurd that the offender should thus take advantage of his own wrong, and that the very act of marriage, which is a principal ingredient of his crime, should, by a forced construction of law, be made use of to stop the mouth of the most material witness against him. An inferior degree of the same kind of offense, but not attended with force, is punished by the statute 4 and 5 Philip and Mary c. 8, which enacts that if any person above the age of 14 unlawfully shall convey or take away any woman child unmarried, which is held to extend to bastards as well as to legitimate children, within the age of 15 years from the possession and against the will of the father, mother, guardians, or governors, he shall be imprisoned 2 years or fined at the discretion of the justices. And if he deflowers such maid or woman child, or, without the consent of parents, contracts matrimony with her, he shall be imprisoned 5 years, or fined at the discretion of the justices, and she shall forfeit all her lands to her next of kin during the life of her said husband. So that as these stolen marriages under the age of 15 were usually upon mercenary views, This act, besides punishing the seducer, wisely removed the temptation. But this latter part of the act is now rendered almost useless by provisions of a very different kind which make the marriage totally void in the statute 26 George II, c. 33. 3. A third offence against the female part also of His Majesty's subjects, but attended with greater aggravations than that of forcible marriage, is the crime of rape, raptus mulierum, or the carnal knowledge of a woman forcibly and against her will. This, by the Jewish law, was punished with death in case the damsel was betrothed to another man, and in case she was not betrothed, then a heavy fine of 50 shekels was to be paid to the damsel's father, and she was to be the wife of the ravisher all the days of his life, without the power of divorce which was in general permitted by the Mosaic law. The civil law punishes the crime of ravishment with death and confiscation of goods, under which it includes both the offense of forcible abduction, or taking away a woman from her friends, of which we last spoke, and also the present offense of forcibly dishonoring them, either of which without the other is in law sufficient to constitute a capital crime. Also, stealing away a woman from her parents or guardians and debauching her is equally penal by the emperor's edict whether she consent or is forced. Sive volentibus, sive nolentibus mulieribus, tale facinas fuerit perpetratum. And this in order to take away from women every opportunity of offending in this way, whom the Roman laws suppose never to go astray without the seduction and arts of the other sex. And therefore, by restraining and making so highly penal the solicitations of the men, they meant to secure effectually the honor of the women. Si enim ipsi raptores metu, veletrociate poene, ab hujus modi facinore se temperaverent, muli mulieri, sive volente, sive nolente, peccande locis reliquentor, quia hac ipsum vela mulierum, ab insidius nequissimi hominis, qui meditator rapinam inducitor. Nisi etenem eam soliciverit, nisi odiosis artibus circumvenerit, non facit eam velle entatum deducas sese prodere. But our English law does not entertain quite such sublime ideas of the honor of either sex as to lay the blame of a mutual fault upon one of the transgressors only, and therefore makes it a necessary ingredient in the crime of rape that it must be against the woman's will. Rape was punished by the Saxon laws, particularly those of King Athelstan, with death, which was also agreeable to the Old Gothic or Scandinavian constitution. But this was afterwards thought too hard, and in its stead another severe but not capital punishment was inflicted by William the Conqueror, viz., castration and loss of eyes, which continued till after Bracton wrote in the reign of Henry III. But in order to prevent malicious accusations, it was then the law, and it seems still continues to be so in appeals of rape, that the woman should immediately after, dum recens fuerit maleficium, go to the next town, and there make discovery to some credible persons of the injury she has suffered, and afterwards should acquaint the high constable of the hundred, the coroners, and the sheriff with the outrage. This seems to correspond in some degree with the laws of Scotland and Aragon, which require that complaint must be made within 24 hours, though afterwards, by statute Westminster 1, c. 13, the time of limitation in England was extended to 40 days. At present, there is no time of limitation fixed, for as it is usually now punished by indictment at the suit of the king, the maxim of law takes place, that nullum tempus occurrit regi. But the jury will rarely give credit to stale complaint. During the former period also it was held for law that the woman, by consent of the judge and her parents, might redeem the offender from the execution of his sentence by accepting him for her husband, if he also was willing to agree to the exchange, but not otherwise. In the 3 Edward I by the Statute Westminster 1 C13, the punishment of rape was much mitigated, the offence itself being reduced to a trespass, if not prosecuted by the woman within 40 days, and subjecting the offender only to 2 years' imprisonment and a fine at the king's will. But this lenity being productive of the most terrible consequences, it was in 10 years afterwards, 13 Edward I, found necessary to make the offence of rape felony by Statute Westminster 2 C34. And by Statute 18 Elizabeth C7 it is made felony without benefit of clergy, as is also the abominable wickedness of carnally knowing or abusing any woman child under the age of 10 years, in which case the consent or non-consent is immaterial, as by reason of her tender years she is incapable of judgment and discretion. Sir Matthew Hale is indeed of the opinion that such profligate actions committed on an infant under the age of 12 years, the age of female discretion by the common law, either with or without consent, amount to rape and felony, as well since as before the statute of Queen Elizabeth, but the law has in general been held only to extend to infants under 10. A male infant under the age of 14 years is presumed by law incapable to commit a rape, and therefore, it seems, cannot be found guilty of it. For though in other felonies malitia supplet aetatem, as has in some cases been shown, yet as to this particular species of felony the law supposes an imbecility of body as well as mind. The civil law seems to suppose a prostitute or common harlot incapable of any injuries of this kind, not allowing any punishment for violating the chastity of her, who hath indeed no chastity at all, or at least hath no regard to it. But the law of England does not judge so hardly of offenders as to cut off all opportunity of retreat even from common strumpets, and to treat them as never capable of amendment. It therefore holds to be felony to force even a concubine or a harlot, because the woman may have forsaken that unlawful course of life. For, as Bracton well observes, Lice meretrix fuerit entia, certe tunc temporis non sut, cum reclamando nequitie ejus consentere noluit. As to the material facts requisite to be given in evidence and proved upon an indictment of rape, they are of such a nature that though necessary to be known and settled for the conviction of the guilty and preservation of the innocent, and therefore are to be found in such criminal treatises as discourse of these matters in detail, yet they are highly improper to be publicly discussed except only in a court of justice. I shall therefore merely add upon this head a few remarks from Sir Matthew Hale with regard to the competency and credibility of witnesses, which may, salvo pudore, be considered. And first, the party ravished may give evidence upon oath and is in law a competent witness. But the credibility of her testimony and how far forth she is to be believed must be left to the jury upon the circumstances of fact that concur in the testimony. For instance, if the witness be of good fame, if she presently discovered the offense and made search for the offender, if the party accused fled for it, these and the like are concurring circumstances which give greater probability to her evidence. But on the other side, if she be of evil fame, and stand unsupported by others, if she conceal the injury for any considerable time after she had opportunity to complain, if the place where the act was alleged to be committed was where it was possible she might have been heard and she made no outcry, these and the like circumstances carry a strong but not conclusive presumption that her testimony is false or feigned. Moreover, if the rape be charged to be committed on an infant under 12 years of age, she may still be a competent witness if she hath sense and understanding to know the nature and obligations of an oath. And even if she hath not, it is thought by Sir Matthew Hale that she ought to be heard without oath to give the court information, though that alone will not be sufficient to convict the offender. And he is of this opinion, first, because the nature of the offense being secret, there may be no other possible proof of the actual fact, though afterwards there may be concurrent circumstances to corroborate it, proved by other witnesses; and secondly, because the law allows what the child told her mother or other relations to be given in evidence, since the nature of the case admits frequently to no better proof, and there is much more reason for the court to hear the narration of the child herself than to receive it at second hand from those who swear they heard her say so. And indeed it is now settled that infants of any age are to be heard, and if they have any idea of an oath, to be also sworn, it being found by experience that infants of very tender years often give the clearest and truest testimony. But in any of these cases, whether the child be sworn or not, it is to be wished, in order to render her evidence credible, that there should be some concurrent testimony of time, place, and circumstances in order to make out the fact, and that the conviction should not be grounded singly on the unsupported accusation of an infant under years of discretion. There may be, therefore, in cases of this nature, witnesses who are competent, that is, who may be admitted to be heard, and yet, after being heard, may prove not to be credible, or such as the jury is bound to believe. For one excellence of the trial by jury is, that the jury are triers of the credit of the witnesses, as well as of the truth of the fact. It is true, says this learned judge, that rape is a most detestable crime, and therefore ought severely and impartially to be punished with death. But it must be remembered that it is an accusation easy to be made, hard to be proved, but harder to be defended by the party accused, though innocent. He then relates two very extraordinary cases of malicious prosecution for this crime that had happened within his own observation, and concludes thus. I mention these instances that we may be the more cautious upon trials of offenses of this nature, wherein the court and jury may with so much ease be imposed upon without great care and vigilance, the heinousness of the offense many times transporting the judge and jury with so much indignation that they are over hastily carried to the conviction of the person accused thereof by the confident testimony of sometimes false and malicious witnesses. End of chapter the 15th, part 1. Chapter 15, part 2 of the Commentaries on the Laws of England, book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 15th of Offenses Against the Persons of Individuals, Part 2. 4. What has been here observed, especially with regard to the manner of proof, which ought to be the more clear in proportion as the crime is the more detestable, may be applied to another offense of a still deeper malignity, the infamous crime against nature committed either with man or beast. A crime which ought to be strictly and impartially proved, and then as strictly and impartially punished. But it is an offense of so dark a nature, so easily charged, and the negative so difficult to be proved, that the accusation should be clearly made out. For if false, it deserves a punishment inferior only to that of the crime itself. I will not act so disagreeable part to reduce my readers as well as myself as to dwell any longer upon a subject the very mention of which is a disgrace to human nature. It will be more eligible to imitate in this respect the delicacy of our English law, which treats it, in its very indictments, as a crime not fit to be named. Peccatum iliud horribile inter Christianos non nominandum. A taciturnity observed likewise by the edict of Constantius and Constans. Ubi celest est id, quam no proficit scire, jubemos insurgere legis, armare jura gladio ultore, ut exquisitis poenis salvadantur infames, qui sunt, vel qui futuri sunt, re. which leads me to add a word concerning its punishment. This the voice of nature and reason, and the express law of God determined to be capital, of which we have a single instance long before the Jewish dispensation by the destruction of 2 cities by fire from heaven, so that this is an universal, not merely a provincial precept. And our ancient law in some degree imitated this punishment by commanding such miscreants to be burnt to death, though Fleta says they should be buried alive, either of which punishments was indifferently used for this crime by the ancient Goths. But now the general punishment of all felonies is the same, namely by hanging. And this offense, being in times of popery only subject to ecclesiastical censures, was made felony without benefit of clergy by Statute 25 Henry VIII c. 6, revived and confirmed by 5 Elizabeth c. 17, and the rule of law herein is, that if both are arrived at years of discretion, et gentis et conscientis pari poena plecantur. These are all the felonious offenses more immediately against the personal security of the subject. The inferior offenses or misdemeanors that fall under this head are assaults, batteries, wounding, false imprisonment, and kidnapping. 5, 6, and 7. With regard to the nature of the first 3 of these offenses in general, I have nothing farther to add to what has already been observed in the preceding book of these commentaries, when we consider them as private wrongs or civil injuries, for which a satisfaction or remedy is to be given to the party aggrieved. But taken in a public light, as a breach of the king's peace, an affront to his government, and a damage done to his subjects, they are also indictable and punishable with fine and imprisonment, or with other ignominious corporal penalties where they are committed with any very atrocious design, as in case of an assault with an intent to murder, or with an intent to commit either of the crimes last spoken of, for which intentional assaults, in the last 2 cases, indictments are more usual than for the absolute perpetration of the facts themselves, on account of the difficulty of proof. And herein, besides heavy fine and imprisonment, it is usual to award judgment of the pillory. There is also one species of battery more atrocious and penal than the rest, which is the beating of a clerk in orders or clergyman, on account of the respect and reverence due to his sacred character as the minister and ambassador of peace. Accordingly, it is enacted by the statute called Articuli Cleri, 9 Edward II c. 3, that if any person lay violent hands upon a clerk, the amends for the peace broken shall be before the king, that is, by indictment in the king's courts. And the assailant may also be sued before the bishop that excommunication or bodily penance may be imposed, which if the offender will redeem by money to be given to the bishop or party grieved, it might be sued for before the bishop. Whereas otherwise to sue in any spiritual court for civil damages for the battery falls within the danger of praemunire. But suits are and always were allowed in the spiritual court for money agreed to be given as a commutation for penance, so that upon the whole it appears that a person guilty of such brutal behavior to a clergyman is subject to 3 kinds of prosecution, all of which may be pursued for one and the same offense: an indictment for the breach of the king's peace by such assault and battery, a civil action for the special damage sustained by the party injured, and a suit in the ecclesiastical court, first pro correctione et salute animae, by enjoining penance, and then again for such sum of money as shall be agreed on for taking off the penance enjoined, it being usual in those courts to exchange their spiritual censures for a round of compensation in money, perhaps because poverty is generally esteemed by the moralists the best medicine pro salute animae. 8. The 2 remaining crimes and offenses against the persons of His Majesty's subjects are infringements of their natural liberty, concerning the first of which, false imprisonment, in its nature and incidents, I must content myself with referring the student to what was observed in the preceding volume when we considered it as a mere civil injury. But besides the private satisfaction given to the individual by action, the law also demands public vengeance for the breach of the king's peace, for the loss which the state sustains by the confinement of one of its members, and for the infringement of the good order of society. We have before seen that the most atrocious degree of this offense, that of sending any subject of this realm a prisoner into parts beyond the seas, whereby he is deprived of the friendly assistance of the laws to redeem him from such his captivity, is punished with the pains of praemunere and incapacity to hold any office without any possibility of pardon. Inferior degrees of the same offense of false imprisonment are also punishable by indictment like assaults and batteries, and the delinquent may be fined and imprisoned. And indeed there can be no doubt but that all kinds of crimes of a public nature, all disturbances of the peace, all oppressions and other misdemeanors whatsoever of a notoriously evil example may be indicted at the suit of the king. 9. The other remaining offense, that of kidnapping, being the forcible abduction or stealing away of man, woman, or child from their own country and selling them into another, was capital by the Jewish law. He that stealeth a man and selleth him, or if he be found in his hand, shall surely be put to death. So likewise in the civil law the offense of spiriting away and stealing men and children, which was called plagium, and the offenders plagiari, was punished with death. This is unquestionably a very heinous crime, as it robs the king of his subjects, banishes a man from his country, and may in its consequences be productive of the most cruel and disagreeable hardships, and therefore the common law of England has punished it with fine, imprisonment, and pillory. And also the statute 11 and 12 William III c. 7, though principally intended against pirates, has a clause that extends to prevent the leaving of such persons abroad as are thus kidnapped or spirited away, by enacting that if any captain of a merchant vessel shall, during his being abroad, force any person on shore, or wilfully leave him behind, or refuse to bring home all such men as he carried out, if able and desirous to return, he shall suffer 3 months' imprisonment. And thus much for offenses that more immediately affect the persons of individuals. End of chapter the 15th, part 2. Chapter 16 of the Commentaries on the Laws of England, Book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 16th of Offenses against the Habitations of Individuals. The only two offenses that more immediately affect the habitations of individuals or private subjects are those of arson and burglary. 1. Arson, ab ardendo, is the malicious and wilful burning of the house or outhouses of another man. This is an offense of very great malignity, and much more pernicious to the public than simple theft, because, first, it is an offense against that right of habitation which is acquired by the law of nature as well as by the laws of society. Next, because of the terror and confusion that necessarily attends it. And, lastly, because in simple theft the thing stolen only changes its master, but still remains in esse for the benefit of the public, whereas by burning the very substance is absolutely destroyed. It is also frequently more destructive than murder itself, of which too it is often the cause, since murder, atrocious as it is, seldom extends beyond the felonious act designed, whereas fire too frequently involves in the common calamity persons unknown to the incendiary, and not intended to be hurt by him, and friends as well as enemies. For which reason the civil law punishes with death such as maliciously set fire to houses in towns and contiguous to others, but is more merciful to such as only fire a cottage or house standing by itself. Our English law also distinguishes with much accuracy upon this crime, and therefore we will inquire first what is such a house as may be the subject of this offense, next wherein the offense itself consists or what amounts to a burning of such house, and lastly how the offense is punished. 1. Not only the bare dwelling house, but all outhouses that are parcel thereof, though not contiguous thereto, nor under the same roof, as barns and stables, may be the subject of arson. And this by the common law, which also accounted it felony to burn a single barn in the field, if filled with hay or corn, though not parcel of the dwelling house. The burning of a stack of corn was anciently likewise accounted arson. And indeed, all the niceties and distinctions which we meet within our books concerning what shall or shall not amount to arson seem now to be taken away by a variety of statutes, which will be mentioned in the next chapter, and have made the punishment of wilful burning equally extensive as the mischief. The offense of arson, strictly so called, may be committed by wilfully setting fire to one's own house, provided one's neighbor's house is thereby also burnt. But if no mischief is done but to one's own, it does not amount to felony, though the fire was kindled with the intent to burn another's. For by the common law no intention to commit a felony amounts to the same crime, though it does in some cases by particular statutes. However, such wilful firing one's own house in a town is a high misdemeanor, and punishable by fine, imprisonment, pillory, and perpetual sureties for the good behavior. And if a landlord or reversioner sets fire to his own house, of which another is in possession under lease from himself or from those whose estate he hath, it shall be accounted arson, for during the lease the house is the property of the tenant. 2. As to what shall be said of burning so as to amount to arson, a bare intent or attempt to do it by actually setting fire to an house, unless it absolutely burns, does not fall within the description of incendit et combustit, which were words necessary in the days of law Latin to all indictments of this sort. But the burning and consuming of any part is sufficient, though the fire be afterwards extinguished. Also, it must be a malicious burning. Otherwise, it is only a trespass, and therefore no negligence or mischance amounts to it. For which reason, though an unqualified person, by shooting with a gun, happens to set fire to the thatch of a house, this Sir Matthew Hale determines not to be felony, contrary to the opinion of former writers. But by Statute 6 and C 31, any servant negligently setting fire to a house or outhouses shall forfeit £100, or be sent to the House of Correction for 18 months. In the same manner as the Roman law directed, eos, qui negligentur ignis apud se abuerent, fustibus vel flagellis caedi. 3. The punishment of arson was death by our ancient Saxon laws, and in the reign of Edward I this sentence was executed by a kind of lex talionis, for the incendiaries were burnt to death, as they were also by the Gothic constitutions. The Statute 8 Henry VI c. 6 made the wilful burning of houses, under some special circumstances therein mentioned, amount to the crime of high treason. But it was again reduced to felony by the general acts of Edward VI and Queen Mary, and now the punishment of all capital felonies is uniform, namely by suspension. The offense of arson was denied the benefit of clergy by Statute 21 Henry VIII c. 1, but that statute was repealed by 1 Edward VI c. 12. And arson was afterwards held to be ousted of clergy with respect to the principal offender only by inference and deduction from the statute 4 and 5 Philip and Mary c. 4, which expressly denied it to the accessory, though now it is expressly denied to the principal also by statute 9 George I c. 22. 2. Burglary or nocturnal housebreaking, burgi latrocinium, which by our ancient law was called hamsecond, as it is in Scotland to this day, has always been looked upon as a very heinous offence, not only because of the abundant terror that it naturally carries with it, but also as it is a forcible invasion and disturbance of that right of habitation which every individual might acquire even in a state of nature, an invasion which in such a state would be sure to be punished with death unless the assailant were the stronger. But in civil society the laws also come in to the assistance of the weaker party, and besides that they leave him this natural right of killing the aggressor if he can, as was shown in a former chapter, they also protect and avenge him in case the might of the assailant be too powerful. And the law of England has so particular and tender a regard to the immunity of a man's house that it styles it his castle, and will never suffer it to be violated with impunity, agreeing herein with the sentiments of ancient Rome as expressed in the words of Tully: Qui denim sanctius, quid omne religione munitius, quam domos unius cujusque civium. For this reason, no doors can in general be broken open to execute any civil process, though in criminal cases the public safety supersedes the private. Hence also in part arises the animadversion of the law upon eavesdroppers, nuisancers, and incendiaries. And to this principle it must be assigned that a man may assemble people together lawfully, at least if they do not exceed 11, without danger of raising a riot, rout, or unlawful assembly in order to protect and defend his house, which he is not permitted to do in any other case. The definition of a burglar, as given us by Sir Edward Coke, is "He that by night breaketh and entereth into a mansion house with intent to commit a felony." In this definition there are four things to be considered: the time, the place, the manner, and the intent. 1. The time must be by night and not by day, for in the daytime there is no burglary. We have seen, in the case of justifiable homicide, how much more heinous all laws made an attack by night rather than by day, allowing the party attacked by night to kill the assailant with impunity. As to what is reckoned night and what day for this purpose, anciently the day was accounted to begin only at sunrising and to end immediately upon sunset. But the better opinion seems to be that if there be daylight or crepusculum enough begun or left to discern a man's face withal, it is no burglary. But this does not extend to moonlight, for then many midnight burglaries would go unpunished. And besides, the malignity of the offense does not so properly arise from its being done in the dark as at the dead of night, when all the creation except beasts of prey are at rest, when sleep has disarmed the owner and rendered his castle defenseless. 2. As to the place, it must be, according to Sir Edward Coke's definition, in a mansion house, and therefore to account for the reason why breaking open a church is burglary, as it undoubtedly is, he quaintly observes that it is domus mansionalis Dei. But it does not seem absolutely necessary that it should in all cases be a mansion house, for it may also be committed by breaking the gates or walls of a town in the night, though that perhaps Sir Edward Coke would have called the mansion house of the garrison or corporation. Spellman defines burglary to be nocturna disruptio alle cujus habitaculi, vel ecclesiae, etiam mororum portarumve burgi, ad felonium perpetrandum. And therefore we may safely conclude that the requisite of its being a dominus mansionalis is only in the burglary of a private house, which is the most frequent, and in which it is indispensably necessary to form its guilt that it must be in a mansion or dwelling house. For no distant barn, warehouse, or the like are under the same privileges, nor looked upon as a man's castle of defense, nor is a breaking open of houses wherein no man resides, and which therefore for the time being are not mansion houses, attended with the same circumstances of midnight terror. A house, however, wherein a man sometimes resides, and which the owner hath only left for a short reason, amino refertendi, is the object of burglary, though no one be in it at the time of the fact committed. And if the barn, stable, or warehouse be parcel of the mansion house, though not under the same roof or contiguous, a burglary may be committed therein. For the capital house protects and privileges all its branches and appurtenance, if within the curtilage or homestall. A chamber in a college or an inn of court, where each inhabitant hath a distinct property, is, to all other purposes as well as this, the mansion house of the owner. So also is a room or lodging in any private house the mansion for the time being of the lodger. The house of a corporation, inhabited in separate apartments by officers of the body corporate, is the mansion house of the corporation, and not of the respective officers. But if I hire a shop, parcel of another man's house, and work or trade in it, but never lie there, it is no dwelling house, nor can burglary be committed therein, for by the lease it is severed from the rest of the house, and therefore is not the dwelling house of him who occupies the other part. Neither can I be said to dwell therein when I never lie there. Neither can burglary be committed in a tent or a booth erected at a market or fair, though the owner may lodge therein. For the law regards thus highly nothing but permanent edifices, a house or a church, the wall or gate of a town, and it is the folly of the owner to lodge in so fragile a tenement. But his lodging there no more makes it a burglary to break it open than it would be to uncover a tilted wagon in the same circumstances. 3. As to the manner of committing burglary, there must be both a breaking and an entry to complete it. But they need not be both done at once, for if a hole be broken one night, and the same breakers enter the next night through the same, they are burglars. There must be an actual breaking, not a mere legal clausum fregit, by leaping over invisible ideal boundaries which may constitute a civil trespass, but a substantial and forcible irruption, as at least by breaking or taking out the glass of, or otherwise opening a window, picking a lock or opening it with a key, nay, by lifting up the latch of a door or unloosing any other fastening which the owner has provided. But if a person leaves his doors or windows open, it is his own folly and negligence, and if a man enters therein, it is no burglary. Yet if he afterwards unlocks an inner or chamber door, it is so. But to come down a chimney is held a burglarious entry, for that is as much closed as the nature of things will permit. So also to knock at a door, and upon opening it to rush in with a felonious intent, or, under pretense of taking lodgings, to fall upon the landlord and rob him, or to procure a constable to gain admittance in order to search for traitors, and then to bind the constable and rob the house. All these entries have been adjudged burglarious, though there was no actual breaking, for the law will not suffer itself to be trifled with by such evasions, especially under the cloak of legal process. And so if a servant opens and enters his master's chamber door with a felonious design, or if any other person lodging in the same house or in a public inn opens and enters another's door with such evil intent, it is burglary. Nay, if the servant conspires with a robber and lets him into the house by night, this is burglary in both, for the servant is doing an unlawful act, and the opportunity afforded him of doing it with greater ease rather aggravates than extenuates the guilt. As for the entry, any the least degree of it, with any part of the body or with an instrument held in the hand, is sufficient. as to step over the threshold, to put a hand or a hook in at a window to draw out goods, or a pistol to demand one's money, are all of them burglarious entries. The entry may be before the breaking as well as after. For by statute 12 and C7, if a person enters into or is within the dwelling house of another without breaking in, either by day or by night, with intent to commit felony, and shall in the night break out of the same, this is declared to be burglary, there having before been different opinions concerning it, Lord Bacon holding the affirmative, and Sir Matthew Hale the negative. But it is universally agreed that there must be both a breaking, either in fact or by implication, and also an entry in order to complete the burglary. 4. As to the intent, it is clear that such breaking and entry must be with a felonious intent, otherwise it is only a trespass. And it is the same whether such intention be actually carried into execution or only demonstrated by some attempt or overt act of which the jury is to judge. And therefore such a breach and entry of a house as has been before described by night with intent to commit a robbery, a murder, a rape, or any other felony is burglary, whether the thing be actually perpetrated or not. Nor does it make any difference whether the offense were felony at common law or only created so by statute, since that statute which makes an offense felony gives it incidentally all the properties of a felony at common law. Thus much for the nature of burglary, which is, as has been said, a felony at common law, but within the benefit of clergy. The statute, however, of 18 Elizabeth C7 takes away clergy from the principals, and that of 3 and 4 William and Mary C9 from all accessories before the fact. And, in like manner, the laws of Athens, which punished no simple theft with death, made burglary a capital crime. End of chapter the 16th. Chapter 17, Part 1 of the Commentaries on the Laws of England, Book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 17th of Offenses Against Private Property, Part 1. The next and last species of offenses against private subjects are such as more immediately affect their property, of which there are two which are attended with a breach of the peace, larceny and malicious mischief, and one that is equally injurious to the rights of property, but attended with no act of violence, which is the crime of forgery. Of these three in their order. 1. Larceny, or theft by contraction for latrociny, latrocinium, is distinguished by law into two sorts, the one called simple larceny, or plain theft unaccompanied with any other atrocious circumstance, and mixed or compound larceny, which also includes in it the aggravation of a taking from one's house or person. And first of simple larceny, which, when it is the stealing of goods above the value of 12 pence, is called grand larceny, when of goods to that value are under, is petite larceny, offenses which are considerably distinguished in their punishment, but not otherwise. I shall therefore first consider the nature of simple larceny in general, and then shall observe the different degrees of punishment inflicted on its two several branches. Simple larceny, then, is the felonious taking and carrying away of the personal goods of another. This offense certainly commenced then, whenever it was that the bounds of property, or laws of meum and tuum, were established. How far such an offense can exist in a state of nature where all things are held to be common is a question that may be solved with very little difficulty. The disturbance of any individual in the occupation of what he has seized to his present use seems to be the only offense of this kind incident to such a state. But unquestionably, in social communities, when property is established, the necessity whereof we have formerly seen, any violation of that property is subject to be punished by the laws of society, though how far that punishment should extend is a matter of considerable doubt. At present, we will examine the nature of theft or larceny as laid down in the foregoing definition. 1. It must be a taking. This implies the consent of the owner to be wanting. Therefore, no delivery of the goods from the owner to the offender upon trust can ground a larceny, as if A lends B a horse and he rides away with him, or if I send goods by a carrier and he carries them away, these are no larcenies. But if the carrier opens a bale or pack of goods, or pierces a vessel of wine, and takes away part thereof, or if he carries it to the place appointed, and afterwards takes away the whole, these are larcenies. For here the animus furandi is manifest, since in the first case he had otherwise no inducement to open the goods, and in the second the trust was determined, the delivery having taken its effect. But bare non-delivery shall not of course be intended to arise from a felonious design, since that may happen from a variety of other accidents. Neither by the common law was it larceny in any servant to run away with the goods committed to him to keep, but only a breach of civil trust. But by statute 33 Henry VI c.1, the servants of persons deceased, accused of embezzling their master's goods, may by writ out of chancery, issued by the advice of the chief justices and chief baron, or any two of them, and proclamation made thereupon, be summoned to appear personally in the Court of King's Bench to answer their master's executors in any civil suit for such goods, and shall, on default of appearance, be attainted of felony. And by statute 21 Henry VIII c.7, if any servant embezzles his master's goods to the value of 40 shillings, it is made felony, except in apprentices and servants under 18 years old. But if he had not the possession, but only the care and oversight of the goods, as the butler of plate, the shepherd of sheep, and the like, the embezzling of them is felony at common law. So if a guest robs his inn or tavern of a piece of plate, it is larceny, for he hath not the possession delivered to him, but merely the use. And so it is declared to be by statute 3 and 4 William and Mary c.9, if a lodger runs away with the goods from his ready furnished lodgings. Under some circumstances, a man may be guilty of felony in taking his own goods, as if he steals them from a pawnbroker or any one to whom he hath delivered and entrusted them, with intent to charge such bailee with the value, or if he robs his own messenger on the road, with the intent to charge the 100 with the loss, according to the statute of Winchester. 2. There must not only be a taking, but a carrying away. Cepit et asportavit was the old Latin. A bare removal from the place in which he found the goods, though the thief does not quite make off with them, is a sufficient asportation or carrying away. As if a man be leading another's horse out of a close and be apprehended in the fact, or if a guest, stealing goods out of an inn, has removed them from his chamber downstairs, these have been adjudged sufficient carryings away to constitute a larceny. Or if a thief, intending to steal plate, takes it out of the chest in which it was, and lays it down upon the floor, but is surprised before he can make his escape with it, this is larceny. 3. This taking and carrying away must also be felonious, that is, done animo furandi, or, as the civil law expresses it, lucri causa. This requisite, besides excusing those who labor under incapacities of mind or will, of whom we spoke sufficiently at the entrance of this book, indemnifies also mere trespassers or other petty offenders. As if a servant takes his master's horse without his knowledge and brings him home again. If a neighbor takes another's plow that is left in the field and uses it upon his own land and then returns it. If, under color of arrear of rent, where none is due, I distrain another's cattle or seize them, all these are misdemeanors and trespasses, but no felonies. The ordinary discovery of a felonious intent is where the party doth it clandestinely, or, being charged with the fact, denies it. But this is by no means the only criterion of criminality, for in cases that may amount to larceny, the variety of circumstances is so great, and the complications thereof so mingled, that it is impossible to recount all those which may evidence a felonious intent or animum furandi, wherefore they must be left to the due and attentive consideration of the court and jury. 4. This felonious taking and carrying away must be of the personal goods of another, for if they are things real or favor of the realty, larceny at the common law cannot be committed of them. Lands, tenements, and hereditaments, either corporeal or incorporeal, cannot in their nature be taken and carried away. And of things likewise that adhere to the freehold, as corn, grass, trees, and the like, or lead upon a house, no larceny could be committed by the rules of the common law. But the severance of them was, and in many things is still, merely a trespass, which depend on a subtlety in the legal notions of our ancestors. These things were parcel of the real estate, and therefore, while they continued so, could not by any possibility be the subject of theft, being absolutely fixed and immovable. And if they were severed by violence so as to be changed into movables, and at the same time, by one and the same continued act, carried off by the person who severed them, they could never be said to be taken from the proprietor in this their newly acquired state of mobility, which is essential to the nature of larceny, being never as such in the actual or constructive possession of any one but of him who committed the trespass. He could not in strictness be said to have taken what at the time were the personal goods of another, since the very act of taking was what turned them into personal goods. But if the thief severs them at one time whereby the trespass is completed, and they are converted into personal chattels in the constructive possession of him on whose soil they are left or laid, and comes again at another time when they are so turned into personality and takes them away, it is larceny. And so it is if the owner or any one else has severed them. And now by statute 4 George II c. 32, to steal or sever with intent to steal any lead or iron fixed to a house or in any court or garden thereunto belonging is made felony, liable to transportation for 7 years. And to steal, damage, or destroy underwood or hedges and the like, to rob orchards or gardens of fruit growing therein, to steal or otherwise destroy any turnips or the roots of matter when growing, are punishable criminally by whipping, small fines, imprisonment, and satisfaction to the party wronged, according to the nature of the offense. Moreover, the stealing by night of any trees or of any roots, shrubs, or plants to the value of 5 shillings is by statute 6 George III c. 36 made felony in the principals, aiders, and abettors, and in the purchasers thereof knowing the same to be stolen. And by statute 6 George III c. 48, the stealing of any timber trees therein specified, and of any root, shrub, or plant by day or night, is liable to pecuniary penalties for the 2 first offenses, and for the third is constituted a felony liable to transportation for 7 years. Stealing ore out of mines is also no larceny upon the same principle of adherence to the freehold. With an exception only to mines of black lead, the stealing ore out of which is felony without benefit of clergy by statute 25 George II c. 10. Upon nearly the same principle, the stealing of writings relating to a real estate is no felony but a trespass, because they concern the land, or, according to our technical language, favor of the realty, and are considered as part of it by law, so that they descend to the heir together with the land which they concern. Bonds, bills, and notes which concern mere choses in action were also at the common law held not to be goods whereof larceny might be committed. being of no intrinsic value, and not importing any property in the possession of to the person from whom they are taken. But by the statute 2 George II, c. 25, they are now put on the same footing with respect to larcenies as the money they were meant to secure. And by statute 7 George III, c. 50, if any officer or servant of the post office shall secrete, embezzle, or destroy any letter or packet containing any banknote or other valuable paper particularly specified in the act, or shall steal the same out of any letter or packet, he shall be guilty of felony without benefit of clergy. Or if he shall destroy any letter or packet with which he has received money for the postage, or shall advance the rate of postage on any letter or packet sent by the post, and shall secrete the money received for such advancement, he shall be guilty of single felony. Larceny also could not at common law be committed of treasure trove or wreck till seized by the king or him who hath the franchise, for till such seizure no one hath a determinate property therein. But by statute 26 George II, c. 19, plundering or stealing from any ship in distress, whether wreck or no wreck, is felony without benefit of clergy. In like manner as, by the civil law, this inhumanity is punished in the same degree as the most atrocious theft. Larceny also cannot be committed of such animals in which there is no property either absolute or qualified, as of beasts that are ferae naturae and unreclaimed, such as deer, hares, and conies in a forest, chase, or warren, fish in an open river or pond, or wild fowls at their natural liberty. But if they are reclaimed or confined and may serve for food, it is otherwise, even at common law. For if deer so enclosed in a park that they may be taken at pleasure, fish in a trunk, and pheasants or partridges in a mew, larceny may be committed. And now by statute 9 George I, c. 22, to kill or steal any deer in a forest or other place enclosed, to rob a warren, or to steal fish from a river or pond, being in this last case armed and disguised, these are felonies without benefit of clergy. And by statute 13 Charles II, c. 10, to steal deer in any forest, though unenclosed, is forfeiture of £20 for the first offence, and by statute 10 George II, c. 32, 7 years transportation for the second offence, which punishment is also inflicted for the first offence upon such as come to hunt there armed with offensive weapons. Also, by statute 5 George III, c. 14, the penalty of transportation for 7 years is inflicted on persons stealing or taking fish in any water within a park, paddock, garden, orchard, or yard, and on the receivers, aiders, and abettors, and the like punishment, or whipping, fine, or imprisonment, is provided for the taking or killing of conies in open warrens. And a forfeiture of £5 to the owner of the fishery is made payable by persons taking or destroying, or attempting so to do, any fish in any river or other water within an enclosed ground, being private property. Stealing hawks in disobedience to the rules prescribed by the statute 37 Edward III, c. 19, is also felony. It is also laid that if swans be lawfully marked, it is felony to steal them, though at large in a public river, and that it is likewise felony to steal them, though unmarked, in any private river or pond, otherwise it is only a trespass. But of all valuable domestic animals, as horses and all animals domitae naturae, which serve for food, as swine, sheep, poultry, and the like, larceny may be committed, and also the flesh of such as are ferae naturae when killed. As to those animals which do not serve for food, and which therefore the law holds to have no intrinsic value, as dogs of all sorts, and other creatures kept for whim and pleasure, though a man may have a base property therein, and maintain a civil action for the loss of them, yet they are not of such estimation as that the crime of stealing them amounts to larceny. Notwithstanding, however, that no larceny can be committed unless there be some property in the thing taken and an owner, yet if the owner be unknown, provided there be a property, it is larceny to steal it, and an indictment will lie for the goods of a person unknown. In like manner as, among the Romans, the lex hostilia de furtis provided that a prosecution for theft might be carried on without the intervention of the owner. This is the case of stealing a shroud out of a grave, which is the property of those, whoever they were, that buried the deceased, but stealing the corpse itself, which has no owner, though a matter of great indecency, is no felony unless some of the grave cloths be stolen with it. Very different from the law of the Franks, which seems to have respected both as equal offences, when it directed that a person who had dug a corpse out of the ground in order to strip it should be banished from society, and no one suffered to relieve his wants till the relations of the deceased consented to his readmission. End of chapter the 17th, part 1. Chapter 17, Part 2 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 17th of Offenses Against Private Property, Part 2. Having thus considered the general nature of simple larceny, I come next to treat of its punishment. Theft, by the Jewish law, was only punished with a pecuniary fine and satisfaction to the party injured. And in the civil law, till some very late constitutions, we never find the punishment capital. The laws of Draco at Athens punished it with death, but his laws were said to be written in blood, and Solon afterwards changed the penalty to a pecuniary mulct. And so the Attic laws in general continued, except that once, in a time of dearth, it was made capital to break into a garden and steal figs. But this law and the informers against the offense grew so odious that from them all malicious informers were styled sycophants, a name which we have much perverted from its original meaning. From these examples, as well as the reason of the thing, many learned and scrupulous men have questioned the propriety, if not the lawfulness, of inflicting capital punishment for simple theft. And certainly the natural punishment for injuries to property seemed to be the loss of the offender's own property, which ought to be universally the case were all men's fortunes equal. But as those who have no property themselves are generally the most ready to attack the property of others, it has been found necessary, instead of a pecuniary, to substitute a corporal punishment. Yet how far this corporal punishment ought to extend is what occasioned the doubt. Sir Thomas More and the Marquis Beccaria, at the distance of more than 2 centuries, have very sensibly proposed that kind of corporal punishment which approaches the nearest to a pecuniary satisfaction, viz., a temporary imprisonment with an obligation to labor, first for the party robbed, and afterwards for the public, in works of the most slavish kind, in order to oblige the offender to repair, by his industry and diligence, the depredations he has committed upon private property and public order. But notwithstanding all remonstrances of speculative politicians and moralists, the punishment of theft still continues throughout the greatest part of Europe to be capital, and Pufendorf, together with Sir Matthew Hale, are of the opinion that this must always be referred to the prudence of the legislature, who are to judge, say they, when crimes are become so enormous as to require such sanguinary restrictions. Yet both these writers agree that such punishments should be cautiously inflicted, and never without the utmost necessity. Our ancient Saxon laws nominally punished theft with death if above the value of 12 pence, but the criminal was permitted to redeem his life by a pecuniary ransom, as among their ancestors the Germans by a stated number of cattle. But in the 9th year of Henry I, this power of redemption was taken away, and all persons guilty of larceny above the value of 12 pence were directed to be hanged, which law continues in force to this day. For though the inferior species of theft or petit larceny is only punished by whipping at common law, or by statute 4 George I. c. 11 may perhaps be extended to transportation for 7 years, yet the punishment of grand larceny, or the stealing above the value of 12 pence, which sum was the standard in the time of King Athelstan 800 years ago, is at common law regularly death, which, considering the great intermediate alteration in the price or denomination of money, is undoubtedly a very rigorous constitution, and made Sir Henry Spelman, above a century since, when money was at twice its present rate, complain that while everything else was risen in its nominal value and become dearer, the life of man had continually grown cheaper. It is true that the mercy of juries will often make them strain a point and bring in larceny to be under the value of 12 pence, when it is really of much greater value. But this is a kind of pious perjury, and does not at all excuse our common law in this respect from the imputation of severity, but rather strongly confesses the charge. It is likewise true that by the merciful extensions of the benefit of clergy by our modern statute law, a person who commits simple larceny to the value of 13 pence or £1,300, though guilty of a capital offence, shall be excused the pains of death, but this is only for the first offence, and in many cases of simple larceny the benefit of clergy is taken away by statute, as from horse stealing, taking woolen cloth from off the tenters, or linen from the place of manufacture, stealing sheep or other cattle specified in the acts, thefts on navigable rivers above the value of 40 shillings, plundering vessels in distress or that have suffered shipwreck, stealing letters sent by the post, and also stealing deer, hares, and conies under the peculiar circumstances mentioned in the Waltham Black Act, which additional severity is owing to the great malice and mischief of the theft in some of these instances, and in others to the difficulties men would otherwise lie under to preserve those goods which are so easily carried off. Upon which last principle the Roman law punished more severely than other thieves the abigae, or stealers of cattle, and the balneari, or such as stole the cloths of persons who were washing in the public baths, both which constitutions seem to be borrowed from the laws of Athens, and so too the ancient Goths punished with unrelenting severity thefts of cattle or of corn that was reaped and left in the field, such kind of property which no human industry can sufficiently guard, being esteemed under the peculiar custody of heaven. And thus much for the offence of simple larceny. Mixed or compound larceny is such as has all the properties of the former, but is accompanied with one of or both the aggravations of taking from one's house or person. First, therefore, of larceny from the house, and then of larceny from the person. 1. Larceny from the house, though it seems, from the considerations mentioned in the preceding chapter, to have a higher degree of guilt than simple larceny, yet is not at all distinguished from the other at common law, unless where it is accompanied with the circumstance of breaking the house by night, and then we have seen that it falls under another description, viz., that of burglary. But now by several acts of Parliament, the history of which is very ingeniously deduced by a learned modern writer, who hath shown them to have gradually arisen from our improvements in trade and opulence, the benefit of clergy is taken from larcenies committed in an house in almost every instance, the multiplicity of which acts is apt to create some confusion, but upon comparing them diligently, we may collect that the benefit of clergy is denied upon the following domestic aggravations of larceny, viz., first of all, in larcenies above the value of 12 pence committed, 1. In a church or chapel with or without violence or breaking the same. 2. In a booth or tent at a market fair, in the daytime or in the night, by violence or breaking the same, the owner or some of his family being therein. 3. In a dwelling house by day, by breaking the same, any person being therein. 4. In a dwelling house by day, without breaking the same, any person being therein and put in fear. 5. In a dwelling house by night, without breaking the same, the owner or some of his family being therein and put in fear. Secondly, in all larcenies to the value of 5 shillings committed, 1. By breaking any dwelling house or any outhouse, shop, or warehouse thereunto belonging, in the daytime, although no person be therein. 2. By privately stealing in any shop, warehouse, coach-house, or stable, by day or by night, though the same be not broken open, and though no person be therein. Lastly, in all larcenies to the value of 40 shillings from a dwelling house or its outhouses without breaking in, and whether any person be therein or no. 2. Larceny from the person is either by privately stealing or by open and violent assault, which is usually called robbery. The offense of privately stealing from a man's person, as by picking his pocket or the like without his knowledge, was debarred the benefit of clergy so early as by the statute 8 Elizabeth c. 14. But then it must be such a larceny as stands in need of the benefit of clergy, viz., above the value of 12 pence, else the offender shall not have judgment of death. For the statute creates no new offense, but only takes away the benefit of clergy, which was a matter of grace, and leaves the thief to the regular judgment of the ancient law. This severity, for a most severe law it certainly is, seems to be owing to the ease with which such offences are committed, and the difficulty of guarding against them. Besides that this is an infringement of property in the manual occupation or corporal possession of the owner, which was an offence even in a state of nature, and therefore the saculari or cut purses were more severely punished than common thieves by the Roman and Athenian laws. Open and violent larceny from the person, or robbery, the rapina of civilians, is the felonious and forcible taking from the person of another of goods or money to any value by putting him in fear. 1. There must be a taking, otherwise it is no robbery. A mere attempt to rob was indeed held to be felony so late as Henry IV's time, but afterwards it was taken to be only a misdemeanor and punishable with fine and imprisonment, till the statute 7 George II c. 21, which makes it a felony transportable for 7 years. If the thief, having once taken a purse, returns it, still it is a robbery. And so it is, whether the taking be strictly from the person of another, or in his presence only, as where a robber by menaces and violence puts a man in fear, and drives away his sheep or his cattle before his face. 2. It is immaterial of what value the thing taken is. A penny as well as a pound thus forcibly extorted makes a robbery. 3. Lastly, the taking must be by force or a previous putting in fear, which makes the violation of the person more atrocious than privately stealing. For according to the maxim of the civil law, qui vi rapuit, ferem probior esse veditor. This previous putting in fear is the criterion that distinguishes robbery from other larcenies. For if one privately steals 6 pence from the person of another, and afterwards keeps it by putting him in fear, this is no robbery, for the fear is subsequent. Neither is it capital, as privately stealing, being under the value of 12 pence. Yet this putting in fear does not imply that any great degree of terror or affright in the party robbed is necessary to constitute a robbery. It is sufficient that so much force or threatening by word or gesture be used as might create an apprehension of danger or oblige a man to part with his property without or against his consent. Thus, if a man be knocked down without previous warning and stripped of his property while senseless, though strictly he cannot be said to be put in fear, yet this is undoubtedly a robbery. Or if a person with a sword drawn begs an alms, and I give it to him through mistrust and apprehension of violence, this is a felonious robbery. So, if under the pretense of sale a man forcibly extorts money from another, neither shall this subterfuge avail him. But it is doubted whether the forcing a higgler or other chapman to sell his wares and giving him the full value of them amounts to so heinous a crime as robbery. This species of larceny is debarred the benefit of clergy by statute 23 Henry VIII c. 1 and other subsequent statutes, not indeed in general, but only when committed in or near the king's highway. A robbery, therefore, in a distant field or footpath was not punished with death, but was open to the benefit of clergy till the statute 3 and 4 William and Mary c. 9, which takes away clergy from robbery wheresoever committed. End of chapter the 17th, part 2. Chapter 17, part 3 of the Commentaries on the Laws of England, book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 17th of Offenses Against Private Property, Part 3. 2. Malicious mischief or damage is the next species of injury to private property which the law considers as a public crime. This is such as is done, not animo furandi, or with intent of gaining by another's loss, which is some, though a weak excuse, but either out of a spirit of wanton cruelty or black and diabolical revenge, in which it bears a near relation to the crime of arson, for as that affects the habitation, so this does the other property of individuals. And therefore any damage arising from this mischievous disposition, though only a trespass at common law, is now by a multitude of statutes made penal in the highest degree. Of these I shall extract the contents in order of time. And first, by statute 22 Henry VIII c. 11, perversely and maliciously to cut down or destroy the powder dyke in the fens of Norfolk and Ely is felony. By statute 43 Elizabeth c. 13, for preventing rapine on the northern borders, to burn any bark or stack of corn or grain, or to prey or make spoil of the persons or goods of the subject upon deadly feud in the 4 northern counties of Northumberland, Westmoreland, Cumberland, and Durham, or to give or take any money or contribution there called blackmail to secure such goods from rapine, is felony without benefit of clergy. By statute 22 and 23 Charles II c. 7, to burn any ricks or stacks of corn, hay, or grain, barns, houses, buildings, or kilns, or maliciously, unlawfully, and willingly to kill any horses, sheep, or other cattle in the night time is felony. But the offender may make his election to be transported for 7 years, and to maim or hurt such cattle is a trespass for which treble damages shall be recovered. By statute 1 and St. 2 c. 9, captains and mariners belonging to ships and destroying the same to the prejudice of the owners, and by 4 George I c. 12 to the prejudice of insurers also, are guilty of felony without benefit of clergy. And by statute 12 and c. 18, making any hole in a ship in distress, or stealing her pumps, or wilfully doing anything tending to the immediate loss of such ship, is felony without benefit of clergy. By statute 1 George I c. 48, maliciously to set on fire any underwood, wood, or coppice is made single felony. By statute 6 George I c. 23, the willful and malicious tearing, cutting, spoiling, burning, or defacing of the garments or clothes of any person passing in the streets or highways is felony. This was occasioned by the insolence of certain weavers and others who, upon the introduction of some Indian fashions prejudicial to their own manufactures, made it their practice to cast aquafortis in the streets upon such as wore them. By Statute 9 George I, c. 22, commonly called the Waltham Black Act, occasioned by devastations committed near Waltham in Hampshire by persons in disguise or with their faces blacked, who seem to have resembled the Robertsmen or followers of Robert Hood, that in the reign of Richard I committed great outrages on the borders of England and Scotland. By this Black Act, I say, which has in part been mentioned under the several heads of riots, mayhem, and larceny, it is farther enacted that unlawfully, riotously, tumultuously, and forcibly to demolish or pull down, or begin to demolish or pull down, any church, chapel, or meeting house, or any dwelling house, barn, stable, or outhouse, or unlawfully and maliciously to set fire to any house, barn, or outhouse, which in both cases is extended by Statute 9 George III, c. 29, to all kinds of mills, or to any hovel, cock, mow, or stack of corn, straw, hay, or wood, or to break down the head of any fish pond whereby the fish shall be lost, or to kill, maim, or wound any cattle, or to cut down or destroy any trees planted in an avenue, or growing in a garden, orchard, or plantation, for ornament, shelter, or profit. All these malicious acts are felonies without benefit of clergy, and the 100 shall be chargeable for the damages unless the offender be convicted. In like manner, by the Roman law, to cut down trees, and especially vines, was punished in the same degree as robbery. By Statute 6 George II, c. 37, and 10 George II, c. 32, it is also made felony without the benefit of clergy, maliciously to cut down any river or sea bank whereby lands may be overflowed, or to cut any hop vines growing in a plantation of hops, or wilfully and maliciously to set fire to any mine or delf of coal. By Statute 28 George II, c. 19, to set fire to any grouse, furze, or fern growing in any forest or chase is subject to a fine of £5. By Statute 6 George III, c. 36 and 48, willfully to spoil or destroy any timber or other trees, roots, shrubs, or plants, is for the first two offenses liable to pecuniary penalties, and for the third, if in the daytime, and even for the first if at night, the offender shall be guilty of felony and be liable to transportation for 7 years. And by Statute 9 George III, c. 29, willfully and maliciously to burn or destroy any engine or other machines therein specified belonging to any mine, or any fences for enclosures pursuant to any act of Parliament, is made single felony and punishable with transportation for 7 years in the offender, his advisers, and procurers. And these are the punishments of malicious mischief. 3. Forgery, or the crimen falsi, is an offense which was punished by the civil law with deportation or banishment, and sometimes with death. It may with us be defined, at common law, to be the fraudulent making or alteration of a writing to the prejudice of another man's right, for which the offender may suffer fine, imprisonment, and pillory, and also by a variety of statutes, a more severe punishment is inflicted on the offender in many particular cases which are so multiplied of late as almost to become general. I shall mention the principal instances. By Statute 5 Elizabeth, c. 14, to forge or make, or knowingly to publish or give in evidence any forged deed, court roll, or will, with intent to effect the right of real property, either freehold or copyhold, is punished by a forfeiture to the party grieved of double costs and damages, by standing in the pillory and having both his ears cut off and nostrils slit and seared. by forfeiture to the crown of the profits of his lands, and by perpetual imprisonment. For any forgery relating to a term of years, or annuity, bond, obligation, acquittance, release, or discharge of any debt or demand of any personal chattels, the same forfeiture is given to the party grieved, and on the offender is inflicted the pillory, loss of one of his ears, and half a year's imprisonment, the second offense in both cases being felony without benefit of clergy. Besides this general act, a multitude of others since the Revolution, when paper credit was first established, have inflicted capital punishment on the forging or altering of bank bills or notes or other securities, of bills of credit issued from the exchequer, of South Sea bonds, etc., of lottery orders, of army or navy debentures, of East India bonds, of writing under the seal of London or Royal Exchange assurance, of a letter of attorney or other power to receive or transfer stock or annuities, and on the impersonating a proprietor thereof to receive or transfer such annuities, stock, or dividends. Also, on the uttering or publishing as true any counterfeited seaman's will or powers, to which may be added, though not strictly reducible to this head, the counterfeiting of Mediterranean passes under the hands of the lords of the Admiralty, to protect one from the piratical states of Barbary, the forging or imitating any stamps to defraud the stamp office, and the forging of any marriage register or license, all which are by distinct acts of Parliament made felonies without benefit of clergy, and by Statute 31 George II c. 32, forging or counterfeiting any stamp or mark to denote the standard of gold and silver plate, and certain other offences of like tendency are made felony, but not without benefit of clergy. There are also two other general laws with regard to forgery. The one, 2 George II c. 35, whereby the first offense in forging or publishing any forged deed, will, writing obligatory, bill of exchange, promissory note, endorsement or assignment thereof, or any acquittance or receipt for money or goods, with intention to defraud any person, is made felony without benefit of clergy. And by Statute 7 George II c. 22, it is equally penal to forge or utter a counterfeit acceptance of a bill of exchange, or the number of any accountable receipt for any note, bill, or any other security for money, or any warrant or order for the payment of money or delivery of goods. So that, I believe, through the number of these general and special provisions, there is now hardly a case possible to be conceived wherein forgery that tends to defraud, whether in the name of a real or fictitious person, is not made a capital crime. These are the principal infringements of the rights of property, which were the last species of offenses against individuals or private subjects, which the method of our distribution has led us to consider. We have before examined the nature of all offenses against the public or commonwealth, against the king or supreme magistrate, the father and protector of that community, against the universal law of all civilized nations, together with some of the more atrocious offenses of publicly pernicious consequence against God and his holy religion. And these several heads comprehend the whole circle of crimes and misdemeanors, with the punishments annexed to each that are cognizable by the laws of England. End of chapter the 17th, part 3. Chapter 18 of the Commentaries on the Laws of England, Book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 18th of the Means of Preventing Offenses. We are now arrived at the fifth general branch or head under which I propose to consider the subject of this book of our commentaries, viz., the means of preventing the commission of crimes and misdemeanors. and it really is an honor, and almost a singular one, to our English laws that they furnish a title of this sort, since preventative justice is upon every principle of reason, of humanity, and of sound policy preferable in all respects to punishing justice, the execution of which, though necessary, and in its consequence a species of mercy to the commonwealth, is always attended with many harsh and disagreeable circumstances. This preventative justice consists in obliging those persons whom there is a probable ground to suspect of future misbehavior to stipulate with and give full assurance to the public that such offense as is apprehended shall not happen, by finding pledges or securities for keeping the peace or for their good behavior. This requisition of sureties has been several times mentioned before as part of the penalty inflicted upon such as have been guilty of certain gross misdemeanors, but there also it must be understood rather as a caution against the repetition of the offense than any immediate pain or punishment. And indeed, if we consider all human punishments in a large and extended view, we shall find them all rather calculated to prevent future crimes than to expiate the past, since, as was observed in a former chapter, all punishments inflicted by temporal laws may be classed under three heads, such as tend to the amendment of the offender himself, or to deprive him of any power to do future mischief, or to deter others by his example, all of which conduce to one and the same end of preventing future crimes, whether that be effected by amendment, disability, or example. But the caution which we speak of at present is such as is intended merely for prevention without any crime actually committed by the party, but arising only from probable suspicion that some crime is intended or likely to happen, and consequently it is not meant as any degree of punishment, unless perhaps for a man's imprudence in giving just ground of apprehension. By the Saxon constitution these sureties were always at hand by means of King Alfred's wise institution of decinaries or frank pledges, wherein, as has more than once been observed, the whole neighborhood or tithing of freemen were mutually pledges for each other's good behavior. But this great and general security being now fallen into disuse and neglected, there hath succeeded to it the method of making suspected persons find particular and special securities for their future conduct, of which we find mention in the laws of King Edward the Confessor, Tradat fide usores de pace et legalitate tuenda. Let us therefore consider, first, what the security is, next, who may take or demand it, and lastly, how it may be discharged. 1. This security consists in being bound with one or more sureties in a recognizance or obligation to the king, entered on record and taken in some court or by some judicial officer, whereby the parties acknowledge themselves to be indebted to the crown in the sum required, for instance, £100, with condition to be void and of none effect, if the party shall appear in court on such a day, and in the meantime shall keep the peace, either generally towards the king and all his liege people, or particularly also with regard to the person who craves the security. Or, if it be for the good behavior, then on condition that he shall demean and behave himself well, or be of good behavior, either generally or specially for the time therein limited, as for 1 or more years, or for life. This recognizance, if taken by a justice of the peace, must be certified to the next sessions in pursuance of the statute 3 Henry VII. C.1, and if the condition of such recognizance be broken by any breach of the peace in the one case, or any misbehavior in the other, the recognizance becomes forfeited or absolute, and being estreated or extracted, taken out from among the other records, and sent up to the exchequer, the party and his sureties, having now become the king's absolute debtors, are sued for the several sums in which they are respectively bound. 2. Any justices of the peace, by virtue of their commission, or those who are ex officio conservators of the peace, as was mentioned in a former volume, may demand such security according to their own discretion, or it may be granted at the request of any subject upon due cause shown, provided such demandant be under the king's protection, for which reason it hath been formerly doubted whether Jews, pagans, or other persons convicted of a praemunere were entitled thereto. Or if the justice is averse to act, it may be granted by a mandatory writ called a supplicavit, issuing out of the court of King's Bench or Chancery, which will compel the justice to act as a ministerial and not as a judicial officer, and he must make a return to such writ, specifying his compliance under his hand and seal. But this writ is seldom used, for when application is made to the superior courts, they usually take the recognizances there under the direction of the statute 21 James I, c. 8. And indeed, a peer or peeress cannot be bound over in any other place than the courts of King's Bench or Chancery, though a justice of the peace has a power to require sureties of any other person, being compos mentis and under the degree of nobility, whether he be a fellow of justice or other magistrate, or whether he be merely a private man. Wives may demand it against their husbands, or husbands, if necessary, against their wives. But femme coverts and infants under age ought to find security by their friends only, and not to be bound themselves, for they are incapable of engaging themselves to answer any debt, which, as we have observed, is the nature of these recognizances or acknowledgments. 3. A recognizance may be discharged either by the demise of the king to whom the recognizance is made, or by the death of the principal party bound thereby if not before forfeited, or by order of the court to which such recognizance is certified by the justices, as the Quarter Sessions, Assizes, or King's Bench, if they see sufficient cause, or if he at whose request it was granted, if granted upon a private account, will release it, or does not make his appearance to pray that it be continued. Thus far, what has been said is applicable to both species of recognizances for the peace and for the good behavior, de pace et legalitate tuenda, as expressed in the laws of King Edward. But as these two species of securities are in some respects different, especially as to the cause of granting or the means of forfeiting them, I shall now consider them separately, and first shall show for what cause such a recognizance with sureties for the peace is grantable, and then how it may be forfeited. 1. Any justice of the peace may, ex officio, bind all those to keep the peace who in his presence make any affray, or threaten to kill or beat another, or contend together with hot and angry words, or go about with unusual weapons or attendants to the terror of the people, and all such as he knows to be common barrators, and such as are brought before him by the constable for a breach of the peace in his presence, and all such persons as having been before bound to the peace have broken it and forfeited their recognizance. Also, wherever any private man hath just cause to fear that another will burn his house or do him a corporal injury by killing, imprisoning, or beating him, or that he will procure others so to do, he may demand surety of the peace against such person, and every justice of the peace is bound to grant it if he who demands it will make oath that he is actually under fear of death or bodily harm, and will show that he has just cause to be so, by reason of the other's menaces, attempts, or having lain in wait for him, and will also farther swear that he does not require such surety out of malice or for mere vexation. This is called swearing the peace against another, and if the party does not find such sureties as the justice in his discretion shall require, he may immediately be committed till he does. 2. Such recognizance for keeping the peace when given may be forfeited by any actual violence, or even an assault or menace to the person of whom demanded it, if a special recognizance, or, if the recognizance be general, by any unlawful action whatsoever that either is or attends to a breach of the peace, or more particularly by any one of the many species of offenses which were mentioned as crimes against the public peace in the 11th chapter of this book, or by any private violence committed against any of his Majesty's subjects. But a bare trespass upon the lands or goods of another, which is a ground for a civil action, unless accompanied with a wilful breach of the peace, is no forfeiture of the recognizance. Neither are mere reproachful words, as calling a man a knave or a liar, any breach of the peace so as to forfeit one's recognizance, being looked upon to be merely the effect of unmeaning heat and passion, unless they amount to a challenge to a fight. The other species of recognizance with sureties is for the good abeyance or good behavior. This includes security for the peace and somewhat more. We will therefore examine it in the same manner as the other. 1. First, then, the justices are empowered by the statute 34 Edward III c. 1 to bind over to the good behavior towards the king and his people all them that be not of good fame, wherever they be found, to the intent that the people be not troubled or endamaged, nor the peace diminished, nor merchants and others passing by the highways of the realm be disturbed nor put in the peril which may happen by such offenders. Under the general words of this expression, that be not of good fame, it is holden that a man be bound to his good behavior for causes of scandal contra bonos mores, as well as contra pacem, as for haunting bawdy houses with women of bad fame, or for keeping such women in his own house, or for words tending to scandalize the government, or in abuse of the officers of justice, especially in the execution of their office. Thus also a justice may bind over all night walkers, eavesdroppers, such as keep suspicious company, or are reported to be pilferers or robbers, such as sleep in the day and wake upon the night, common drunkards, whoremasters, the putative fathers of bastards, cheats, idle vagabonds, and other persons whose misbehavior may reasonably bring them within the general words of the statute as persons not of good fame, an expression, it must be owned, of so great a latitude as leaves much to be determined by the discretion of the magistrate himself. But if he commits a man for want of sureties, he must express the cause thereof with convenient certainty, and take care that such cause be a good one. 2. A recognizance for the good behavior may be forfeited by all the same means as one for the security of the peace may be, and also by some others, as by going armed with unusual attendance to the terror of the people, by speaking words tending to sedition, or by committing any of those acts of misbehavior which the recognizance was intended to prevent, but not by barely giving fresh cause of suspicion of that which perhaps may never actually happen. For though it is just to compel suspected persons to give security to the public against misbehavior that is apprehended, yet it would be hard, upon such suspicion, without the proof of any actual crime, to punish them by a forfeiture of their recognizance. End of chapter the 18th. Chapter 19, Part 1 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 19th of Courts of a Criminal Jurisdiction, Part 1. The sixth and last object of our inquiries will be the method of inflicting those punishments which the law has annexed to particular offenses, and which I have constantly subjoined to the description of the crime itself, in the discussion of which I shall pursue much the same general method that I followed in the preceding book with regard to the redress of civil injuries, by first pointing out the several courts of criminal jurisdiction wherein offenders may be prosecuted to punishment, and by secondly deducing down in their natural order and explaining the several proceedings therein. First, then, in reckoning up the several courts of criminal jurisdiction, I shall, as in the former case, begin with an account of such as are of a public and general jurisdiction throughout the whole realm, and afterwards proceed to such as are only of a private and special jurisdiction, and confined to some particular parts of the kingdom. 1. In our inquiries into the criminal courts of public and general jurisdiction, I must in one respect pursue a different order from that in which I considered the civil tribunals. For there, as the several courts had a gradual subordination to each other, the superior correcting and reforming the errors of the inferior, I thought it best to begin with the lowest, and so ascend gradually to the courts of appeal, or those of the most extensive powers. But as it is contrary to the genius and spirit of the law of England to suffer any man to be tried twice for the same offense in a criminal way, especially if acquitted upon the first trial, therefore these criminal courts may be said to be all independent of each other, at least so far as that the sentence of the lowest of them can never be controlled or reversed by the highest jurisdiction in the kingdom, unless for error in matter of law apparent on the face of the record, though sometimes causes may be removed from one to the other before trial. And therefore, as in these courts of criminal cognizance there is not the same chain and independence as in the others, I shall rank them according to their dignity, and begin with the highest of all, viz. 1. The High Court of Parliament, which is the supreme court in the kingdom, not only for the making, but also for the execution of laws, by the trial of great and enormous offenders, whether lords or commoners, in the method of parliamentary impeachment. As for acts of Parliament to attaint particular persons of treason or felony, or to inflict pains and penalties beyond or contrary to the common law, to serve a special purpose, I speak not of them, being to all intents and purposes new laws made pro re nata, and by no means an execution of such as are already in being. But an impeachment before the Lords by the Commons of Great Britain in Parliament is a prosecution of the already known and established law, and has been frequently put in practice, being a presentment to the Most High and Supreme Court of Criminal Jurisdiction by the most solemn grand inquest of the whole kingdom. A commoner cannot, however, be impeached before the Lords for any capital offense, but only for high misdemeanors. A peer may be impeached for any crime. And they usually, in case of an impeachment of a peer for treason, address the Crown to appoint a Lord High Steward for the greater dignity and regularity of their proceedings, which High Steward was formerly elected by the peers themselves, though he was generally commissioned by the King. But it hath of late years been strenuously maintained that the appointment of an high steward in such cases is not indispensably necessary, but that the House may proceed without one. The articles of impeachment are a kind of bills of indictment found by the House of Commons and afterwards tried by the Lords, who are in cases of misdemeanors considered not only as their own peers, but as the peers of the whole nation. This is a custom derived to us from the constitution of the ancient Germans, who in their great councils sometimes tried capital accusations relating to the public. Dicet apud concilium accusare quoque, et discrimin capitis intendere. And it has a peculiar propriety in the English Constitution, which has much improved upon the ancient motto imported hither from the Continent. For though in general the union of the legislative and judicial powers ought to be most carefully avoided, yet it may happen that a subject entrusted with the administration of public affairs may infringe the rights of the people, and be guilty of such crimes as the ordinary magistrate either dares not or cannot punish. Of these, the representatives of the people, or House of Commons, cannot properly judge, because their constituents are the parties injured, and can therefore only impeach. But before what court shall this impeachment be tried? Not before the ordinary tribunals, which would naturally be swayed by the authority of so powerful an accuser. Reason, therefore, will suggest that this branch of the legislature, which represents the people, must bring its charge before the other branch, which consists of the nobility, who have neither the same interests nor the same passions as popular assemblies. This is a vast superiority which the constitution of this island enjoys over those of the Grecian or Roman republics, where the people were at the same time both judges and accusers. It is proper that the nobility should judge to ensure justice to the accused, as it is proper that the people should accuse to ensure justice to the commonwealth. And therefore, among other extraordinary circumstances attending the authority of this court, there is one of a very singular nature which was insisted on by the House of Commons in the case of the Earl of Danby in the reign of Charles II, and is now enacted by Statute 12 and 13 William III C2, that no pardon under the Great Seal shall be pleadable to an impeachment by the Commons of Great Britain in Parliament. 2. The Court of the Lord High Steward of Great Britain is a court instituted for the trial of peers indicted for treason or felony or for misprision of either. The office of this great magistrate is very ancient, and was formerly hereditary, or at least held for life, or dum bene se gesiret. But now it is usually, and hath been for many centuries past, granted pro hac vice only. And it hath been the constant practice, and therefore seems now to have become necessary, to grant it to a Lord of Parliament, else he is incapable to try such delinquent peer. When such indictment is therefore found by a grand jury of freeholders in the King's Bench, or at the assizes before the justices of Oyer and Terminer, it is to be removed by a writ of certiorari into the court of the Lord High Steward, which has only power to determine it. A peer may plead a pardon before the Court of King's Bench, and the judges have a power to allow it, in order to prevent the trouble of appointing an high steward merely for the purpose of receiving such plea. But he may not plead in that inferior court any other plea, as guilty or not guilty of the indictment, but only in this court, because in consequence of such plea it is possible that judgment of death might be awarded against him. The king, therefore, in case a peer be indicted of treason, felony, or misprision, creates a Lord High Steward pro hac vice by commission under the Great Seal, which recites the indictment so found, and gives his grace power to receive and try it secundum legem et consuetudinem Angliae. Then when the indictment is regularly removed by the writ of certiorari, commanding the inferior court to certify it up to him, the Lord High Steward directs a precept to a sergeant at arms to summon the lords to attend and try the indicted peer. This precept was formerly issued to summon only 18 or 20 selected from the body of peers. Then the number came to be indefinite, and the custom was for the Lord High Steward to summon as many as he thought proper, but of late years not less than 23, and that those lords only should sit upon the trial, which threw a monstrous weight of power into the hands of the crown, and this its great officer, of selecting only such peers as the then predominant party should most approve of. And accordingly, when the Earl of Clarendon fell into disgrace with Charles II, there was a design formed to prorogue the Parliament in order to try him by a select number of peers, it being doubted whether the whole House could be induced to fall in with the views of the court. But now by Statute 7, William III C3, upon all trials of peers for treason or misprision, all the peers who have a right to sit and vote in Parliament shall be summoned, at least 20 days before such trial, to appear and vote therein. And every lord appearing shall vote in the trial of such peer, first taking the oaths of allegiance and supremacy, and subscribing the declaration against popery. During the session of Parliament, the trial of an indicted peer is not properly in the court of the Lord High Steward, but before the court last mentioned of our Lord the King in Parliament. It is true, a Lord High Steward is always appointed in that case to regulate and add weight to the proceedings, but he is rather in the nature of a speaker pro tempore or chairman of the court than the judge of it. For the collective body of the peers are therein the judges both of law and fact, and the high steward has a vote with the rest in right of his peerage. But in the court of the Lord High Steward, which is held in the recess of Parliament, he is the sole judge in matters of law, as the Lords Triers are in matters of fact. And as they may not interfere with him in regulating the proceedings of the court, so he has no right to intermix with them in giving any vote upon the trial. Therefore, upon the conviction and attainder of a peer for murder in full Parliament, it hath been holden by the judges that in case the day appointed in the judgment for execution should lapse before execution done, a new time of execution may be appointed by either the High Court of Parliament during its sitting, though no High Steward should be existing, or in the recess of Parliament by the Court of King's Bench, the record being removed into that court. It has been a point of some controversy whether the bishops have now a right to sit in the court of the Lord High Steward to try indictments of treason and misprision. Some incline to imagine them included under the general words of the statute of King William, all peers who have a right to sit and vote in Parliament. But the expression had been much clearer if it had been all lords and not all peers. For though bishops, on account of the baronies annexed to their bishoprics, are clearly lords of Parliament, yet their blood not being ennobled, they are not universally allowed to be peers with the temporal nobility, and perhaps this word might be inserted purposely with a view to exclude them. However, there is no instance of their sitting on trials for capital offences, even upon impeachments or indictments in full Parliament, much less in the court we are now treating of. For indeed, they usually voluntarily withdraw, but enter a protest declaring their right to stay. It is certain that in the 11th chapter of the Constitutions of Clarendon, made in Parliament 11 Henry II, they are expressly excluded from sitting and voting in trials of life or limb. Episcopi, sicut caeteri barones, debet interesse judicis cumberanibus, quousque perveniatur ad diminitionem membrorum, vel ad mortem. And Becket's quarrel with the king hereupon was not on account of the exception, which was agreeable to the canon law, but of the general rule that compelled the bishops to attend at all. And the determination of the House of Lords in the Earl of Danby's case, which hath ever since been adhered to, is consonant to these constitutions, that the Lords Spiritual have a right to stay and sit in court in capital cases till the court proceeds to the vote of guilty or not guilty. It must be noted that this resolution extends only to trials in full Parliament, for to the court of the Lord High Steward, in which no vote can be given, but merely that of guilty or not guilty, no bishop as such ever was or could be summoned. And though the statute of King William regulates the proceedings in that court, as well as in the court of Parliament, yet it never intended to new model or alter its constitution, and consequently does not give the Lords Spiritual any right in cases of blood in which they had not before. And what makes their exclusion more reasonable is, that they have no right to be tried themselves in the court of the Lord High Steward, and therefore surely ought not to be judges there. For the privilege of being thus tried depends upon nobility of blood rather than a seat in the House, as appears from the trials of popish lords, or of lords under age, and, since the Union, of the Scots nobility, though not in the number of 16, and from the trials of females, such as the Queen Consort or Dowager, and of all peeresses by birth, and peeresses by marriage also, unless they have, when dowagers, disparaged themselves by taking a commoner to their second husband. 3. The Court of King's Bench, concerning the nature of which we partly inquired in the preceding book, was, we may remember, divided into a Crown side and a Plea side. And on the Crown side, or Crown Office, it takes cognizance of all criminal cases from high treason down to the most trivial misdemeanor or breach of the peace. Into this court also indictments from all inferior courts may be removed by writ of certiorari and tried either at bar or at nisi prius by a judge of the county out of which the indictment is brought. The judges of this court are the supreme coroners of the kingdom, and the court itself is the principal court of criminal jurisdiction, though the two former are of greater dignity, known to the laws of England. For which reason, by the coming of the Court of King's Bench into any county, as it was removed to Oxford on account of the sickness in 1665, all former commissions of Oyer and Terminer and General Jail Delivery are at once absorbed and determined ipso facto, in the same manner as by the old Gothic and Saxon constitutions, jure vestusto obtinuit, quia vice omnia inferioria judicia dicente jus rege. Into this court of King's Bench hath reverted all that was good and salutary of the jurisdiction of the Court of Star Chamber, Camera Stellata, which was a court of very ancient original, but new modelled by Statute 3 Henry VII c. 1 and 21 Henry VIII c. 20, consisting of divers lords spiritual and temporal, being privy councillors, together with two judges of the courts of common law, without intervention of any jury. Their jurisdiction extended legally over riots, perjury, misbehavior of sheriffs, and other notorious misdemeanors contrary to the laws of the land. Yet this was afterwards, as Lord Clarendon informs us, stretched to the asserting of all proclamations and orders of state, to the vindicating of all illegal commissions and grants of monopolies, holding for honorable that which pleased, and for just that which profited, and becoming both a court of law to determine civil rights and a court of revenue to enrich the treasury. The council table by proclamations enjoining to the people that which was not enjoined by the laws, and prohibiting that which was not prohibited. And the Star Chamber, which consisted of the same persons in different rooms, censuring the breach and disobedience to those proclamations by very great fines, imprisonments, and corporal severities, so that any disrespect to any acts of state, or to the persons of statesmen, was in no time more penal, and the foundations of right never more in danger to be destroyed. For which reasons it was finally abolished by Statute 16 Charles I c. 10, to the great general joy of the whole nation. 4. The Court of Chivalry, of which we also formerly spoke as a military court or court of honor when held before the Earl Marshal only, is also a criminal court when held before the Lord High Constable of England jointly with the Earl Marshal. And then it has jurisdiction over pleas of life and member, arising in matters of arms and deeds of war, as well out of the realm as within it. But the criminal as well as civil part of its authority is fallen into entire disuse, there having been no permanent High Constable of England, but only pro hoc vice at coronations and the like, since the attainder and execution of Stafford, Duke of Buckingham, in the 13th year of Henry VIII, the authority in charge both in war and peace being deemed too ample for a subject, so ample that when Chief Justice Finney was asked by King Henry VIII how far they extended, he declined answering, and said the decision of that question belonged to the law of arms and not to the law of England. 5. The High Court of Admiralty, held before the Lord High Admiral of England or his deputy, styled the Judge of the Admiralty, is not only a court of civil but also of criminal jurisdiction. This court hath cognizance of all crimes and offences committed either upon the sea or on the coasts, out of the body or extent of any English county, and by Statute 15 Richard II c. 3, of death and mayhem happening in great ships being and hovering in the main stream of great rivers, below the bridges of the same rivers, which are then a sort of ports or havens, such as are the ports of London and Gloucester, though they lie at a great distance from the sea. But as this court proceeded without jury in a method much conformed to the civil law, the exercise of a criminal jurisdiction therein was contrary to the genius of the law of England, insomuch as a man might be there deprived of his life by the opinion of a single judge without the judgment of his peers. And besides, as innocent persons might thus fall a sacrifice to the caprice of a single man, so very gross offenders might, and frequently did, escape punishment. For the rule of the civil law is, how reasonably I shall not at present inquire, that no judgment of death can be given against offenders without proof by two witnesses or a confession of the fact by themselves. This was always a great offence to the English nation, and therefore in the 8th year of Henry VI it was endeavoured to apply a remedy in Parliament, which then miscarried for want of the royal assent. However, by the statute 28 Henry VIII c. 15, it was enacted that these offences should be tried by commissioners nominated by the Lord Chancellor, namely, the Admiral or his deputy, and 3 or 4 more, among whom 2 common law judges are constantly appointed, who in effect try all the prisoners, the indictment being first found by a grand jury of 12 men, and afterwards tried by another jury as at common law, and that the course of proceedings should be according to the law of the land. This is now the only method of trying marine felonies in the Court of Admiralty, the Judge of the Admiralty still presiding therein, just as the Lord Mayor presides at the sessions in London. These 5 courts may be held in any part of the kingdom, and their jurisdiction extends over crimes that arise throughout the whole of it, from one end to the other. End of chapter the 19th, part 1. Chapter 19, Part 2 of the Commentaries on the Laws of England, Book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 19th of Courts of a Criminal Jurisdiction, Part 2. What follow are also of a general nature and universally diffused over the nation, but are of a local jurisdiction and confined to particular districts, of which species is 6. The Court of Oyer and Terminer and General Jail Delivery, which is held before the King's Commissioners, among whom are usually 2 judges of the courts at Westminster, twice in every year in every county of the kingdom, except the 4 northern ones, where it is held only once, and London and Middlesex, wherein it is held 8 times. This was slightly mentioned in the preceding book, when we then observed that at what is usually called the assizes, judges sit by virtue of 5 several authorities, 2 of which, the Commission of Assize and its attendant jurisdiction of nisi prius, being principally of a civil nature, were then explained at large, to which I shall only add that these justices have, by virtue of several statutes, a criminal jurisdiction also in certain special cases. The third, which is the Commission of the Peace, was also treated in a former volume when we inquired into the nature and office of a Justice of the Peace. I shall only add that all the justices of the peace of any county wherein the assizes are held are bound by law to attend them, or else be liable to a fine, in order to return recognizances, etc., and to assist the judges in such matters as lie within their knowledge and jurisdiction, and in which some of them have probably been concerned by way of previous examination. But the 4th authority is the Commission of Oyer and Terminer, to hear and determine all treasons, felonies, and misdemeanors. This is directed to the judges and several others, but the judges only are of the quorum, so that the rest cannot act without them. The words of the Commission are, to inquire, hear, and determine, so that by virtue of this Commission they can only proceed upon an indictment found at the same assizes. For they must first inquire by means of grand jury or inquest before they are empowered to hear and determine by the help of a petit jury. Therefore, they have besides, fifthly, a commission of general jail delivery, which empowers them to try and deliver every prisoner who shall be in the jail when the judges arrive at the circuit town, whenever indicted, or for whatever crime committed. It was anciently the course to issue special writs of jail delivery for each particular prisoner, which were called the writs de bono et malo, but these being found inconvenient and oppressive, a general commission for all the prisoners has long been established in their stead, so that one way or the other the jails are cleared and all offenders tried, punished, or delivered twice in every year, a constitution of singular use and excellence. Sometimes also, upon urgent occasions, the king issues a special or extraordinary commission of oyer interminer and jail delivery, confined to those offences which stand in need of immediate inquiry and punishment, upon which the course of proceeding is the same as upon general and ordinary commissions. Formerly, it was held in pursuance of the statutes 8 Richard II c. 2 and 33 Henry VIII c. 4 that no judge or other lawyer could act in the commission of oyer interminer or in that of jail delivery within his own county where he was born or inhabited, in the like manner as they are prohibited from being judges of assize and determining civil causes. But that local partiality which the jealousy of our ancestors was careful to prevent, being judged less likely to operate in the trial of crimes and misdemeanors than in matters of property and disputes between party and party, it was thought proper by Statute 12 George II c. 27 to allow any man to be a justice of oyer interminer and general jail delivery within any county of England. 7. The Court of General Quarter Sessions of the Peace is a court that must be held in every county once in every quarter of the year, which by Statute 2 Henry V c. 4 is appointed to be in the first week after Michaelmas Day, the first week after the Epiphany, the first week after the close of Easter, and in the week after the translation of St. Thomas the Martyr or the 7th of July. It is held before 2 or more justices of the peace, one of which must be of the quorum. The jurisdiction of this court by Statute 34 Edward III c. 1 extends to the trying and determining all felonies and trespasses whatsoever, though they seldom, if ever, try any greater offense than small felonies within the benefit of clergy, their commission providing that, if any case of difficulty arises, they shall not proceed to judgment but in the presence of one of the justices of the courts of King's Bench or Common Pleas, or one of the justices of assize, and therefore murders and other capital felonies are usually remitted for a more solemn trial to the assizes. They cannot also try any new created offense without express power given them by the statute which creates it. But there are many offenses and particular matters which by particular statutes belong properly to this jurisdiction and ought to be prosecuted in this court, as the smaller misdemeanors against the public or commonwealth not amounting to felony, and especially offenses relating to the game, highways, alehouses, bastard children, the settlement and provision for the poor, vagrants, servant wages, apprentices, and popish recusants. Some of these are proceeded upon by indictment, and others in a summary way by motion and order thereupon, which order may for the most part, unless guarded against by particular statutes, be removed into the Court of King's Bench by writ of certiorari facias, and there be quashed or confirmed. The records or rolls of the sessions are committed to the custody of the special officer denominated custos rotulorum, who is always a justice of the quorum, and among them of the quorum, saith Lambarde, a man for the most part especially picked out either for wisdom, countenance, or credit. The nomination of the custos rotulorum, who is the principal civil officer in the county, as the Lord Lieutenant is the chief in military command, is by the king's signed manual, and to him the nomination of the clerk of the peace belongs, which office he is expressly forbidden to sell for money. In most corporation towns there are quarter sessions kept before justices of their own within their respective limits, which have exactly the same authority as the general quarter sessions of the county, except in a very few instances, one of the most considerable of which is the matter of appeals from orders of removal of the poor, which, though they be from the orders of corporation justices, must be to the sessions of the county by statute 8 and 9, William III, c. 30. In both corporations and counties at large, there is sometimes kept a special or petty session by a few justices for dispatching smaller business in the neighborhood between the times of the general sessions, as for licensing alehouses, passing the accounts of parish officers, and the like. 8. The sheriff's turn or rotation is a court of record held twice every year within a month after Easter and Michaelmas before the sheriff in different parts of the county, being indeed only the turn of the sheriff to keep a court leet in each respective hundred. This therefore is the great court leet of the county, as the county court is the court baron, for out of this, for the ease of the sheriff was taken. 9. The court leet, or view of frank pledge, which is a court of record held once in the year and not oftener, within a particular hundred, lordship, or manor, before the steward of the leet, being the king's court granted by charter to the lords of those hundreds or manors. Its original intent was to view the frank pledges, that is, the freemen within the liberty, who, we may remember, according to the institution of the great Alfred, were all mutually pledges for the good behavior of each other. Besides this, the preservation of the peace and the chastisement of divers minute offenses against the public good are the objects both of the court leet and the sheriff's turn, which have exactly the same jurisdiction, one being only a larger species of the other, extending over more territory, but not over more causes. All freeholders within the precinct are obliged to attend them, and all persons cormorant therein, which cormorancy consists in usually lying there, a regulation which owes its original to the laws of King Canute. But persons under 12 and above 60 years old, peers, clergymen, women, and the king's tenants in ancient demesne are excused from attendance there, all others being bound to appear upon the jury if required and make their due presentments. It was also anciently the custom to summon all the king's subjects as they respectively grew to years of discretion and strength, to come to the court leet and there take the oath of allegiance to the king. The other general business of the leet and turn was to present by jury all crimes whatsoever that happened within their jurisdiction, and not only to present, but also to punish all trivial misdemeanors, as trivial debts were recoverable in the court baron and county court. Justice in these matters of both kinds being brought home to the doors of every man by our ancient constitution. Thus, in the Gothic constitution, the Arreda, which answered to our court leet, de omnibus quidem cognoscet, non tamen de omnibus judicat. The objects of their jurisdiction are therefore unavoidably very numerous, being such as in some degree, either less or more, affect the public weal or good governance of the district in which they arise. From common nuisances and other material offences against the king's peace and public trade, down to eavesdropping, waifs, and irregularities in public commons. But both the turn and the leet have been for a long time in a declining way, a circumstance owing in part to the discharge granted by the Statute of Marlbridge 52 Henry III c. 10 to all prelates, peers, and clergymen from their attendance upon these courts, which occasioned them to grow into disrepute. And hence it is that their business hath for the most part gradually devolved upon the quarter sessions, which it is particularly directed to do in some cases by statute 1 Edward IV. c. 2. 10. The court of the coroner is also a court of record to inquire when anyone dies in prison or comes to a violent or sudden death by what manner he came to his end. And this he is only entitled to do super visum corporis. Of the coroner and his office we treated at large in a former volume among the public officers and ministers of the kingdom, and therefore shall not here repeat our inquiries, only mentioning his court by way of regularity among the criminal courts of the nation. 11. The court of the clerk of the market is incident to every fair and market in the kingdom to punish misdemeanors therein, as a court of pied poudre is to determine all disputes relating to private or civil property. The object of this jurisdiction is principally the cognizance of weights and measures to try whether they be according to the true standard thereof or no, which standard was anciently committed to the custody of the bishop, who appointed some clerk under him to inspect the abuse of them more narrowly, and hence this officer, though now usually a layman, is called the clerk of the market. If they be not according to the standard, then, besides the punishment of the party by fine, the weights and measures themselves ought to be burnt. This is the most inferior court of criminal jurisdiction in the kingdom, though the objects of its coercion were esteemed among the Romans of such importance to the public that they were committed to the care of some of their most dignified magistrates, the curulae aediles. 12. There are a few other criminal courts of greater dignity than many of these, but of a more confined and partial jurisdiction, extending only to some particular places which the royal favor, confirmed by Act of Parliament, has distinguished by the privilege of having peculiar courts of their own for the punishment of crimes and misdemeanors arising within the bounds of their cognizance. These being not universally dispersed or of general use as the former, but confined to one spot as well as to a determinate species of causes, may be denominated private or special courts of criminal jurisdiction. I speak not here of ecclesiastical courts, which punish spiritual sins rather than temporal crimes by penance, contrition, and excommunication pro salute animae, or which is looked upon as equivalent to all the rest, by a sum of money to the officers of the court by way of commutation of penance. Of these we discourse sufficiently in the preceding book. I am now speaking of such courts as proceed according to the course of the common law, which is a stranger to such unaccountable barterings of public justice. 1. And first, the court of the Lord Steward, Treasurer, or Comptroller of the King's household was instituted by Statute 3, Henry VII, c. 14, to inquire of felony by any of the King's sworn servants in the check roll of the household under the degree of a lord, in confederating, compassing, conspiring, and imagining the death or destruction of the King, or any lord or other of his Majesty's privy council, or the Lord Steward, Treasurer, or Comptroller of the King's house. The inquiry and trial thereon must be by a jury according to the course of the common law, consisting of 12 sad men, that is, sober and discreet persons of the King's household. 2. The court of the Lord Steward of the King's household, or, in his absence, of the Treasurer, Comptroller, and Steward of the Marshalsea, was erected by Statute 33 Henry VIII c. 12, with the jurisdiction to inquire of, hear, and determine all treasons, misprisions of treason, murders, manslaughters, bloodshed, and other malicious strikings, whereby blood shall be shed in any of the palaces and houses of the king, or in any other house where the royal person shall abide. The proceedings are also by jury, both a grand and petite one, as at common law, taken out of the officers and sworn servants of the king's household. The form and solemnity of the process, particularly with regard to the execution of the sentence for cutting off the hand, which is part of the punishment for shedding blood in the king's court, is very minutely set forth in the said statute 33 Henry VIII, and several offices of the servants of the household in and about such execution are described, from the sergeant of the wood yard who furnishes the chopping block to the sergeant farrier who brings hot irons to sear the stump. 3. As in the preceding book we mentioned the courts of the two universities or their chancellors' courts for the redress of civil injuries, it will not be improper now to add a short word concerning the jurisdiction of their criminal courts, which is equally large and extensive. The Chancellor's Court of Oxford, with which university the author hath been chiefly conversant, though probably that of Cambridge hath also a similar jurisdiction, hath authority to determine all causes of property wherein a privileged person is one of the parties, except only causes of freehold, and also all criminal offences or misdemeanours under the degree of treason, felony, or mayhem. The prohibition of meddling with freehold still continues, but the trial of treason, felony, and mayhem by a particular charter is committed to the university jurisdiction in another court, namely, the court of the Lord High Steward of the university. For by the charter of 7 June 2 Henry IV, confirmed among the rest by the statute 13 Elizabeth c. 29, cognizance is granted to the University of Oxford of all indictments of treasons, insurrections, felony, and mayhem, which shall be found in any of the king's courts against a scholar or privileged person, and they are to be tried before the high steward of the university or his deputy, who is to be nominated by the chancellor of the university for the time being. But when his office is called forth into action, such high steward must be approved by the Lord High Chancellor of England, and a special commission under the Great Seal is given to him and others to try the indictment then depending according to the law of the land and the privilege of the said university. When, therefore, an indictment is found at the assizes or elsewhere against any scholar of the university or other privileged person, the vice-chancellor may claim the cognizance of it, and, when claimed in due time and manner, it ought to be allowed him by the judges of assize, and then it comes to be tried in the high steward's court. But the indictment must first be found by a grand jury, and then the cognizance claimed. For I take it that the high steward cannot proceed originally ad inquirendum, but only after inquest in the common law courts ad audiendum et determinandum, much in the same manner as, when a peer is to be tried in the court of the Lord High Steward of Great Britain, the indictment must first be found at the assizes or in the court of King's Bench, and then, in consequence of a writ of certiorari, transmitted to be finally heard and determined before His Grace the Lord High Steward and the peers. When the cognizance is so allowed, if the offence be inter minora crimina, or a misdemeanor only, it is tried in the Chancellor's Court by the ordinary judge. But if it be for treason, felony, or mayhem, it is then and then only to be determined before the High Steward under the King's special commission to try the same. The process of the trial is this. The High Steward issues one precept to the Sheriff of the county, who thereupon returns a panel of 18 freeholders, and another precept to the beadles of the university, who thereupon return a panel of 18 matriculated laymen, laicos privilegio universitatis gaudentes, and by a jury formed de mediatate, half of freeholders and half of matriculated persons, is the indictment to be tried, and that in the Guildhall of the city of Oxford. And if execution be necessary to be awarded in consequence of finding the party guilty, the sheriff of the county must execute the university process to which he is annually bound by an oath. I have been the more minute in describing these proceedings, as there has happily been no occasion to reduce them into practice for more than a century past, though it is not a right that merely rests in scriptus or theory, but has formerly often been carried into execution. There are many instances, one in the reign of Queen Elizabeth, two in that of James I, and two in that of Charles I, where indictments for murder have been challenged by the Vice Chancellor at the Assizes and afterwards tried before the High Steward by jury. The commissions under the Great Seal, the sheriffs and beadles panels, and all the other proceedings on the trial of the several indictments are still extant in the archives of that university. End of chapter the 19th, part 2. Chapter 20 of the Commentaries on the Laws of England, Book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 20th of Summary Convictions. We are next, according to the plan I have laid down, to take into consideration the proceedings in the courts of criminal jurisdiction in order to the punishment of offenses. These are plain, easy, and regular, the law not admitting any fictions as in civil causes to take place where the life, liberty, and the safety of the subject are more immediately brought into jeopardy. And these proceedings are divisible into two kinds, summary and regular. Of the former, of which I shall briefly speak before we enter upon the latter, which will require a more thorough and particular examination. By a summary proceeding I mean principally such as is directed by several acts of Parliament, for the common law is a stranger to it unless in the case of contempts, for the conviction of offenders and the inflicting of certain penalties created by those acts of Parliament. In these there is no intervention of a jury, but the party accused is acquitted or condemned by the suffrage of such person only as the statute has appointed for his judge. An institution designed professedly for the greater ease of the subject by doing him speedy justice, and by not harassing the freeholders with frequent and troublesome attendances to try every minute offence. But it has of late been so far extended, as if a check be not timely given to threaten the disuse of our admirable and truly English trial by jury, unless only in capital cases. For 1. Of this summary nature are all trials of offences and frauds contrary to the laws of the excise and other branches of the revenue, which are to be inquired into and determined by the commissioners of the respective departments or by justices of the peace in the country, officers who are all of them appointed and removable at the discretion of the Crown. And though such convictions are absolutely necessary for the due collection of the public money, and are a species of mercy to the delinquents who would be ruined by the expense and delay of frequent prosecutions by indictment, and though such has usually been the conduct of the commissioners as seldom, if ever, to afford just grounds to complain of oppression, yet when we consider the various and almost innumerable branches of this revenue which may be in their turns the subjects of fraud, or at least complaints of fraud, and of course the objects of this summary and arbitrary jurisdiction, we shall find that the power of these officers of the Crown over the property of the people is increased to a very formidable height. 2. Another branch of summary proceedings is that before justices of the peace in order to inflict divers petty pecuniary mulcts and corporate penalties denounced by Act of Parliament for many disorderly offences, such as common swearing, drunkenness, vagrancy, idleness, and a vast variety of others, for which I must refer the student to the justice books formerly cited, and which used to be formally punished by the verdict of a jury in the court leet. This change in the administration of justice hath, however, had some mischievous effects, as 1. The almost entire disuse and contempt of the court leet and sheriff's turn, the king's ancient courts of common law, formerly much revered and respected. 2. The burthensome increase of the business of a justice of the peace, which discourages so many gentlemen of rank and character from acting in the commission, from an apprehension that the duty of their office would take up too much of that time which they are unwilling to spare from the necessary concerns of their families, the improvement of their understandings, and their engagements in other services of the public. Though if all gentlemen of fortune had it both in their power and inclinations to act in this capacity, the business of a justice of the peace would be more divided, and fall the less heavy upon individuals, which would remove what in the present scarcity of magistrates is really an objection so formidable that the country is greatly obliged to any gentleman of figure who will undertake to perform that duty which in consequence of his rank in life he owes more peculiarly to his country. However, this backwardness to act as magistrates, arising greatly from the increase of summary jurisdiction, is productive of 3. A third mischief, which is that this trust, when slighted by gentlemen, falls of course into the hands of those who are not so, but the mere tools of office. And then the extensive power of a justice of the peace, which even in the hands of men of honor is highly formidable, will be prostituted to mean and scandalous purposes, to the low ends of selfish ambition, avarice, or personal resentment. And from these ill consequences we may collect the prudent foresight of our ancient lawgivers, who suffered neither the property nor the punishment of the subject to be determined by the opinion of any one or two men, and we may also observe the necessity of not deviating any farther from our ancient constitution by ordaining new penalties to be inflicted upon summary convictions. The process of these summary convictions, it must be owned, is extremely speedy, though the courts of common law have thrown in one check upon them by making it necessary to summon the party accused before he is condemned. This is now held to be an indispensable requisite, though the justices long struggled the point, forgetting the rule of natural reason expressed by Seneca, Qui statuit aliquid, parte inaudita altera, aequam licet statueret, aud aequus sut. A rule to which all municipal laws that are founded on the principles of justice have strictly conformed. The Roman law requiring a citation at least, and our own common law never suffering any fact, either civil or criminal, to be tried till it has previously compelled an appearance by the party concerned. After this summons, the magistrate, in summary proceedings, may go on to examine one or more witnesses, as the statute may require, upon oath, and then make his conviction of the offender in writing, upon which he usually issues his warrant, either to apprehend the offender in case corporal punishment is to be inflicted on him, or else to levy the penalty incurred by distress and sale of his goods. This is, in general, the method of summary proceedings before a justice or justices of the peace. But for particulars we must have recourse to the several statutes which create the offense or inflict the punishment, and which usually chalk out the method by which offenders are to be convicted. Otherwise, they fall of course under the general rule and can only be convicted by indictment or information at the common law. 3. To this head of summary proceedings may also be properly referred the method immemorially used by superior courts of justice of punishing contempts by attachment and the subsequent proceedings thereon. The contempts that are thus punished are either direct, which openly insult or resist the powers of the courts or the persons of the judges who preside there, or else are consequential, which, without such gross insolence or direct opposition, plainly tend to create an universal disregard of their authority. The principal instances of either sort that has been usually punished by attachment are chiefly of the following kinds. 1. Those committed by inferior judges and magistrates by acting unjustly, oppressively, or irregularly in administering those portions of justice which are entrusted to their distribution, or by disobeying the king's writs issuing out of the superior courts, by proceeding in a cause after it is put a stop to or removed by writ of prohibition, certiorari, error, supersedious, and the like. For as the king's superior courts, and especially the Court of King's Bench, have a general superintendence over all inferior jurisdictions, any corrupt or iniquitous practices of subordinate judges are contempts of that superintending authority whose duty it is to keep them within the bounds of justice. 2. Those committed by sheriffs, bailiffs, jailers, and other officers of the court by abusing the process of the law or deceiving the parties by any acts of oppression, extortion, collusive behavior, or culpable neglect of duty. 3. Those committed by attorneys and solicitors, who are also officers of the respective courts, by gross instances of fraud and corruption, injustice to their clients, or other dishonest practice. For the malpractice of the officers reflects some dishonor on their employers, and, if frequent or unpunished, creates among the people a disgust against the courts themselves. 4. Those committed by jurymen in collateral matters relating to the discharge of their office, such as making default when summoned, refusing to be sworn or to give any verdict, eating or drinking without leave of the court, and especially at the cost of either party, and other misbehaviors or irregularities of a similar kind, but not in the mere exercise of their judicial capacities, as by giving a false or erroneous verdict. 5. Those committed by witnesses, by making default when summoned, refusing to be sworn or examined, or prevaricating in their evidence when sworn. 6. Those committed by parties to any suit or proceeding before the court, as by disobedience to any rule or order made in the progress of a cause, by non-payment of cost awarded by the court upon a motion, or by non-observance of awards duly made by arbiters or umpires after having entered into a rule for submitting to such determination. 7. Those committed by any other persons under the degree of a peer, and even by peers themselves when enormous and accompanied with violence, such as formidable rescues and the like, or when they import a disobedience to the king's great prerogative writs of prohibition, habeas corpus, and the rest. Some of these contempts may arise in the face of the court, as by rude and contumelious behavior, by obstinacy, perverseness, or prevarication, by breach of the peace, or any wilful disturbance whatsoever; others in the absence of the party, as by disobeying or treating with disrespect the king's writ or rules of process of the court, by perverting such writ or process to the purposes of private malice, extortion, or injustice, by speaking or writing contemptuously of the court or judges acting in their judicial capacity, by printing false accounts, or even true ones without proper permission, of causes then depending in judgment, and by anything in short that demonstrates a gross want of that regard and respect which, when once courts of justice are deprived of, their authority, so necessary for the good order of the kingdom, is entirely lost among the people. The process of attachment for these and the like contempts must necessarily be as ancient as the laws themselves. For laws without a competent authority to secure their administration from disobedience and contempt would be vain and nugatory. A power, therefore, in the supreme courts of justice to suppress such contempts by an immediate attachment of the offender results from the first principles of judicial establishments, and must be an inseparable attendant upon every superior tribunal. Accordingly, we find it actually exercised as early as the annals of our law extend. And though a very learned author seems inclinable to derive this process from the statute of Westminster 2, 13, Edward I, c. 39, which ordains that in case the process of the king's court be resisted by the power of any great man, the sheriff shall chastise the resisters by imprisonment, a qua non deliberentos in speciale praecepto domini regis. And if the sheriff himself be resisted, he shall certify to the court the names of the principal offenders, their aiders, consenters, commanders, and favorers, and by a special writ judicial they shall be attached by their bodies to appear before the court, and if they be convicted thereof, they shall be punished at the king's pleasure, without any interfering by any other person whatsoever. Yet he afterwards more justly concludes that it is part of the law of the land, and, as such, is confirmed by the statute of Magna Carta. If the contempt be committed in the face of the court, the offender may be instantly apprehended and imprisoned at the discretion of the judges without any farther proof or examination. But in matters that arise at a distance, and of which the court cannot have so perfect a knowledge unless by the confession of the party or the testimony of others, if the judges upon affidavit see sufficient ground to suspect that a contempt has been committed, they either make a rule on the suspected party to show cause why an attachment should not issue against him, or, in very flagrant instances of contempt, the attachment issues in the first instance, as it also does if no sufficient cause be shown to discharge, and thereupon the court confirms and makes absolute the original rule. This process of attachment is merely intended to bring the party into court, and when there, he must either stand committed or put in bail, in order to answer upon oath such interrogatories as shall be administered to him for the better information of the court with respect to the circumstances of the contempt. These interrogatories are in the nature of a charge or accusation, and must, by the course of the court, be exhibited within the first 4 days, and if any of the interrogatories is improper, the defendant may refuse to answer it and move the court to have it struck out. If the party can clear himself upon oath, he is discharged, but if perjured, may be prosecuted for the perjury. If he confesses to the contempt, the court will proceed to correct him by fine or imprisonment, or both, and sometimes by a corporal or infamous punishment. If the contempt be of such a nature that, when the fact is once acknowledged, the court can receive no farther information by interrogatories than it is already possessed of, as in the case of Orescus, the defendant may be admitted to make such simple acknowledgment and receive his judgment without answering to any interrogatories. But if he wilfully and obstinately refuses to answer, or answers in an evasive manner, he is then clearly guilty of a high and repeated contempt to be punished at the discretion of the court. It cannot have escaped the attention of the reader that this method of making the defendant answer upon oath to a criminal charge is not agreeable to the genius of the common law in any other instance, and seems indeed to have been derived to the courts of King's Bench and Common Pleas through the medium of the courts of equity. For the whole process of the courts of equity in their several stages of a cause, and finally to enforce their decrees, was, till the introduction of sequestrations, in the nature of a process of contempt, acting only in personam and not in rem. And there, after the party in contempt has answered the interrogatories, such as answer may be contradicted and disproved by affidavits of the adverse party, whereas in the courts of law, the admission of the party to purge himself by oath is more favorable to his liberty, though perhaps not less dangerous to his conscience. For if he clears himself by his answers, the complaint is totally dismissed. And with regard to this singular mode of trial thus admitted in this one particular instance, I shall only for the present observe, that as the process by attachment in general appears to be extremely ancient, and has since the Restoration been confirmed by an express act of Parliament, So the method of examining the delinquent himself upon oath with regard to the contempt alleged is at least of as high antiquity, and by long and immemorial usage is now become the law of the land. End of chapter the 20th. Chapter 21 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 21st of Arrests. We are now to consider the regular and ordinary method of proceeding in the courts of criminal jurisdiction, which may be distributed under 12 general heads following each other in progressive order, viz. 1. Arrest. 2. Commitment and bail. 3. Prosecution. 4. Process. 5. Arraignment and its incidents. 6. Plea and issue. 7. Trial and conviction. 8. Clergy. 9. Judgment and its consequences. 10. Reversal of judgment. 11. Reprieve or pardon. 12. Execution, all which will be discussed in the subsequent part of this book. First, then, of an arrest, which is the apprehending or restraining of one's person in order to be forthcoming to answer an alleged or suspected crime. To this arrest all persons whatsoever are without distinction equally liable to all criminal cases, but no man is to be arrested unless charged with such a crime as will at least justify holding him to bail when taken. And in general, an arrest may be made by 4 ways. 1. By warrant. 2. By an officer without warrant. 3. By a private person also without warrant. 4. By hue and cry. 1. A warrant may be granted in extraordinary cases by the Privy Council or Secretaries of State, but ordinarily by justices of the peace. This they may do in cases where they have a jurisdiction over the offense in order to compel the person accused to appear before them, for it would be absurd to give them power to examine an offender unless they had also a power to compel him to attend and submit to such examination. And this extends undoubtedly to all treasons, felonies, and breaches of the peace, and also to all such offenses as they have power to punish by statute. Sir Edward Coke indeed hath laid it down that a justice of the peace cannot issue a warrant to apprehend a felon upon a bare suspicion, no, not even till an indictment be actually found, and the contrary practice is by others held to be grounded rather upon connivance than the express rule of law, though now by long custom established. A doctrine which would in most cases give loose to felons to escape without punishment, and therefore Sir Matthew Hale hath combated it with invincible authority and strength of reason, maintaining, 1. That a justice of the peace hath power to issue a warrant to apprehend a person accused of felony, though not yet indicted, and 2. That he may also issue a warrant to apprehend a person suspected of felony, though the original suspicion be not in himself, but in a party that prays his warrant, because he is a competent judge of the probability offered to him of such suspicion. But in both cases it is fitting to examine upon oath the party requiring a warrant, as well to ascertain that there is a felony or other crime actually committed, without which no warrant should be granted, as also to prove the cause and probability of suspecting the party against whom the warrant is prayed. This warrant ought to be under the hand and seal of the justice, should set forth the time and place of making, and the cause for which it is made, and should be directed to a constable or other peace officer, requiring him to bring the party either generally before any justice of the peace for the county, or only before the justice who granted it, the warrant in the latter case being called a special warrant. A general warrant to apprehend all persons suspected without naming or particularly describing any person in special is illegal and void for its uncertainty, for it is the duty of the magistrate and ought not to be left to the officer to judge of the ground of suspicion. And a warrant to apprehend all persons guilty of a crime therein specified is no legal warrant, for the point upon which its authority rests is a fact to be decided on a subsequent trial, namely, whether the person apprehended thereon be guilty or not. It is therefore in fact no warrant at all, for it will not justify the officer who acts under it, whereas a warrant properly penned, even though the magistrate who issues it shall exceed his jurisdiction, will, by statute 24 George II, c. 44, at all events indemnify the officer who executes the same ministerially. And when a warrant is received by the officer, he is bound to execute it so far as the jurisdiction of the magistrate and himself extends. A warrant from the chief or other justice of the Court of King's Bench extends all over the kingdom, and is test or dated England, not Oxfordshire, Berks, or other particular county. But the warrant of a justice of the peace in any one county, as Yorkshire, must be backed, that is, signed by a justice of the peace in another, as Middlesex, before it can be executed there. Formerly, regularly speaking, there ought to have been a fresh warrant in every fresh county, but the practice of backing warrants had long prevailed without law, and was at last authorized by statutes 23 George II, c. 26, and 24 George II, c. 55. 2. Arrests by officers without warrant may be executed, 1. By a justice of the peace who may himself apprehend or cause to be apprehended by word only any person committing a felony or breach of the peace in his presence. 2. The sheriff, and 3. The coroner may apprehend any felon within the county without a warrant. 4. The constable, of whose office we formerly spoke, hath great original and inherent authority with regard to arrests. He may, without warrant, arrest anyone for a breach of the peace and carry him before a justice of the peace. And, in case of felony actually committed, or a dangerous wounding whereby felony is like to ensue, he may upon probable suspicion arrest the felon, and for that purpose is authorized, as upon a justice's warrant, to break open doors and even to kill the felon if he cannot be otherwise taken. And if he or his assistants be killed in attempting such arrest, it is murder in all concerned. 5. Watchmen, either those appointed by the Statute of Winchester 13 Edward I c. 4 to keep watch and ward in all towns from sunsetting to sunrising, or such as are mere assistants to the constable, may virtute officii arrest all offenders, and particularly night walkers, and commit them to custody till morning. 3. Any private person, and a fortiori a peace officer, that is present when any felony is committed, is bound by the law to arrest the felon on pain of fine and imprisonment if he escapes through the negligence of the standers by, and they may justify breaking open doors upon such felon, and if they kill him, provided he cannot be otherwise taken, it is justifiable, though if they are killed in endeavoring to make such arrest, it is murder. Upon probable suspicion also, a private person may arrest the felon or other person so suspected, but he cannot justify breaking open doors to do it, and if either party kill the other in the attempt, it is manslaughter and no more. It is no more, because there is no malicious design to kill, but it amounts to so much because it would be of most pernicious consequence if, under pretense of suspecting felony, any private person might break open a house or kill another, and also because such arrest upon suspicion is barely permitted by the law and not enjoined as in the case of those who are present when a felony is committed. 4. There is yet another species of arrest wherein both officers and private men are concerned, and that is upon a hue and cry raised upon a felony committed. And hue, from huer to shout, and cry, hutesium et clamor, is the old common law process of pursuing with horn and with voice all felons and such as have dangerously wounded another. It is also mentioned by statute Westminster 1, 3, Edward I, c. 9, and 4, Edward I, de officio coronatoris. But the principal statute relative to this matter is that of Winchester 13, Edward I, c. 1 and 4, which directs that from thenceforth every county shall be so well kept that immediately upon robberies and felonies committed, fresh suit shall be made from town to town and from county to county, and that hue and cry shall be raised upon the felons, and they that keep the town shall follow with hue and cry, with all the town and the towns near. And so hue and cry shall be made from town to town until they be taken and delivered to the sheriff. And that such hue and cry may more effectually be made, the hundred is bound by the same statute, c. 3, to answer for all robberies therein committed unless they take the felon, which is the foundation of an action against the hundred in case of any loss by robbery. By statute 27 Elizabeth c. 13, no hue and cry is sufficient unless made with both horsemen and footmen. And by statute 8 George II, c. 16, the constable or like officer refusing or neglecting to make hue and cry forfeits £5, and the whole ville or district is still in strictness liable to be amerced according to the law of Alfred if any felony be committed therein and the felon escapes. An institution which hath long prevailed in many of the eastern countries, and hath in part been introduced even into the Mogul Empire about the beginning of the last century, which is said to have effectually delivered that vast territory from the plague of robbers by making in some places the villages, in others the offices of justice, responsible for all the robberies committed within their respective districts. Hue and cry may be raised either by precept of a justice of the peace, or by a peace officer, or by any private man that knows of a felony. The party raising it must acquaint the constable of the ville with all the circumstances which he knows of the felony and the person of the felon, and thereupon the constable is to search his own town and raise all the neighboring villes and make pursuit with horse and foot. And in the prosecution of such hue and cry, the constable and his attendants have the same powers, protection, and indemnification as if acting under the warrant of a justice of the peace. But if a man wantonly or maliciously raises a hue and cry without cause, he shall be severely punished as a disturber of the public peace. In order to encourage farther the apprehending of certain felons, rewards and immunities are bestowed on such as bring them to justice by diverse acts of Parliament. The statute 4 and 5 William and Mary c. 8 enacts that such as apprehend a highwayman and prosecute him to conviction shall receive a reward of £40 from the public, to be paid to them, or, if killed in the endeavor to take him, their executors, by the sheriff of the county, to which the statute 8 George II, c. 16, superadds £10 to be paid by the hundred indemnified by such taking. By statute 10 and 11 William III, c. 23, any person apprehending and prosecuting to conviction a felon guilty of burglary or private larceny to the value of 5 shillings from any shop, warehouse, coach house, or stable, shall be excused from all parish offices. And by statute 5 and c. 31, any person so apprehending and prosecuting a burglar or felonious housebreaker, or if killed in the attempt, his executors, shall be entitled to a reward of £40. End of chapter the 21st. Chapter 22 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 22nd of Commitment and Bail. When a delinquent is arrested by any of the means mentioned in the preceding chapter, he ought regularly to be carried before a justice of the peace, and how he is there to be treated I shall next show under the second head of commitment and bail. The justice before whom such prisoner is brought is bound immediately to examine the circumstances of the crime alleged, and to this end, by statute 2 and 3 Philip and Mary c. 10, he is to take in writing the examination of such prisoner and the information of those who bring him, which, Mr. Lambarde observes, was the first warrant given for the examination of a felon in the English law. For at the common law, nemo tenebatur prodere se ipsum, and his fault was not to be wrung out of himself, but rather to be discovered by other means and other men. If upon this inquiry it manifestly appears either that no such crime was committed, or that the suspicion entertained of the prisoner was wholly groundless, in such cases only it is lawful totally to discharge him. Otherwise, he must either be committed to prison or give bail, that is, put in securities for his appearance to answer the charge against him. This commitment, therefore, being only for safe custody, wherever bail will answer the same intention, it ought to be taken, as in most cases of the inferior crimes. But in felonies and other offenses of a capital nature, no bail can be a security equivalent to the actual custody of the person. For what is there that a man may not be induced to forfeit to save his own life? And what satisfaction or indemnity is it to the public to seize the effects of them who have bailed a murderer, if the murderer himself be suffered to escape with impunity? Upon a principle similar to which the Athenian magistrates, when they took a solemn oath never to keep a citizen in bonds that could give 3 sureties of the same quality with himself, did it with an exception to such as had embezzled the public money or been guilty of treasonable practices. What the nature of bail is hath been shown in the preceding book, viz., a delivery or bailment of a person to his sureties upon their giving, together with himself, sufficient security for his appearance, he being supposed to continue in their friendly custody instead of going to jail. In civil cases, we have seen that every defendant is bailable, but in criminal matters it is otherwise. Let us therefore inquire in what cases the party accused ought or ought not to be admitted to bail. And first, to refuse or delay to bail any person bailable is an offense against the liberty of the subject in any magistrate by the common law, as well as by the statute Westminster 1, 3, Edward I, c. 15, and the Habeas Corpus Act 31, Charles II, c. 2. Unless the intention of the law should be frustrated by the justices requiring bail to a greater amount than the nature of the case demands, it is expressly declared by Statute 1, William and Mary, St. 2, c. 1, that excessive bail ought not to be required, though what bail shall be called excessive must be left to the courts on considering the circumstances of the case to determine. And on the other hand, if the magistrate takes insufficient bail, he is liable to be fined if the criminal doth not appear. Bail may be taken in either court or in some particular cases by the sheriff, coroner, or other magistrate, but most usually by the justices of the peace. Regularly, in all offenses either against the common law or act of Parliament that are below felony, the offender ought to be admitted to bail unless it be prohibited by some special act of Parliament. In order, therefore, to more precisely ascertain what offenses are bailable, let us next see who may not be admitted to bail or what offenses are not bailable. And here I shall not consider any one of those cases in which bail is ousted by statute from prisoners convicted of particular offenses, for then such imprisonment without bail is part of their sentence and punishment. But where the imprisonment is only for safe custody before conviction and not for punishment afterwards, in such cases bail is ousted or taken away wherever the offense is of a very enormous nature. For then the public is entitled to demand nothing less than the highest security that can be given, viz., the body of the accused, in order to ensure that justice shall be done upon him if guilty. Such persons, therefore, as the author of the Mirror observes, have no other sureties but the four walls of the prison. By the ancient common law, before and since the conquest, all felonies were bailable till murder was accepted by statute, so that persons might be admitted to bail before conviction almost in every case. But the Statute Westminster 1, 3, Edward I, c. 15, takes away the power of bailing in treason and in divers instances of felony. The Statute 1 and 2, Philip and Mary, c. 13, gives farther regulations in this manner, and upon the whole we may collect that no justices of the peace can bail, 1. Upon an accusation of treason, nor 2. Of murder, nor 3. In case of manslaughter, if the prisoner be clearly the slayer and not barely suspected to be so, or if any incitement be found against him, nor 4. Such as, being committed for felony, have broken prison, because it not only carries a presumption of guilt, but is also superadding one felony to another. 5. Persons outlawed. 6. Such as have abjured the realm. 7. Approvers of whom we shall speak in a subsequent chapter, and persons by them accused. 8. Persons taken with the manner or in the fact of felony. 9. Persons charged with arson. 10. Excommunicated persons taken by writ de excommunicato capiendo, all which are clearly not admissible to bail. Others are of a dubious nature, as 11. Thieves openly defamed and known. 12. Persons charged with other felonies or manifest and enormous offenses not being of good fame. And 13. Accessories to felony that labor under the same want of reputation. These seem to be in the discretion of the justices whether bailable or not. The last class are such as must be bailed upon offering sufficient surety, as 14. Persons of good fame charged with a bare suspicion of manslaughter or other inferior homicide. 15. Such persons being charged with petite larceny or any felony not before specified. Or 16. With being accessory to any felony. Lastly, it is agreed that the Court of King's Bench, or any judge thereof in time of vacation, may bail for any crime whatsoever, be it treason, murder, or any other offense, according to the circumstances of the case. And herein the wisdom of the law is very manifest. To allow bail to be taken commonly for such enormous crimes would greatly tend to elude the public justice. And yet there are cases, though they rarely happen, in which it would be hard and unjust to confine a man in prison, though accused even of the greatest offense. The law has therefore provided one court, and only one, which has a discretionary power of bailing in any case, except only even to this high jurisdiction, and of course to all inferior ones, such persons as are committed by either House of Parliament so long as the session lasts, or such as are committed for contempts by any of the King's superior courts of justice. Upon the whole, if the offense be not bailable, or the party cannot find bail, he is to be committed to the county jail by the mittimus of justice, or warrant under his hand and seal, containing the cause of his commitment, there to abide till delivered by due course of law. But this imprisonment, as has been said, is only for safe custody and not for punishment. Therefore, in this dubious interval between commitment and trial, a prisoner ought to be used with the utmost humanity, and neither be loaded with needless fetters or subjected to other hardships than such as are absolutely requisite for the purpose of confinement only. Though what are so requisite must too often be left to the discretion of the jailers, who are frequently a merciless race of men, and by being conversant in scenes of misery, steeled against any tender sensation. Yet the law will not justify them in fettering a prisoner unless where he is unruly or has attempted an escape, this being the humane language of our ancient lawgivers. Custodes poenam sibi commissorium non augent, nec eos torquent, sed omnis aevitia remota, fiatetque habita, judicia debete ex quantor. End of chapter the 22nd. Chapter 23, Part 1 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 23rd of the Several Modes of Prosecution, Part 1. The next step towards the punishment of offenders is their prosecution, or the manner of their formal accusation, and this is either upon a previous finding of the fact by an inquest or grand jury, or without such previous finding. The former way is either by presentment or indictment. 1. A presentment, generally taken, is a very comprehensive term, including not only presentments properly so called, but also inquisitions of office and indictments by a grand jury. A presentment, properly speaking, is the notice taken by a grand jury of any offense from their own knowledge or observation, without any bill of indictment laid before them at the suit of the king, as the presentment of a nuisance, a libel, and the like, upon which the officer of the court must afterwards frame an indictment before the party presented as the author can be put to answer it. An inquisition of office is the act of a jury summoned by the proper officer to inquire of matters relating to the crown upon evidence laid before them. Some of these are in themselves convictions and cannot afterwards be traversed or denied, and therefore the inquest or jury ought to hear all that can be alleged on both sides. Of this nature are all inquisitions of felo de se, of flight in persons accused of felony, of deodans and the like, and presentments of petty offenses in the sheriff's tourn or court leet, whereupon the presiding officer may set a fine. Other inquisitions may be afterwards traversed and examined, as particularly the coroner's inquisition of the death of a man when it finds anyone guilty of homicide, for in such cases the offender so presented must be arraigned upon this inquisition and may dispute the truth of it, which brings it to a kind of indictment, the most usual and effectual means of prosecution, and into which we will therefore inquire a little more minutely. 2. An indictment is a written accusation of one or more persons of a crime or misdemeanor preferred to and presented upon oath by a grand jury. To this end, the sheriff of every county is bound to return to every session of the peace and every commission of oyer interminer and of general jail delivery 24 good and lawful men of the county, some out of every 100, to inquire, present, do, and execute all those things which on the part of our lord the king shall then and there be commanded them. They ought to be freeholders, but to what amount is uncertain, which seems to be a causus omissus, and as proper to be supplied by the legislature as the qualifications of the petit jury, which were formerly equally vague and uncertain, but are now settled by several acts of Parliament. However, they are usually gentlemen of the best figure in the county. As many as appear on this panel are sworn upon the grand jury to the amount of 12 at the least, and not more than 23, that 12 may be a majority, which number, as well as the Constitution itself, we find exactly described so early as the laws of King Ethelred. Exiant Signores duodecim tani, et praefectes cum ies, et jurant super sanctuarium quod ies in manus dator, quod nullint ullum innocentem accusare, nec aliquem noxiam celare. In the time of King Richard I, according to Hoveden, the process of electing the grand jury ordained by that prince was as follows. 4 knights were to be taken from the county at large, who chose 2 more out of every 100, which 2 associated to themselves 10 other principal freemen, and those 12 were to answer concerning all particulars relating to their own district. This number was probably found too large and inconvenient, but the traces of this institution still remain in that some of the jury must be summoned out of every 100. This grand jury are previously instructed in the articles of their inquiry by a charge from the judge who presides upon the bench. They then withdraw to sit and receive indictments which are preferred to them in the name of the king, but at the suit of any private prosecutor. And they are only to hear evidence on behalf of the prosecution, for the finding of an indictment is only in the nature of an inquiry or accusation which is afterwards to be tried and determined, and the grand jury are only to inquire upon their oaths whether there be sufficient cause to call upon the party to answer it. A grand jury, however, ought to be thoroughly persuaded of the truth of an indictment so far as their evidence goes, and not to rest satisfied merely with remote probabilities, a doctrine that might be applied to very oppressive purposes. The grand jury are sworn to inquire only for the body of the county pro corpore comitatus, and therefore they cannot regularly inquire of a fact done out of that county for which they are sworn, unless particularly enabled by Act of Parliament. And to so high a nicety was this matter anciently carried, that where a man was wounded in one county and died in another, the offender was at common law indictable in neither, because no complete act of felony was done in any one of them. But by statute 2 and 3 Edward VI, c. 24, he is now indictable in the county where the party died. And so in some other cases, as particularly where treason is committed out of the realm, it may be inquired of in any county within the realm as the king shall direct, in pursuance of statutes 26 Henry VIII, c. 13, 35 Henry VIII, c. 2, and 5 and 6 Edward VI, c. 11. But in general, all offenses must be inquired into as well as tried in the county where the fact is committed. When the grand jury have heard the evidence, if they think it is a groundless accusation, they use formally to endorse on the back of the bill ignoramus, or we know nothing of it, intimating that though the facts might possibly be true, that truth did not appear to them. But now they assert in English more absolutely, not a true bill, and then the party is discharged without farther answer. But a fresh bill may afterwards be preferred to a subsequent grand jury. If they are satisfied of the truth of the accusation, then they endorse upon it a true bill, anciently billa vera. The indictment is then said to be found, and the party stands indicted. But to find a bill, there must at least 12 of the jury agree, for so tender is the law of England of the lives of the subjects, that no man can be convicted at the suit of the king of any capital offense, unless by the unanimous voice of 24 of his equals and neighbors, that is, by 12 at least of the grand jury in the first place assenting to the accusation, and afterwards by the whole petit jury of 12 more, finding him guilty upon his trial. But if 12 of the grand jury assent, it is a good presentment, though some of the rest disagree, and the indictment, when so found, is publicly delivered into court. Indictments must have a precise and sufficient certainty, By Statute 1 Henry V, c. 5, all indictments must set forth the Christian name, first name, and addition of the state and degree, mystery, town or place, and the county of the offender, and all this to identify his person. The time and place are also to be ascertained by naming the day and township in which the fact was committed, though a mistake in these points is in general not held to be material, provided the time be laid previous to the finding of the indictment and the place to be within the jurisdiction of the court. But sometimes the time may be very material where there is any limitation in point of time assigned for the prosecution of offenders, as by Statute 7 William III c. 3, which enacts that no prosecution shall be had for any of the treasons or misprisions therein mentioned, except an assassination designed or attempted on the person of the king, unless the bill of indictment be found within 3 years after the offense committed, and in case of murder, the time of the death must be laid within a year and a day after the mortal stroke was given. The offense itself must also be set forth with clearness and certainty, and in some crimes particular words of art must be used, which are so appropriated by the law to express the precise idea which it entertains of the offense, that no other words, however synonymous they may seem, are capable of doing it. Thus, in treason, the facts must be laid to be done treasonably and against his allegiance, anciently prodiatore et contra legiante sue debitum, else the indictment is void. In indictments for murder, it is necessary to say that the party indicted murdered, not killed or slew the other, which till the late statute was expressed in Latin by the word murdravit. In all indictments for felonies, the adverb feloniously, felonice, must be used, and for burglaries also, burglariter, or in English, burglariously, and all these to ascertain the intent. In rapes, the word rapuit or ravished is necessary and must not be expressed by any periphrasis in order to render the crime certain. So in larcenies also, the words felonais cepit et asportavit, feloniously took and carried away, are necessary to every indictment, for these only can express the very offense. Also in indictments for murder, the length and depth of the wound should in general be expressed in order that it may appear to the court to have been of a mortal nature. But if it goes through the body, then its dimensions are immaterial, for that is apparently sufficient to have been the cause of death. Also, where a limb or the like is absolutely cut off, there such description is impossible. Lastly, in indictments, the value of the thing, which is the subject or instrument of the offense, must sometimes be expressed. In indictments for larcenies, this is necessary that it may appear whether it be grand or petite larceny, and whether entitled or not to the benefit of clergy. In homicide of all sorts it is necessary, as the weapon with which it is committed is forfeited to the king as a deodand. The remaining methods of prosecution are without any previous finding by a jury to fix the authoritative stamp of verisimilitude upon the accusation. One of these, by the common law, was when a thief was taken with the maner, that is, with the thing stolen upon him, in manu. For he might, when so detected, flagrante delicto, be brought into court, arraigned and tried without indictment, as by the Danish law he might be taken and hanged upon the spot without accusation or trial. But this proceeding was taken away by several statutes in the reign of Edward III, though in Scotland a similar process remains to this day. So that the only species of proceeding at the suit of the king without a previous indictment or presentment by a grand jury now seems to be that of information. 3. Informations are of two sorts. First, those which are partly at the suit of the king and partly at that of a subject, and secondly, such as are only in the name of the king. The former are usually brought upon penal statutes which inflict a penalty upon conviction of the offender, one part to the use of the king and another to the use of the informer, and are of a sort of qui tam actions, the nature of which was explained in a former volume, only carried on by a criminal instead of a civil process, upon which I shall therefore only observe that by the statute 31 Elizabeth c. 5, no prosecution upon any penal statute, the suit and the benefit whereof are limited in part to the king and in part to the prosecutor, can be brought by any common informer after 1 year is expired since the commission of the offense, nor on behalf of the crown after the lapse of 2 years longer, nor where the forfeiture is originally given only to the king can such prosecution be had after the expiration of 2 years from the commission of the offense. The informations that are exhibited in the name of the king alone are also of two kinds. First, those which are truly and properly his own suits and filed ex officio by his own immediate officer, the Attorney General. Secondly, those in which, though the king is the nominal prosecutor, yet it is at the relation of some private person or common informer, and they are filed by the king's coroner and attorney in the Court of King's Bench, usually called the Master of the Crown Office, who is for this purpose the standing officer of the public. The objects of the king's own prosecutions, filed ex officio by his own attorney general, are properly such enormous misdemeanors as particularly tend to disturb or endanger his government, or to molest or affront him in the regular discharge of his royal functions. For offenses so high and dangerous, in the punishment or prevention of which a moment's delay would be fatal, the law has given to the Crown the power of an immediate prosecution without waiting for any previous application to any other tribunal, a power so necessary not only to the ease and safety but even to the very existence of the executive magistrate, was originally reserved in the great plan of the English Constitution, which has wisely provided for the due preservation of all its parts. The objects of the other species of informations filed by the Master of the Crown Office upon the complaint or relation of a private subject are any gross and notorious misdemeanors, riots, batteries, libels, and other immoralities of an atrocious kind, not peculiarly tending to disturb the government, for those are left to the care of the Attorney General, but which, on account of their magnitude or pernicious example, deserve the most public animadversion. And when an information is filed either thus or by the Attorney General ex officio, it must be tried by a petit jury of the county where the offense arises, after which, if the defendant be found guilty, he must resort to the court for his punishment. There can be no doubt but this mode of prosecution by information or suggestion, filed on record by the King's Attorney General or by his coroner or Master of the Crown Office in the Court of King's Bench, is as ancient as the common law itself. For as the king was bound to prosecute, or at least to lend the sanction of his name to a prosecutor, whenever a grand jury informed him upon their oaths that there was a sufficient ground for instituting a criminal suit, so, when these his immediate officers were otherwise sufficiently assured that a man had committed a gross misdemeanor, either personally against the king or his government, or against the public peace and good order, they were at liberty, without waiting for any further intelligence, to convey that information to the Court of King's Bench by a suggestion on record, and to carry on the prosecution in His Majesty's name. But these informations of every kind are confined by the constitutional law to mere misdemeanors only. For wherever any capital offense is charged, the same law requires that the accusation be warranted by the oath of 12 men before the party shall be put to answer it. And as to those offenses in which informations were allowed as well as indictments, so long as they were confined to his high and respectable jurisdiction, and were carried on in a legal and regular course in His Majesty's Court of King's Bench, the subject had no reason to complain. The same notice was given, the same process was issued, the same pleas were allowed, the same trial by jury was had, the same judgment was given by the same judges as if the prosecution had originally been by indictment. But when the Statute 3, Henry VII, c. 1, had extended the jurisdiction of the Court of Star Chamber, the members of which were the sole judges of the law, the fact, and the penalty, and when the Statute 11, Henry VII, c. 3, had permitted informations to be brought by any informer upon any penal statute not extending to life or member at the assizes or before the justices of the peace who were to hear and determine the same according to their own discretion, then it was that the legal and orderly jurisdiction of the Court of King's Bench fell into disuse and oblivion, and Empson and Dudley, the wicked instruments of King Henry VII, by hunting out obsolete penalties and this tyrannical mode of prosecution with other oppressive devices, continually harassed the subject and shamefully enriched the crown. The latter of these acts was soon indeed repealed by Statute 1, Henry VII, c. 6, but the Court of Star Chamber continued in high vigor and daily increasing its authority for more than a century longer, till finally abolished by Statute 16, Charles I, c. 10. Upon this dissolution, the old common law authority of the Court of King's Bench as the custos morum of the nation being found necessary to reside somewhere for the peace and good government of the kingdom was again revived in practice. And it is observable that in the same Act of Parliament which abolished the Court of Star Chamber, a conviction by information is expressly reckoned up as one of the legal modes of conviction of such persons as should offend a third time against the provisions of that statute. It is true, Sir Matthew Hale, who presided in this court soon after the time of such revival, is said to have been no friend of this method of prosecution, and, if so, the reason of such his dislike was probably the ill use which the Master of the Crown Office then made of his authority by permitting the subject to be harassed with vexatious informations whenever applied to by any malicious or revengeful prosecutor, rather than his doubt of their legality or propriety upon urgent occasions. For the power of filing informations without any control then resided in the breast of the master, and being filed in the name of the king, they subjected the prosecutor to no costs, though on trial they proved to be groundless. This oppressive use of them in the times preceding the Revolution occasioned a struggle soon after the accession of King William to procure a declaration of their illegality by the judgment of the Court of King's Bench. But Sir John Holt, who then presided there, and all the judges were clearly of opinion that this proceeding was grounded on the common law and could not be then impeached. And in a few years afterwards a more temperate remedy was applied in Parliament by Statute 4 and 5, William and Mary, c. 18, which enacts that the Clerk of the Crown shall not file any information without express direction from the Court of King's Bench, and that every prosecutor permitted to promote such information shall give security by a recognizance of £20, which now seems to be too small a sum, to prosecute the same with effect, and to pay costs to the defendant in case he be acquitted thereon, unless the judge who tries the information shall certify there was reasonable cause for filing it, and at all events to pay costs unless the information shall be tried within a year after issue joined. But there is a proviso in this act that it shall not extend to any other informations than those which are exhibited by the Master of the Crown Office, and consequently informations at the King's own suit filed by his Attorney General are no way restrained thereby. There is one species of information still farther regulated by Statute 9 and c. 20, viz., those in the nature of a writ of quo warranto, which was shown in the preceding volume to be a remedy given to the Crown against such as had usurped or intruded into any office or franchise. The modern information tends to the same purpose as the ancient writ, being generally made use of to try the civil rights of such franchises. though it is commenced in the same manner as the other informations are, by leave of the court or at the will of the Attorney General, being properly a criminal prosecution in order to find the defendant for his usurpation as well as to oust him from his office, yet usually considered at present as merely a civil proceeding. These are all the methods of prosecution at the suit of the king. There yet remains another, which is merely at the suit of the subject and is called an appeal. End of chapter the 23rd, part 1. Chapter 23, part 2 of the Commentaries on the Laws of England, book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 23rd of the Several Modes of Prosecution, Part 2. 4. An appeal, in the sense wherein it is here used, does not signify any complaint to a superior court of an injustice done by an inferior one, which is the general use of the word, but here it means an original suit at the time of its first commencement. An appeal, therefore, when spoken of as a criminal prosecution, denotes an accusation by a private subject against another for some heinous crime, demanding punishment on account of the particular injury suffered rather than for the offense against the public. As this method of prosecution is still in force, I cannot omit to mention it. But as it is very little in use, on account of the great nicety required in conducting it, I shall treat of it very briefly, referring the student for more particulars to other voluminous compilations. This private process for the punishment of public crimes had probably its original in those times when a private pecuniary satisfaction, called a weirgeld, was constantly paid to the party injured or his relations to expiate enormous offenses. This was a custom derived to us in common with other northern nations from our ancestors the ancient Germans, among whom, according to Tacitus, Luitor amacidum certo armorentorum ac pecorum numero, recepitque satisfactionem universa domus. In the same manner, by the Irish Brehon law, in case of murder, the Brehon or judge was used to compound between the murderer and the friends of the deceased who prosecuted him, by causing the malefactor to give unto them or to the child or wife of him that was slain a recompense for which they called an eriac. And thus we find in our Saxon laws, particularly those of King Athelstan, the several wereguilds for homicide established in progressive order from the death of the ceorl or peasant up to that of the king himself. And in the laws of King Henry I we have an account of what other offenses were then redeemable by weregild and what were not so. As therefore during the continuance of this custom a process was certainly given for recovering the weregild by the party to whom it was due, it seems that when these offenses by degrees grew no longer redeemable, the private process was still continued in order to ensure the infliction of punishment upon the offender, though the party injured was allowed no pecuniary compensation for the offense. But though appeals were thus in the nature of prosecutions for some atrocious injury committed more immediately against an individual, yet it also was anciently permitted that any subject might appeal another subject of high treason either in the courts of common law or in Parliament, or, for treasons committed beyond the seas, in the court of the High Constable and Marshal. The cognizance of appeals in the latter still continues in force, and so late as 1631 there was a trial by battle awarded in the court of chivalry upon such an appeal of treason, but the first was virtually abolished by the statutes 5 Edward III c. 9 and 25 Edward III c. 24, and the second expressly by statute 1 Henry IV c. 14. So that the only appeals now in force for things done within the realm are appeals of felony and mayhem. An appeal of felony may be brought for crimes committed either against the parties themselves or their relations. The crimes against the parties themselves are larceny, rape, and arson. And for these, as well as for mayhem, the persons robbed, ravished, maimed, or whose houses are burnt may institute this private process. The only crime against one's relation for which an appeal can be brought is that of killing him either by murder or manslaughter. But this cannot be brought by every relation, but only by the wife for the death of her husband, or by the heir male for the death of his ancestor, which heirship was also confined by an ordinance of King Henry I to the 4 nearest degrees of blood. It is given to the wife on account of the loss of her husband. Therefore, if she marries again before or pending her appeal, it is lost and gone. Or, if she marries after judgment, she shall not demand execution. The heir, as was said, must also be heir male, and such a one as was the next heir by the course of the common law at the time of the killing of the ancestor. But this rule has 3 exceptions. 1. If the person killed leaves an innocent wife, she only, not the heir, shall have the appeal. 2. If there be no wife, and the heir be accused of the murder, the person who next to him would have been heir male shall bring the appeal. 3. If the wife kills her husband, the heir may appeal her of the death. And by the statute of Gloucester, 6 Edward I, c. 9, all appeals of death must be sued within a year and a day after the completion of the felony by the death of the party, which seems to be only declaratory of the old common law, for in the Gothic constitutions we find the same praescriptio annalis, quae currit adversus actorem, si de homicida ea non constet intra annum accaede facta, nequenquam interia arguat et accuset. These appeals may be brought previous to any indictment, and if the appellee be acquitted thereon, he cannot be afterwards indicted for the same offense. In like manner as by the old Gothic constitution, if any offender gained a verdict in his favor when prosecuted by the party injured, he was also understood to be acquitted of any crown prosecution for the same offense. But on the contrary, if he made his peace with the king, still he might be prosecuted at the suit of the party. And so, with us, if a man be acquitted on an indictment of murder, or found guilty and pardoned by the king, still he may, by virtue of statute 3 Henry VII, c. 1, be prosecuted by appeal for the same felony, not having as yet been punished for it. Though if he hath been found guilty of manslaughter on an indictment, and hath had the benefit of clergy, and suffered the judgment of the law, he cannot afterwards be appealed. For it is a maxim of the law that nemo bis puintur pro eodem delecto. If the appellee be found guilty, he shall suffer the same judgment as if he had been convicted by indictment, but with this remarkable difference, that on an indictment which is at the suit of the king may pardon and remit the execution. On an appeal which is at the suit of a private subject to make an atonement for the private wrong, the king can no more pardon it than he can remit the damages recovered on an action of battery. In like manner as, while the weir guild continued to be paid as a fine for homicide, it could not be remitted by the king's authority. And the ancient usage was, so late as Henry IV's time, that all the relations of the slain should drag the appellee to the place of execution, a custom founded on that savage spirit of family resentment which prevailed universally throughout Europe after the irruption of the northern nations, and is peculiarly attended to in their several codes of law, and which prevails even now among the wild and untutored inhabitants of America, as if the finger of nature had pointed it out to mankind in their rude and uncultivated state. However, the punishment of the offender may be remitted and discharged by the concurrence of all parties interested, and as the king by his pardon may frustrate an indictment, so the appellant by his release may discharge an appeal, Nam quilibet potest renunciare iure pro se introducto. These are the several methods of prosecution instituted by the laws of England for the punishment of offences, of which that by indictment is the most general. I shall therefore confine my subsequent observations principally to this method of prosecution, remarking by the way the most material variations that may arise from the method of proceeding by either information or appeal. End of chapter the 23rd, part 2. Chapter 24 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 24th of Process upon an Indictment. We are next in the fourth place to inquire into the manner of issuing process after indictment found to bring in the accused to answer it. We have hitherto supposed the offender to be in custody before the finding of the indictment, in which case he is immediately to be arraigned thereon. But if he hath fled or secretes himself in capital cases, or hath not in smaller misdemeanors been bound over to appear at the assizes or sessions, still an indictment may be preferred against him in his absence, since, were he present, he could not be heard before the grand jury against it. And if it be found, then process must issue to bring him into court, for the indictment cannot be tried unless he personally appears, according to the rules of equity in all and the express provision of Statute 28 Edward III C3 in capital cases, that no man shall be put to death without being brought to answer by due process of law. The proper process on an indictment for any petty misdemeanor or on a penal statute is a writ of venere facias, which is in the nature of a summons to cause the party to appear. And if by the return to such venere it appears that the party hath lands in the county whereby he may be distrained, then a distress infinite shall be issued from time to time till he appears. But if the sheriff returns that he hath no lands in his bailiwick, then, upon his non-appearance, a writ of coppice shall issue, which commands the sheriff to take his body and have him at the next assizes, and if he cannot be taken upon the first coppice, a second and a third shall issue, called an alias and a pluris coppice. But on indictments for treason or felony, a coppice is the first process, and for treason or homicide only one shall be allowed to issue, or two in the case of other felonies by Statute 25 Edward III C14, though the usage is to issue only one in any felony, the provisions of this statute being in most cases found impracticable. And so, in the case of misdemeanors, it is now the usual practice for any judge of the Court of King's Bench, upon certificate of an indictment found, to award a writ of coppice immediately in order to bring in the defendant. But if he absconds, and it is thought proper to pursue him to an outlawry, then a greater exactness is necessary. For in such case, after the several writs have issued in a regular number according to the nature of the respective crimes without any effect, the offender shall be put in the exigent in order to his outlawry. That is, he shall be exacted, proclaimed, or required to surrender at 5 county courts, and if he be returned quinto exactus, and does not appear at the 5th exaction or requisition, then he is adjudged to be outlawed or put out of the protection of the law, so that he is incapable of taking the benefit of it in any respect, either by bringing actions or otherwise. The punishment for outlawries upon indictments for misdemeanors is the same as for outlawries upon civil actions, of which, and the previous process by writs of coppice, exegi facias, and proclamation, we spoke in the preceding book, viz., forfeiture of goods and chattels. But an outlawry in treason or felony amounts to a conviction and attainder of the offense charged in the indictment as much as if the offender had been found guilty by his country. His life is, however, still under the protection of the law, as hath formerly been observed, and though anciently an outlawed felon was said to have caput lapidem, and might be knocked on the head like a wolf by any one that should meet him, because having renounced all law he was to be dealt with as in a state of nature when every one that should find him might slay him, yet now, to avoid such inhumanity, it is holden that no man is entitled to kill him wantonly or wilfully, but in so doing is guilty of murder, unless it happens in the endeavor to apprehend him. For any person may arrest an outlaw on a criminal prosecution either of his own head, or by writ or warrant of capias ut legatum, in order to bring him to execution. But such outlawry may be frequently reversed by writ of error, the proceedings therein being, as it is fit they should be, exceedingly nice and circumstantial, and if any single minute point be omitted or misconducted, the whole outlawry is illegal and may be reversed, upon which reversal the party accused is admitted to plead to and defend himself against the indictment. Thus much for process to bring in the offender after indictment found, during which stage of the prosecution it is that writs of certiorari facias are usually had, though they may be had at any time before trial, to certify and remove the indictment with all the proceedings thereon from any inferior court of criminal jurisdiction into the court of King's Bench, which is the sovereign ordinary court of justice in causes criminal. And this is frequently done for one of these four purposes, either 1. To consider and determine the validity of appeals or indictments and the proceedings thereon, and to quash or confirm them as there is cause, or 2. Where it is surmised that a partial or insufficient trial will probably be had in the court below, the indictment is removed in order to have the prisoner or defendant tried at the bar of the court of King's Bench or before the justices of Nisi Prius. Or 3. It is so removed in order to plead the king's pardon there. Or 4. To issue process of outlawry against the offender in those counties or places where the process of the inferior judges will not reach him. Such writ of certiorari, when issued and delivered to the inferior court for removing any record or other proceeding, as well upon indictment as otherwise, supersedes the jurisdiction of such inferior court, and makes all subsequent proceedings therein entirely erroneous and illegal, unless the court of King's Bench remands the record to the court below to be there tried and determined. A certiorari may be granted at the instance of either the prosecutor or the defendant, the former as a matter of right, the latter as a matter of discretion, and therefore it is seldom granted to remove indictments from the justices of jail delivery, or after issue joined or confession of the fact in any of the courts below. At this stage of prosecution also it is that indictments found by the grand jury against the peer must in consequence of a writ of certiorari be certified and transmitted into the Court of Parliament or into that of the Lord High Steward of Great Britain, and that in places of exclusive jurisdiction, as the two universities, indictments must be delivered upon challenge and claim of cognizance to the courts therein established by charter and confirmed by Act of Parliament, to be there respectively tried and determined. End of chapter the 24th. Chapter 25 of the Commentaries on the Laws of England, Book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 25th of Arraignment and its Incidents. When the offender either appears voluntarily to an indictment or was before in custody or is brought in upon criminal process to answer it in the proper court, he is immediately to be arraigned thereon, which is the fifth stage of criminal prosecution. To arraign is nothing else but to call the prisoner to the bar of the court to answer the matter charged upon him in the indictment. The prisoner is to be called to the bar by his name, and it is laid down in our ancient books that though under an indictment of the highest nature, he must be brought to the bar without irons or any manner of shackles or bonds, unless there be evident danger of an escape, and then he may be secured with irons. But yet, in Layer's case, A.D. 1722, a difference was taken between the time of arraignment and the time of trial, and accordingly the prisoner stood at the bar in chains during the time of his arraignment. When he is brought to the bar, he is called upon by name to hold up his hand, which, though it may seem a trifling circumstance, yet is of this importance, that by holding up of his hand constat de persona, he owns himself to be of that name by which he is called. However, it is not an indispensable ceremony, for being calculated merely for the purpose of identifying the person, any other acknowledgment will answer the purpose as well. Therefore, if the prisoner obstinately and contemptuously refuses to hold up his hand, but confesses he is the person named, it is fully sufficient. Then the indictment is to be read to him distinctly in the English tongue, which was law even while all other proceedings were in Latin, that he may fully understand his charge. After which it is to be demanded of him whether he be guilty of the crime whereof he stands indicted, or not guilty. By the old common law, the accessory could not be arraigned till the principal was attainted, and therefore, if the principal had never been indicted at all, had stood mute, had challenged above 35 jurors peremptorily, had claimed the benefit of clergy, had obtained a pardon, or had died before attainder, the accessory in any of these cases could not be arraigned for non-consistent whether any felony was committed or no, till the principal was attainted. And it might so happen that the accessory should be convicted one day, and the principal acquitted the next, which would be absurd. However, this absurdity could only happen where it was possible that a trial by the principal might be had subsequent to that of the accessory, and therefore the law still continues that the accessory shall not be tried so long as the principal remains liable to be tried hereafter. But by statute 1 and C9, if the principal be once convicted and before attainder, that is, before he receives judgment of death or outlawry, he is delivered by pardon, the benefit of clergy, or otherwise, or if the principal stands mute or challenges peremptorily above the legal number of jurors so as never to be convicted at all. In any of these cases in which no subsequent trial can be had of the principal, the accessory may be proceeded against as if the principal felon had been attainted, for there is no danger of future contradiction. And upon the trial of the accessory, as well after as before the conviction of the principal, it seems to be the better opinion, and founded on the true spirit of justice, that the accessory is at liberty, if he can, to controvert the guilt of his supposed principal, and to prove him innocent of the charge, as well in point of fact as in point of law. When a criminal is arraigned, he either stands mute or confesses the fact, which circumstances we may call incidents to the arraignment, or else he pleads to the indictment, which is to be considered as the next stage of proceedings. But first, let us observe these incidents to the arraignment of standing mute or confession. 1. Regularly, a prisoner is said to stand mute when being arraigned for treason or felony, he either 1. Makes no answer at all, or 2. Answers foreign to the purpose or with such matter as is not allowable, and will not answer otherwise, or 3. Upon having pleaded not guilty, refuses to put himself upon the country. If he says nothing, the court ought, ex officio, to empanel a jury to inquire whether he stands obstinately mute, or whether he be dumb ex visatione Dei. If the latter appears to be the case, the judges of the court, who are to be of counsel for the prisoner, and to see that he hath law and justice, shall proceed to the trial and examine all points as if he had pleaded not guilty. But whether judgment of death can be given against such a prisoner who hath never pleaded, and can say nothing in arrest of judgment, is a point yet undetermined. If he be found to be obstinately mute, which a prisoner hath been held to be that cut out his own tongue, then, if it be on an indictment of high treason, it is clearly settled that standing mute is equivalent to a conviction, and he shall receive the same judgment and execution. And as in this the highest crime, so also in the lowest species of felony, viz., in petite larceny, and in all misdemeanors, standing mute is equivalent to conviction. But upon appeals or indictments for other felonies or petite treason, he shall not be looked upon as convicted so as to receive judgment for the felony, but shall for his obstinacy receive the terrible sentence of penance or peine forte dure. Before this is pronounced, the prisoner ought to have not only trina admonitio, but also a convenient respite of a few hours, and the sentence should be distinctly read to him that he may know his danger. And after all, if he continues obstinate, and his offense is clergyable, he shall have the benefit of his clergy allowed him, even though he is too stubborn to pray it. Thus tender has the modern law been of inflicting this dreadful punishment. But if no other means will prevail, and the prisoner, when charged with a capital felony, continues stubbornly mute, the judgment is then given against him without any distinction of sex or degree, a judgment which the law has purposely ordained to be exquisitely severe, that by that very means it might rarely be put in execution. The rack, or question to extort a confession from criminals, is a practice of a different nature, this being only used to compel a man to put himself upon his trial, that being a species of trial in itself. And the trial by rack is utterly unknown to the law of England, though once, when the Dukes of Exeter and Suffolk and other ministers of Henry VI had laid a design to introduce the civil law into this kingdom as the rule of government, for a beginning thereof they erected a rack for torture, which was called in derision the Duke of Exeter's daughter, and still remains in the Tower of London, where it was occasionally used as an engine of state, not of law, more than once in the reign of Queen Elizabeth. But when, upon the assassination of Villiers, Duke of Buckingham, by Felton, it was proposed in the Privy Council to put the assassin to the rack in order to discover his accomplices, the judges, being consulted, declared unanimously to their own honor and to the honor of the English law that no such proceeding was allowable by the laws of England. It seems astonishing that this usage of administering the torture should be said to arise from a tenderness to the lives of men, and yet this is the reason given for its introduction in the civil law and its subsequent adoption by the French and other foreign nations, viz., because the laws cannot endure that any man should die upon the evidence of a false or even a single witness, and therefore contrive this method that innocence should manifest itself by a stout denial or guilt by a plain confession, thus rating a man's virtue by the hardiness of his constitution and his guilt by the sensibility of his nerves. But there needs only to state accurately, in order most effectually to expose this inhuman species of mercy, the uncertainty of which, as a test and criterion of truth, was long ago very elegantly pointed out by Tully, though he lived in a state wherein it was usual to torture slaves in order to furnish evidence. Tamen, says he, illa tormenta gubernat dolor, moderator natura cujusque tum animi tum corporis, regit quaesitor, flectit libido, corrumptit spes, infirmit metus, ut in toti rerum angustatiis nihil veritati loci relinquator. The English judgment of penance for standing mute is as follows: that the prisoner shall be remanded to the prison from whence he came, and put into a low dark chamber, and there be laid on his back on the bare floor, naked, unless where decency forbids, that there be placed upon his body as great a weight of iron as he can bear, and more, that he shall have no sustenance, save only on the first day 3 morsels of the worst bread, and on the second day 3 draughts of standing water, that shall be nearest to the prison door. And in this situation this shall be alternately his daily diet till he dies, as the judgment now runs, though formerly it was till he answered. It hath been doubted whether this punishment subsisted at the common law, or was introduced in consequence of the statute Westminster 1, 3, Edward I, c. 12, which seems to be the better opinion. For not a word of it is mentioned in Glanville or Bracton, or in any ancient author, case, or record that hath yet been produced previous to the reign of Edward I. But there are instances on record in the reign of Henry III, where persons accused of felony and standing mute were tried in a particular manner by 2 successive juries and convicted, and it is asserted by the judges in 8 Henry IV that by the common law before the statute, standing mute on an appeal amounted to a conviction of the felony. This statute of Edward I directs such persons as will not put themselves upon the inquests of felonies before the judges at the suit of the king to be put into hard and strong prison, soit mis en la prison fort et dure, as those which refuse to be at the common law of the land. And immediately after this statute, the form of the judgment appears in Fleta and Britain to have been only a very straight confinement in prison, with hardly any degree of sustenance, but no weight is directed to be laid upon the body so as to hasten the death of the miserable sufferer, and indeed any surcharge of punishment on persons adjudged to penance so as to shorten their lives is reckoned by Horne in the Mirror as a species of criminal homicide, to which we may add that the record of 35 Edward I, cited by a learned author, most clearly proves that the prisoner might then possibly subsist for 40 days under this lingering punishment. I should therefore imagine that the practice of loading him with weights, or, as it is usually called, pressing him to death, was gradually introduced between the reign of Edward I and 8 Henry IV, when it first appears on our books, and was intended as a species of mercy to the delinquent by delivering him the sooner from his torment, and hence I presume it also was that the duration of the penance was then first altered, and instead of continuing till he answered, it was directed to continue till he died, which must very soon happen under an enormous pressure. The uncertainty of its original, the doubts that may be conceived of its legality, and the repugnance of its theory, for it rarely is carried into practice, to the humanity of the laws of England, all seem to require a legislative abolition of this cruel process, and a restitution of the ancient common law, whereby the standing mute in felony, as well as in treason and in trespass, amounted to a confession of the charge. Or, if the corruption of the blood and the consequent échec in felony were removed, the peine forte d'or might still remain as a monument of the savage rapacity with which the lordly tyrants of feudal antiquity hunted after échecs and forfeitures, but no man would ever be tempted to undergo such a horrid alternative. For the law is, that by standing mute and suffering this heavy penance, the judgment and of course the corruption of the blood and échec of the lands are saved in felony and petit treason, though not the forfeiture of the goods, and therefore this lingering punishment was probably introduced in order to extort a plea, without which it was held that no judgment of death could be given, and so the lord lost his échec. But notwithstanding these terrors, some hardy delinquents, conscious of their guilt and yet touched with a tender regard for their children, have rather chosen to submit to this painful death than the easier judgment upon conviction, which might expose their offspring not only to present want, but to future incapacities of inheritance. But in high treason, as standing mute is equivalent to a conviction, the same judgment, the same corruption of blood, and the same forfeitures attend it as in other cases of conviction. And thus much for the demeanor of a prisoner upon his arraignment by standing mute. 2. The other incident to arraignments, exclusive of the plea, is the prisoner's confession of the indictment. Upon a simple and plain confession, the court hath nothing to do but award judgment, but it is usually very backward in receiving and recording such confession out of tenderness to the life of the subject, and will generally advise the prisoner to retract it and plead to the indictment. But there is another species of confession which we read much of in our ancient books, of a far more complicated kind, which is called an approvement. And that is where a person indicted of treason or felony, and arraigned for the same, doth confess the fact before a plea pleaded, and appeals or accuses others, his accomplices, of the same crime in order to obtain his pardon. In this case he is called an approver or prover, probator, and the party appealed or accused is called the appellee. Such approvement can only be in capital offenses, and it is, as it were, equivalent to an indictment, since the appellee is equally called upon to answer it. And if he hath no reasonable and legal exceptions to make to the person of the approver, which indeed are very numerous, he must put himself upon his trial either by battle or by the country, and if vanquished or found guilty, must suffer the judgment of the law, and the approver shall have his pardon ex debito justitiae. On the other hand, if the appellee be conqueror, or acquitted by the jury, the approver shall receive judgment to be hanged upon his own confession of the indictment, for the condition of his pardon has failed, viz., the convicting of some other person, and therefore his conviction remains absolute. But it is purely in the discretion of the court to permit the approver to thus appeal or not. And in fact, this course of admitting approvements hath long been disused, for the truth was, as Sir Matthew Hale observes, that more mischief hath arisen to good men by these kinds of approvements upon false and malicious accusations of desperate villains, than benefit to the public by discovery and conviction of real offenders. And therefore, in the times when such appeals were more frequently admitted, great strictness and nicety were held therein, though since their discontinuance the doctrine of approvements is become a matter of more curiosity than use. I shall only observe that all the good, whatever it be, that can be expected from this method of approvement is fully provided for in the cases of robbery, burglary, housebreaking, and larceny, to the value of 5 shillings, from shops, warehouses, stables, and coach houses, by statutes 4 and 5 William and Mary c. 8, 10 and 11 William III c. 23, and 5 Anne c. 31, which enact that if any such felon, being out of prison, shall discover 2 or more persons who have committed the like felonies, so as they may be convicted thereof, he shall in most cases receive a ward of £40, and in general be entitled to a pardon of all capital offences, excepting only murder and treason. And if any such person, having feloniously stolen any lead, iron, or other metals, shall discover and convict 2 offenders of having illegally bought or received the same, he shall, by virtue of statute 29 George II c. 30, be pardoned for all such felonies committed before such discovery. End of chapter the 25th. Chapter 26 of the Commentaries on the Laws of England, Book the 4th of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 26th of Plea and Issue. We are now to consider the plea of the prisoner or defensive matter alleged by him on his arraignment if he does not confess or stand mute. This is either 1. A plea to the jurisdiction, 2. A demurrer, 3. A plea in abatement, 4. A special plea in bar, or 5. The general issue. Formerly there was another plea, now abrogated, that of sanctuary, which is however necessary to be lightly touched upon, as it may give some light to many parts of our ancient law, it being introduced and continued during the superstitious veneration that was paid to consecrated ground in the times of popery. First, then, it is to be observed that if a person accused of any crime, except treason, wherein the crown, and sacrilege, wherein the church was too nearly concerned, had fled to any church or churchyard, and within 40 days after went in sackcloth and confessed himself guilty before the coroner, and declared all the particular circumstances of the offense, and thereupon took the oath in that case provided, viz., that he abjured the realm, and would depart from thence forthwith at the port that should be assigned him, and would never return without leave from the king, he by this means saved his life, if he observed the conditions of the oath, by going with a cross in his hand, with all convenient speed, to the port assigned, and embarking. For if during this 40 days' privilege of sanctuary, or in his road to the seaside, he was apprehended and arraigned in any court for this felony, he might plead the privilege of sanctuary, and had a right to be remanded if taken out against his will. But by this abjuration his blood was attainted, and he forfeited all his goods and chattels. The immunity of these privileged places was very much abridged by the statutes 27 Henry VIII c. 19 and 32 Henry VIII c. 12, and now by the statute 21 James I c. 28, all privilege of sanctuary and abjuration consequent thereupon is utterly taken away and abolished. Formerly also the benefit of clergy used to be pleaded before trial or conviction, and was called a declinatory plea, which was the name also given to that of sanctuary. But as the prisoner upon a trial has a chance to be acquitted and totally discharged, and if convicted of a clergyable felony is entitled equally to his clergy after as before conviction, this course is extremely disadvantageous, and therefore the benefit of clergy is now very rarely pleaded, but if found requisite is prayed by the convict before judgment is passed upon him. I proceed therefore to the 5 species of pleas before mentioned. 1. A plea to the jurisdiction is where an indictment is taken before a court that hath no cognizance of the offense, as if a man be indicted for a rape at the sheriff's torn, or for treason at the quarter sessions. In these or similar cases he may accept to the jurisdiction of the court without answering at all to the crime alleged. 2. A demurrer to the indictment. This is incident to criminal cases as well as civil, when the fact as alleged is allowed to be true, but the prisoner joins issue upon some point of law in the indictment by which he insists that the fact as stated is no felony, treason, or whatever the crime is alleged to be. Thus, for instance, if a man be indicted for feloniously stealing a greyhound, which is an animal in which no valuable property can be had, and therefore it is not felony, but only a civil trespass to steal it, in this case the party indicted may demur to the indictment, denying it to be felony, though he confesses to the act of taking it. Some have held that if on demurrer the point of law be judged against the prisoner, he shall have judgment and execution as if convicted by verdict. But this is denied by others who hold that in such case he shall be directed and receive to plead the general issue not guilty after a demurrer determined against him, which appears the more reasonable because it is clear that if the prisoner freely discovers the fact in court and refers it to the opinion of the court, whether it be felony or no, and upon the fact thus shown it appears to be felony, the court will not record the confession, but admit him afterwards to plead not guilty. And this seems to be the case of the same nature, being for the most part a mistake in point of law and in the conduct of his pleading, and though a man by mispleading may in some cases lose his property, yet the law will not suffer him by such niceties to lose his life. However, upon this doubt, demurrers to indictments are seldom used, since the same advantages may be taken upon a plea of not guilty, or afterwards in arrest of judgment when the verdict has established the fact. 3. A plea in abatement is principally for a misnomer, a wrong name, or a false addition to the prisoner, as if James Allen, gentleman, is indicted by the name John Allen, Esquire, he may plead that he has the name of James and not John, and that he is a gentleman and not an esquire. And if either fact is found by a jury, then the indictment shall be abated, as writs or declarations may be in civil actions, of which we spoke at large in the preceding volume. But in the end there is little advantage accruing to the prisoner by means of these dilatory pleas, because if the exception be allowed, a new bill of indictment may be framed according to what the prisoner in his plea avers to be his true name and addition. For it is a rule upon all pleas in abatement that he who takes advantage of a flaw must at the same time show how it may be amended. Let us therefore next consider a more substantial kind of plea, viz. 4. Special pleas in bar, which go to the merits of the indictment and give a reason why the prisoner ought not to answer it at all, nor put himself upon his trial for the crime alleged. These are of 4 kinds: a former acquittal, a former conviction, a former attainder, or a pardon. There are many other pleas which may be pleaded in bar of an appeal, but these are applicable to both appeals and indictments. 1. First, the plea of autrefois acquit, or a former acquittal, is grounded on this universal maxim of the common law of England, that no man is to be brought into jeopardy of his life more than once for the same offense. And hence it is allowed as a consequence that when a man is once fairly found not guilty upon any indictment or other prosecution, he may plead such acquittal in bar of any subsequent accusation for the same crime. Therefore, an acquittal on an appeal is a good bar to an indictment of the same offense. And so also was an acquittal on an indictment a good bar to an appeal by the common law. And therefore, in favor of appeals, a general practice was introduced not to try any person on an indictment of homicide till after the year and a day within which appeals may be brought were passed, by which time it often happened that the witnesses died or the whole was forgotten. To remedy which inconvenience, the Statute 3 Henry VII c. 1 enacts that indictments shall be proceeded on immediately at the king's suit for the death of a man without waiting for bringing an appeal, and that the plea of autrefois acquit on an indictment shall be no bar to the prosecuting of any appeal. 2. Secondly, the plea of autrefois convict, or a former conviction for the same identical crime, though no judgment was ever given or perhaps will be, being suspended by the benefit of clergy or other causes, is a good plea in bar to an indictment. And this depends upon the same principle as the former, that no man ought to be twice brought in danger of his life for one and the same crime. Hereupon it has been held that a conviction of manslaughter on an appeal is a bar even in another appeal, and much more in an indictment of murder, for the fact prosecuted is the same in both, though the offenses differ in coloring and degree. It is to be observed that the pleas of autrefois acquit and autrefois convict, or a former acquittal and former conviction, must be upon a prosecution for the same identical act and crime. But the case is otherwise in 3. Thirdly, the plea of autrefois attaint, or a former attainder, which is a good plea in bar whether it be for the same or any other felony. For wherever a man is attainted of felony by judgment of death, either upon a verdict or confession, by outlawry, or heretofore by abjuration, and whether upon an appeal or an indictment, he may plead such attainder in bar to any subsequent indictment or appeal for the same or for any other felony. And this because generally such proceeding on a second prosecution cannot be to any purpose, for the prisoner is dead in law by the first attainder, his blood is already corrupted, and he hath forfeited all that he had, so that it is absurd and superfluous to endeavor to attaint him a second time. But to this general rule, however, as to all others, there are some exceptions, wherein cessante ratione cessat ipsa lex, as 1. Where the former attainder is reversed for error, for then it is the same as if it had never been. And the same reason holds where the attainder is reversed by Parliament, or the judgment vacated by the King's pardon with regard to felonies committed afterwards. 2. Where the attainder was upon indictment, such attainder is no bar to an appeal, for the prior sentence is pardonable by the king, and if that might be pleaded in bar of the appeal, the king might in the end defeat the suit of the subject by suffering the prior sentence to stop the prosecution of a second, and then, when the time of appealing is elapsed, granting the delinquent a pardon. 3. An attainder in felony is no bar to an indictment of treason, because not only the judgment and manner of death are different, but the forfeiture is much more extensive and the land goes to different persons. 4. Where a person attainted of one felony as robbery is afterwards indicted as principal in another as murder, to which there are also accessories prosecuted at the same time, in this case it is held that a plea of autrefois attaint is no bar, but he shall be compelled to take his trial for the sake of public justice, because the accessories to such second felony cannot be convicted till after the conviction of the principal. And from these instances we may collect that the plea of autrefois attaint is never good, but when a second trial would be quite superfluous. 4. Lastly, a pardon may be pleaded in bar as at once destroying the end and purpose of the indictment by remitting that punishment which the prosecution is calculated to inflict. There is one advantage that attends pleading a pardon in bar or arrest of judgment before sentence is passed, which gives it by much the preference to pleading it after the sentence or attainder. This is, that by stopping the judgment it stops the attainder and prevents the corruption of the blood, which, when once corrupted by attainder, cannot afterwards be restored otherwise than by act of Parliament. But as the title of pardons is applicable to other stages of prosecution, and they have their respective force and efficacy as well after as before conviction, outlawry, or attainder, I shall therefore reserve the more minute consideration of them till I have gone through every other title except only that of execution. Before I conclude this head of special pleas in bar, it will be necessary once more to observe that though in civil actions, when a man has his election what plea in bar to make, he is concluded by that plea, and cannot resort to another if that be determined against him, as if on an action of debt the defendant pleads a general release, and no such release can be proved, he cannot afterwards plead the general issue nil debet as he might at first, for he has made his election what plea to abide by, and it was his own folly to choose a rotten defense. Though I say this strictness is observed in civil actions, quia interes publicae ut sit finis litium, yet in criminal prosecutions, in favorem vitae, as well upon appeal as indictment, when a prisoner's plea in bar is found against him upon issue tried by a jury, or adjudged against him in point of law by the court, still he shall not be concluded or convicted thereon, but shall have judgment of respondeat uster, and may plead over to the felony the general issue not guilty. For the law allows many pleas by which a prisoner may escape death, but only one plea in consequence whereof it can be inflicted, viz., on the general issue, after an impartial examination and decision of the facts by the unanimous verdict of a jury. It remains, therefore, that I consider 5. The general issue, or plea of not guilty, upon which plea alone the prisoner can receive his final judgment of death. In case of an indictment of felony or treason, there can be no special justification put in by way of plea. As on an indictment for murder, a man cannot plead that it was his own defense against a robber on the highway or a burglar, but he must plead the general issue not guilty and give this special matter in evidence. For, besides that these pleas do in effect amount to the general issue, since, if true, the prisoner is most clearly not guilty, as the facts in treason are laid to be done prodetore et contra legentiae suae debitum, and in felony that the killing was done felonice. These charges of a traitorous or felonious intent are the points and very gist of the indictment, and must be answered directly by the general negative, not guilty, and the jury upon the evidence will take notice of any defensive matter, and give their verdict accordingly as effectually as if it were or could be specially pleaded. So that this is, upon all accounts, the most advantageous plea for the prisoner. When the prisoner hath thus pleaded not guilty, non culpabilis, or nient culpable, which was formerly used to be abbreviated upon the minutes thus, non or nient cul, the clerk of the assize or the clerk of the arraigns on behalf of the crown replies that the prisoner is guilty and that he is ready to prove him so. This is done by two monosyllables in the same spirit of abbreviation, cul prit, which signifies first that the prisoner is guilty, cul, culpable, culpabilis, and then that the king is ready to prove him so, prit, praesto sum, or paratus vericare. This is therefore a replication on behalf of the king viva voce at the bar, which was formerly the course in all pleadings as well in civil as in criminal causes. And that was done in the concisest manner, for when the pleader intended to demur, he expressed his demur in a single word, judgment, signifying that he demanded judgment whether the writ, declaration, plea, etc., either in form or matter, were sufficiently good in law. And if he meant to rest on the truth of the facts pleaded, he expressed that also in a single syllable, prit, signifying that he was ready to prove his assertions, as may be observed from the yearbooks and other ancient repositories of law. By this replication, the king and the prisoner are therefore at issue, for we may remember in our strictures upon pleadings in the preceding book, it was observed that when the parties came to a fact which is affirmed on one side and denied on the other, then they are said to be at issue in point of fact, which is evidently the case here in the plea of non-cul by the prisoner and the replication of cul by the clerk. And we may also remember that the usual conclusion of all affirmative pleadings, as this of cul or guilty is, was by an averment in these words, and this he is ready to verify, et hoc paratus est vericare, which same thing is here expressed by the single word prit. How our courts came to express a matter of this importance in so odd and obscure a manner, rem tantum tam negligenter, can hardly be pronounced with certainty. It may perhaps, however, be accounted for by supposing that there was at first short notes to help the memory of the clerk and remind him what he was to reply, or else it was the short method of taking down in court upon the minutes the replication and averment culprit, which afterwards the ignorance of succeeding clerks adopted for the very words to be by them spoken. But however it may have arisen, the joining of issue, which though now usually entered on the record, is not otherwise joined in any part of the proceedings, seems to be clearly the meaning of this obscure expression, which has puzzled our most ingenious etymologists, and is commonly understood as if the clerk of the arraigns, immediately on plea pleaded, had fixed an opprobrious name on the prisoner by asking him, Culprit, how wilt thou be tried? For immediately upon issue joined, it is inquired of the prisoner by what trial he will make his innocence appear. This form has at present reference to appeals and improvements only, wherein the appellee has his choice either to try the accusation by battle or by jury. But upon indictment, since the abolition of ordeal, there can be no other trial but that by jury, per pies, or by the country. And therefore, if the prisoner refuses to put himself upon the inquest in the usual form, that is, to answer that he will be tried by God and the country, if a commoner, and, if a peer, by God and his peers, the indictment, if in treason, is taken pro confesso, and the prisoner, in cases of felony, is adjudged to stand mute, and if he perseveres in his obstinacy, shall be condemned to the peine forte dure. When the prisoner has thus put himself upon his trial, the clerk answers in the humane language of the law, which always hopes that the party's innocence rather than his guilt may appear, God send thee a good deliverance. And then they proceed, as soon as conveniently may be, to the trial, the manner of which will be considered at large in the next chapter. End of chapter the 26th. Chapter 27, Part 1 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 27th of Trial and Conviction, Part 1. The several methods of trial and conviction of offenders established by the laws of England were formerly more numerous than at present through the superstition of our Saxon ancestors, who, like other northern nations, were extremely addicted to divination, a character which Tacitus observes in the ancient Germans. They therefore invented a considerable number of methods of purgation or trial to preserve innocence from the danger of false witnesses, and in consequence of a notion that God would always interpose miraculously to vindicate the guiltless. 1. The most ancient species of trial was that by ordeal, which was peculiarly distinguished by the appellation of Judicium Dei, and sometimes vulgaris purgatio, to distinguish it from the canonical purgation, which was by the oath of the party. This was of two sorts, either fire ordeal or water ordeal, the former being confined to persons of higher rank, the latter to the common people. Both these might be performed by deputy, but the principal was to answer for the success of the trial, the deputy only venturing some corporal pain for hire or perhaps for friendship. Fire ordeal was performed either by taking up in the hand, unhurt, a piece of red-hot iron of 1, 2, or 3 pounds weight, or else by walking barefoot and blindfold over 9 red-hot plowshares laid lengthwise at unequal distances. And if the party escaped being hurt, he was adjudged innocent. But if it happened otherwise, as without collusion it usually did, he was then condemned as guilty. However, by this latter method, Queen Emma, the mother of Edward the Confessor, is mentioned to have cleared her character when suspected of familiarity with Alwyn, Bishop of Winchester. Water ordeal was performed either by plunging the bare arm up to the elbow in boiling water and escaping unhurt thereby, or by casting the person suspected into a river or pond of cold water, and if he floated therein without any action of swimming, it was deemed an evidence of his guilt, but if he sunk, he was acquitted. It is easy to trace out the traditional relics of this water ordeal in the ignorant barbarity still practiced in many countries to discover witches by casting them into a pool of water and drowning them to prove their innocence. And in the Eastern Empire the fire ordeal was used to the same purpose by the Emperor Theodore Lascaris, who, attributing his sickness to magic, caused all those whom he suspected to handle the hot iron, thus joining, as has been well remarked, to the most dubious crime in the world, the most dubious proof of innocence. And indeed, this purgation by ordeal seems to have been very ancient and very universal in the times of superstitious barbarity. It was known to the ancient Greeks, for in the Antigone of Sophocles a person suspected by Creon of a misdemeanor declares himself ready to handle hot iron and to walk over fire, in order to manifest his innocence, which the Scholiast tells us was then a very usual purgation. And Grotius gives us many instances of water ordeal in Bithynia, Sardinia, and other places. There is also a very peculiar species of water ordeal said to prevail among the Indians on the coast of Malabar, where a person accused of any enormous crime is obliged to swim over a large river abounding with crocodiles, and if he escapes unhurt he is reputed innocent. As in Siam, besides the usual methods of fire and water ordeal, both parties are sometimes exposed to the fury of a tiger let loose for that purpose, and if the beast spares either, that person is accounted innocent; if neither, both are held to be guilty; but if he spares both, the trial is incomplete, and they proceed to a more certain criterion. One cannot but be astonished at the folly and impiety of pronouncing a man guilty unless he was cleared by a miracle, and of expecting that all the powers of nature should be suspended by an immediate interposition of Providence to save the innocent whenever it was presumptuously required. And yet in England, so late as King John's time, we find grants to the bishops and clergy to the use of judicium feri aquae et ignis, and both in England and Sweden the clergy presided at this trial, and it was only performed in the churches or in other consecrated ground, for which Sternhoek gives the reason. Non defuit illis apparae et laboris pretium, semper anum ab egismode judicio aliquid lucri sacerdotibus obveniabat. But to give it its due praise, we find the canon law very early declaring against trial by ordeal or vulgaris purgatio as being the fabric of the devil, cum sit contra praeceptum Domine, non tentibus dominum Deum tuum. Upon this authority, though the canons themselves were of no validity in England, it was thought proper, as had been done in Denmark above a century before, to disuse and abolish this trial entirely in our courts of justice by an Act of Parliament in 3 Henry III, according to Sir Edward Coke, or rather by an order of the King in Council. 2. Another species of purgation, somewhat similar to the former, but probably sprung from a presumptuous abuse of revelation in the ages of dark superstition, was the corsned, or morsel of execration, being a piece of cheese or bread about an ounce in weight, which was consecrated with a form of exorcism, desiring of the Almighty that it might cause convulsions and paleness and find no passage if the man was really guilty, but might turn to health and nourishment if he was innocent, as the water of jealousy among the Jews was, by God's especial appointment, to cause the belly to swell and the thigh to rot if the woman was guilty of adultery. This corsned was then given to the suspected person, who at the same time also received the Holy Sacrament, if indeed the corsned was not, as some have suspected, the sacramental bread itself, till the subsequent invention of transubstantiation preserved it from profane uses with a more profound respect than formerly. Our historians assure us that Godwin, Earl of Kent, in the reign of King Edward the Confessor, abjuring the death of the king's brother, at last appealed to his corsned, per bucellum deglutiendum abjuravit, which stuck in his throat and killed him. This custom has been long since gradually abolished, though the remembrance of it still subsists in certain phrases of abjuration retained among the common people. However, we cannot but remark that though in European countries this custom most probably arose from an abuse of revealed religion, yet credulity and superstition will, in all ages and in all climates, produce the same or similar effects, and therefore we shall not be surprised to find that in the kingdom of Pegu there still subsists a trial by the corsned, very similar to that of our ancestors, only subsisting raw rice instead of bread. And in the kingdom of Monomopata they have a method of deciding lawsuits equally whimsical and uncertain. The witness for the plaintiff chews the bark of a tree endued with an emetic quality, which being sufficiently masticated is then infused in water, which is given to the defendant to drink. If his stomach rejects it, he is condemned. If it stays with him, he is absolved, unless the plaintiff will drink some of the same water, and if it stays with him also, the suit is left undetermined. These two antiquated methods of trial were principally in use among our Saxon ancestors. The next, which still remains in force, though very rarely in use, owes its introduction among us to the princes of the Norman line, and that is 3. The trial by battle, duel, or single combat, which was another species of presumptuous appeals to Providence under an expectation that heaven would unquestionably give the victory to the innocent or injured party. The nature of this trial in cases of civil injury upon issue joined in a writ of right was fully discussed in the preceding book, to which I have only to add that the trial by battle may be demanded at the election of the appellee in either an appeal or an approvement, and that it is carried on with equal solemnity as that on a writ of right, but with this difference, that there each party might hire a champion, but here they must fight in their proper persons, and therefore if the appellant or approver be a woman, a priest, an infant, or of the age of 60, or lame or blind, he or she may counterplead and refuse the wager of battle, and compel the appellee to put himself upon the country. Also, peers of the realm bringing an appeal shall not be challenged to wage battle on account of the dignity of their persons, nor the citizens of London by special charter because fighting seems foreign to their education and employment. So likewise, if the crime be notorious, as if the thief be taken with the manor, or the murderer in the room with a bloody knife, the appellant may refuse the tender of battle from the appellee, for it is unreasonable that an innocent man should stake his life against one who is already half convicted. The form and manner of waging battle upon appeals are much the same as upon a writ of right, only the oaths of the two combatants are vastly more striking and solemn. The appellee, when appealed of felony, pleads not guilty and throws down his glove and declares he will defend the same by his body. The appellant takes up the glove and replies that he is ready to make good the appeal body for body. And thereupon the appellee, taking the book in his right hand and in his left the right hand of his antagonist, swears to this effect: Ac audi, homo, quem per manum teneo, etc. Hear this, O man whom I hold by the hand, who callest thyself John by the name of baptism, that I, who call myself Thomas by the name of baptism, did not feloniously murder thy father, William, by name, nor am I in any way guilty of the said felony. So help me God and the saints, and this I will defend against thee by my body, as this court shall award. To which the appellant replies, holding the Bible and his antagonist's hand in the same manner as the other, Hear this, O man whom I hold by the hand, who callest thyself Thomas by the name of baptism, that thou art perjured, and therefore perjured, because that thou feloniously didst murder my father William by name. So help me God and the saints, and this I will prove against thee by my body, as this court shall award. The battle is then to be fought with the same weapons, viz., batons, the same solemnity, and the same oath against amulets and sorcery that are used in the civil combat. And if the appellee be so far vanquished that he cannot or will not fight any longer, he shall be adjudged to be hanged immediately. And then, as well as if he be killed in battle, Providence is deemed to have determined in favor of the truth, and his blood shall be attainted. But if he kills the appellant, or can maintain the fight from sunrising till the stars appear in the evening, he shall be acquitted. So also, if the appellant becomes recreant and pronounces the horrible word of craven, he shall lose his liberum legem and become infamous. And the appellee shall recover his damages and also be forever quit, not only of the appeal, but of all indictments likewise for the same offense. 4. The fourth method of trial used in criminal cases is that by the peers of Great Britain in the Court of Parliament or the Court of the Lord High Steward when a peer is capitally indicted. Of this enough has been said in a former chapter, to which I shall now only add that in the method and regulation of its proceedings it differs little from the trial per patrium or by jury, except that the peers need not all agree in their verdict, but the greater number, consisting of 12 at the least, will conclude and bind the minority. End of chapter the 27th, part 1. Chapter 27, Part 2 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 27th of Trial and Conviction, Part 2. 5. The trial by jury or the country per patrium is also that trial by the peers of every Englishman which, as the grand bulwark of his liberties, is secured to him by the Great Charter. Nullus liber homo capiator, vel imprisonetur, aut exulet, aut alico alio modo destruator, nisi per legalem judicium parium suarum, vel per legem terrae. The antiquity and excellence of this trial for the settling of civil property has before been explained at large, and it will hold much stronger in criminal cases, since in times of difficulty and danger more is to be apprehended from the violence and partiality of judges appointed by the Crown in suits between the king and the subject than in disputes between one individual and another to settle the metes and boundaries of private property. Our law has therefore wisely placed this strong and twofold barrier of a presentment and a trial by jury between the liberties of the people and the prerogative of the Crown. It was necessary for preserving the admirable balance of our Constitution to vest the executive power of the laws in the Prince, and yet this power might be dangerous and destructive to that very Constitution if exerted without check or control by justices of oyer and terminer occasionally named by the Crown, who might then, as in France or Turkey, imprison, dispatch, or exile any man that was obnoxious to the government by an instant declaration that such is their will and pleasure. But the founders of the English laws have with excellent forecast contrived that no man should be called to answer to the king for any capital crime, unless upon the preparatory accusation of 12 or more of his fellow subjects the grand jury, and that the truth of every accusation, whether preferred in the shape of indictment, information, or appeal, should afterwards be confirmed by the unanimous suffrage of 12 of his equals and neighbors, indifferently chosen and superior to all suspicion. So that the liberties of England cannot but subsist so long as this palladium remains sacred and inviolate, not only from all open attacks, which none will be so hardy as to make, but also from all secret machinations which may sap and undermine it, by introducing new and arbitrary methods of trial by justices of the peace, commissioners of the revenue, and courts of conscience. And however convenient these may appear at first, as doubtless all arbitrary powers well executed are the most convenient, yet let it be again remembered that delays and little inconveniences in the forms of justice are the price that all free nations must pay for their liberty in more substantial matters; that these inroads upon this sacred bulwark of the nation are fundamentally opposite to the spirit of our Constitution; and that, though begun in trifles, the precedent may gradually increase and spread to the utter disuse of juries in questions of the most momentous concern. What was said of juries in general, and the trial thereby in civil cases, will greatly shorten our present remarks with regard to the trial of criminal suits, indictments, informations, and appeals, which trial I shall consider in the same method that I did the former, by following the order and course of the proceedings themselves as the most clear and perspicuous way of treating it. When therefore a prisoner on his arraignment has pleaded not guilty, and for his trial hath put himself upon the country, which country the jury are, the sheriff of the county must return a panel of jurors, liberos et legales homines de vicineto, that is, freeholders without just exception, and of the visne or neighborhood, which is interpreted to be of the county where the fact is committed. If the proceedings are before the Court of King's Bench, there is time allowed between the arraignment and trial for a jury to be impaneled by writ of venere facias to the sheriff as in civil causes, and the trial in a case of a misdemeanor is had at nisi prius, unless it be of such consequence as to merit a trial at bar, which is always invariably had when the prisoner is tried for any capital offence. But before commissioners of oyer interminer and jail delivery, the sheriff, by virtue of a general precept directed to him beforehand, returns to the court a panel of 48 jurors to try all felons that may be called upon their trial at that session, and therefore it is their usual to try all felons immediately or soon after their arraignment. But it is not customary nor agreeable to the general course of proceedings, unless by consent of the parties, to try persons indicted of smaller misdemeanors at the same court in which they have pleaded not guilty or traversed the indictment. But they usually give security to the court to appear at the next assizes or session, and then and there try the traverse, giving the notice to the prosecutor of the same. In cases of high treason, whereby corruption of blood may ensue, or misprision of such treason, it is enacted by Statute 7 William III, c. 3, first, that no person shall be tried for any such treason except an attempt to assassinate the king, unless the indictment be found within 3 years after the offense committed. Next, that the prisoner shall have a copy of the indictment, but not the names of the witnesses, 5 days at least before the trial, that is, upon the true construction of the act before his arraignment, for then is his time to take any exceptions thereto by way of plea or demurrer. Thirdly, that he shall also have a copy of the panel of jurors 2 days before his trial. And lastly, that he shall have the same compulsive process to bring in his witnesses for him as was usual to compel their appearance against him. And by Statute 7 and C-21, which did not take place till after the decease of the late pretender, all persons indicted for high treason or misprision thereof shall have not only a copy of the indictment, but a list of all the witnesses to be produced and of the jurors impaneled, with their professions and places of abode, delivered to him 10 days before the trial, and in the presence of 2 witnesses, the better to prepare him to make his challenges and defense. But this last act, so far as it affected indictments for the inferior species of high treason respecting the coin and the royal seals, is repealed by the Statute 6 George III C-53, else it had been impossible to have tried those offences in the same circuit in which they are indicted, for 10 clear days between the finding and the trial of the indictment will exceed the time usually allotted for any session of oyer intermiter, and no person indicted for felony is, or, as the law stands, ever can be, entitled to such copies before the time of his trial. When the trial is called on, the jurors are to be sworn as they appear to the number 12 unless they are challenged by the party. Challenges may be here made either on the part of the king or on that of the prisoner, and either to the whole array or to the separate polls for the very same reasons that they may be made in civil causes. For it is here at least as necessary as there that the sheriff or returning officer be totally indifferent, that where an alien is indicted, the jury should be de mediatate or half foreigners, which does not indeed hold in treasons, aliens being very improper judges of the breach of allegiance to the king, that on every panel there should be a competent number of hundredores, and that the particular jurors should be omni exceptione maiores, not liable to objection either propter honoris respectum, propter defectum, propter affectum, or propter delictum. Challenges upon any of the foregoing accounts are styled challenges for cause, which may be without stint in both criminal and civil trials. But in criminal cases, or at least in capital ones, there is in favorem vitae allowed to the prisoner an arbitrary and capricious species of challenge to a certain number of jurors, without showing any cause at all, which is called a peremptory challenge, a provision full of that tenderness and humanity to prisoners for which our English laws are justly famous. This is grounded on 2 reasons. 1. As every one must be sensible what sudden impressions and unaccountable prejudices we are apt to conceive upon the bare looks and gestures of another, and how necessary it is that a prisoner, when put to defend his life, should have a good opinion of his jury, the want of which might totally disconcert him, the law wills not that he should be tried by any one man against whom he has conceived a prejudice, even without being able to assign a reason for such his dislike. 2. Because upon challenges for cause shown, if the reason assigned prove insufficient to set aside the juror, perhaps the bare questioning his indifference may sometimes provoke a resentment, to prevent all ill consequences from which the prisoner is still at liberty, if he pleases, peremptorily to set him aside. This privilege of peremptory challenges, though granted to the prisoner, is denied to the king by the Statute 33 Edward I St. 4, which enacts that the king shall challenge no jurors without assigning a cause certain to be tried and approved by the court. However, it is held that the king need not assign his cause of challenge till all the panel is gone through, and unless there cannot be a full jury without the person so challenged. And then, and not sooner, the king's counsel must show the cause, otherwise the jury shall be sworn. The peremptory challenges of the prisoner must, however, have some reasonable boundary, otherwise he might never be tried. This reasonable boundary is settled by the common law to be the number of 35, that is, 1 under the number of 3 full juries. For the law judges that 5 and 30 are fully sufficient to allow the most timorous man to challenge through mere caprice, and that he who peremptorily challenges a greater number or 3 full juries has no intention to be tried at all. And therefore it dealt with one who peremptorily challenges above 35 and will not retract his challenge, as with one who stands mute or refuses his trial, by sentencing him to the peine forte d'or in felony, and by attainting him in treason. And so the law stands at this day with regard to treason of any kind. But by statute 22 Henry VIII c. 14, which with regard to felonies stands unrepealed by statute 1 and 2 Philip and Mary c. 10, by this statute, I say, no person arraigned for felony can be admitted to make any more than 20 peremptory challenges. But how if the prisoner will peremptorily challenge 21? What shall be done? The old opinion was that judgment of peine forte d'or should be given as where he challenged 36 at the common law. But the better opinion seems to be that such challenge shall only be disregarded and overruled, because first, the common law doth not inflict the judgment of penance for challenging 21, neither doth the statute inflict it, and so heavy a judgment shall not be imposed by implication. Secondly, the words of the statute are, that he be not admitted to challenge more than 20, the evident construction of which is, that any farther challenge shall be disallowed or prevented, and therefore, being null from the beginning, and never in fact a challenge, it can subject the prisoner to no punishment, but the juror shall be regularly sworn. If by reason of challenges or the default of the jurors a sufficient number cannot be had of the original panel, a tales may be awarded as in civil causes till the number of 12 is sworn, well and truly to try and true deliverance make between our sovereign lord the king and the prisoner whom they have in charge, a true verdict to give according to their evidence. When the jury is sworn, if it be a cause of any consequence, the indictment is usually opened and the evidence marshaled, examined, and enforced by the counsel for the crown or prosecution. But it is a settled rule at common law that no counsel shall be allowed a prisoner upon his trial upon the general issue in any capital crime, unless some point of law shall arise proper to be debated. A rule which, however it may be palliated under cover of that noble declaration of the law when rightly understood, that the judge shall be counsel for the prisoner, that is, shall see that the proceedings against him are legal and strictly regular, seems to be not at all of a piece with the rest of the humane treatment of prisoners by the English law. For upon what face of reason can that assistance be denied to save the life of a man, which is yet allowed him in prosecutions for every petty trespass? Nor indeed is it strictly speaking a part of our ancient law, for the mirror, having observed the necessity of counsel in civil suits, who know how to forward and defend the cause by the rules of law and customs of the realm, immediately afterwards subjoins, and more necessary are they for defense upon indictments and appeals of felony than upon other venial causes. And to say the truth, the judges themselves are so sensible of this defect in our modern practice, that they seldom scruple to allow a prisoner counsel to stand by him at the bar and instruct him what questions to ask, or even to ask questions for him with respect to matters of fact. For as to matter of law arising on the trial, they are entitled to the assistance of counsel. But still this is a matter of too much importance to be left to the good pleasure of any judge, and is worthy the interposition of the legislature, which has shown its inclination to indulge prisoners with this reasonable assistance by enacting in statute 7 William III c. 3, that persons indicted for such high treason as works a corruption of the blood or misprision thereof may make their full defense by counsel, not exceeding 2, to be named by the prisoner and assigned by the court or judge. and this indulgence by Statute 20 George II C. 30 is extended to parliamentary impeachments for high treason which were accepted in the former Act. End of Chapter the 27th, Part 2. Chapter 27, Part 3 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 27th of Trial and Conviction, Part 3. The doctrine of evidence upon pleas of the Crown is, in most respects, the same as that upon civil actions. There are, however, a few leading points wherein, by several statutes and resolutions, a difference is made between civil and criminal evidence. First, in all cases of high treason, petite treason, and misprision of treason, by statutes 1 Edward VI c. 12, 5 and 6 Edward VI c. 11, and 1 and 2 Philip and Mary c. 10, two lawful witnesses are required to convict a prisoner except in cases of coining and counterfeiting the seals, or unless the party shall willingly and without violence confess the same. By Statute 7 William III c. 3, in prosecutions for those treasons to which that act extends, the same rule is again enforced with this addition, that the confession of the prisoner, which shall countervail the necessity of such proof, must be in open court, and it is declared that both witnesses must be to the same overt act of treason, or one to one overt act and the other to another overt act of the same species of treason, and not of distinct heads or kinds, and no evidence shall be admitted to prove any overt act not expressly laid in the indictment. And therefore, in Sir John Fenwick's case in King William's time, where there was but one witness, an Act of Parliament was made on purpose to attaint him of treason, and he was executed. But in almost every other accusation one positive witness is sufficient. Baron Montesquieu lays it down for a rule that those laws which condemn a man to death in any case on the deposition of a single witness are fatal to liberty, and he adds this reason, that the witness who affirms and the accused who denies make an equal balance. There is a necessity, therefore, to call in a third man to incline the scale. But this seems to be carrying matters too far, for there are some crimes in which the very privacy of their nature excludes the possibility of having more than one witness. Must these therefore escape unpunished? Neither indeed is the bare denial of the person accused equivalent to the positive oath of a disinterested witness. In cases of indictments for perjury, this doctrine is better founded, and there our law adopts it. For one witness is not allowed to convict a man indicted for perjury, because then there is only one oath against another. In cases of treason also there is the accused's oath of allegiance to counterpoise the information of a single witness, and that may perhaps be one reason why the law requires a double testimony to convict him, though the principal reason undoubtedly is to secure the subject from being sacrificed to fictitious conspiracies which have been the engines of profligate and crafty politicians in all ages. Secondly, though from the reversal of Colonel Sidney's attainder by Act of Parliament in 1689 it may be collected that the mere similitude of handwriting in two papers shown to a jury, without other concurrent testimony, is no evidence that both were written by the same person, yet undoubtedly the testimony of witnesses well acquainted with the party's hand that they believed the paper in question to have been written by him is evidence to be left to a jury. Thirdly, by the statute 21 James I c. 27, a mother of a bastard child concealing its death must prove by one witness that the child was born dead, otherwise such concealment shall be evidence of her having murdered it. Fourthly, All presumptive evidence of felony should be admitted cautiously, for the law holds that it is better that 10 guilty persons escape than that one innocent suffer. And Sir Matthew Hale in particular lays down two rules most prudent and necessary to be observed. One, never to convict a man for stealing the goods of a person unknown merely because he will give no account how he came by them unless an actual felony be proved of such goods. And two, never to convict any person of murder or manslaughter till at least the body be found dead, on account of two instances he mentions where persons were executed for the murder of others who were then alive but missing. Lastly, it was an ancient and commonly received practice derived from the civil law, and which also to this day obtains in the kingdom of France, that as counsel was not allowed to any prisoner accused of a capital crime, so neither should he be suffered to exculpate himself by the testimony of any witnesses. And therefore it deserves to be remembered to the honor of Mary the First, whose early sentiments till her marriage with Philip of Spain seem to have been humane and generous, that when she appointed Sir Richard Morgan Chief Justice of the Common Pleas, she enjoined him, that notwithstanding the old error which did not admit any witness to speak, or any other matter to be heard in favor of the adversary, her Majesty being party, her Highness's pleasure was, that whatsoever could be brought in favor of the subject should be admitted to be heard, and moreover, that the justices should not persuade themselves to sit in judgment otherwise for her Highness than for her subject. Afterwards, in one particular instance, when embezzling the Queen's military stores was made felony by Statute 31 Elizabeth C.4, it was provided that any person impeached for such felony should be received and admitted to make any lawful proof that he could, by lawful witness or otherwise, for his discharge and defense. And in general, the courts grew so heartily ashamed of a doctrine so unreasonable and oppressive, that a practice was gradually introduced of examining witnesses for the prisoner, but not upon oath. The consequence of which still was, that the jury gave less credit to the prisoner's evidence than to that produced by the Crown. Sir Edward Coke protests very strongly against this tyrannical practice, declaring that he never read in any Act of Parliament, bookcase, or record, that in criminal cases the party accused should not have witnesses sworn for him, and therefore there was not so much as a scintilla juris against it. And the House of Commons were so sensible of this absurdity, that in the bill for abolishing hostilities between England and Scotland, when felonies committed by Englishmen in Scotland were ordered to be tried in one of the three northern counties, they insisted on a clause and carried it against the efforts both of the Crown and the House of Lords, against the practice of the courts of England and the express law of Scotland, that in all such trials, for the better discovery of the truth and the better information of the consciences of the jury and justices, there shall be allowed to the party arraigned the benefit of such credible witnesses to be examined upon oath as can be produced for his clearing and justification. At length, by Statute 7 William III C.3, the same measure of justice was established throughout all the realm in cases of treason within the Act, and it was afterwards declared by Statute 1 and St. 2 C.9 that in all cases of treason and felony, all witnesses for the prisoner should be examined upon oath in like manner as the witnesses against him. When the evidence on both sides is closed, the jury cannot be discharged till they have given in their verdict, but are to consider of it and deliver it in with the same forms as upon civil causes, only they cannot, as in a criminal case, give a privy verdict. But an open verdict may be either general, guilty, or not guilty, or special, setting forth all the circumstances of the case and praying the judgment of the court, whether, for instance, on the facts stated, it be murder, manslaughter, or no crime at all. This is where they doubt the matter of law, and therefore choose to leave it to the determination of the court, though they have an unquestionable right of determining it upon all the circumstances and finding a general verdict if they think proper so to hazard a breach of their oaths. And if their verdict be notoriously wrong, they may be punished and the verdict set aside by a taint at the suit of the king, but not at the suit of the prisoner. But the practice heretofore in use of fining, imprisoning, or otherwise punishing jurors merely at the discretion of the court for finding their verdict contrary to the direction of the judge was arbitrary, unconstitutional, and illegal, and it is treated as such by Sir Thomas Smith 200 years ago, who accounted such doings to be very violent, tyrannical, and contrary to the liberty and custom of the realm of England. For, as Sir Matthew Hale well observes, it would be a most unhappy case for the judge himself if the prisoner's fate depended upon his directions, unhappy also for the prisoner. For if the judge's opinion must rule the verdict, the trial by jury would be useless. Yet in many instances where contrary to evidence the jury have found the prisoner guilty, their verdict hath been mercifully set aside and a new trial granted by the Court of King's Bench. For in such case, as hath been said, it cannot be set right by a taint. But there hath yet been no instance of granting a new trial where the prisoner was acquitted upon the first. If the jury therefore find the prisoner not guilty, he is then for ever quit and discharged of the accusation, except he be appealed the felony within the time limited by law. But if the jury find him guilty, he is then said to be convicted of the crime whereof he stands indicted, which conviction may accrue two ways, either by his confessing the offense and pleading guilty, or by his being found so by the verdict of his country. When the offender is thus convicted, there are two collateral circumstances that immediately arise. 1. On a conviction in general for any felony, the reasonable expenses of the prosecution are by statute 25 George II c. 36 to be allowed to the prosecutor out of the county stock if he petitions the judge for that purpose. And by statute 27 George II c. 3, poor persons bound over to give evidence are likewise entitled to be paid their charges as well without conviction as with it. 2. On a conviction of larceny in particular, the prosecutor shall have restitution of his goods by virtue of the statute 21 Henry VIII c. 11. For by the common law there was no restitution of goods upon an indictment, because it is at the suit of the king only, and therefore the party was enforced to bring an appeal of robbery in order to have his goods again. But it being considered that the party prosecuting the offender by indictment deserves to the full as much encouragement as he who prosecutes by appeal, this statute was made, which enacts that if any person be convicted of larceny by the evidence of the party robbed, he shall have full restitution of his money, goods, and chattels, or the value of them out of the offender's goods, if he has any, by a writ to be granted by the justices. And this writ of restitution shall reach the goods so stolen, notwithstanding the property of them as endeavored to be altered by sale in market overt. And though this may seem somewhat hard upon the buyer, yet the rule of law is that spoliatus debet ante omnia restitui, especially when he has used all the diligence in his power to convict the felon. And since the case is reduced to this hard necessity that either the owner or the buyer must suffer, the law prefers the right of the owner, who has done a meritorious act by pursuing a felon to condign punishment, to the right of the buyer, whose merit is only negative, that he has been guilty of no unfair transaction. Or else, secondly, without such writ of restitution, the party may peaceably retake his goods wherever he happens to find them, unless a new property be fairly acquired therein. Or lastly, if the felon be convicted and pardoned, or be allowed his clergy, the party robbed may bring his action of trover against him for his goods, and recover a satisfaction in damages.
But such action lies not before prosecution, for so felonies would be made up and healed, and also recaption is unlawful if it be done with the intention to smother or compound the larceny, it then becoming the heinous offense of theft boat, as was mentioned in a former chapter. It is not uncommon when a person is convicted of a misdemeanor which principally and more immediately affects some individual, as a battery, imprisonment, or the like, for the court to permit the defendant to speak with the prosecutor before any judgment is pronounced, and if the prosecutor declares himself satisfied to inflict but a trivial punishment. This is done to reimburse the prosecutor his expenses and make him some private amends without the trouble and circuity of a civil action. But it surely is a dangerous practice, and though it may be entrusted to the prudence and discretion of the judges in the superior courts of record, it ought never to be allowed in local or inferior jurisdictions such as the Court of Sessions, where prosecutions for assaults are by this means too frequently commenced rather for private lucre than for the great ends of public justice. Above all, it should never be suffered where the testimony of the prosecutor himself is necessary to convict the defendant, for by this means the rules of evidence are entirely subverted, the prosecutor becomes in effect a plaintiff, and yet is suffered to bear witness for himself. Nay, even a voluntary forgiveness by the party injured ought not in true policy to intercept the stroke of justice. This, says an elegant writer, who pleads with equal strength for the certainty as for the lenity of punishment, may be an act of good nature and humanity, but it is contrary to the good of the public. For although a private citizen may dispense with satisfaction for his private injury, he cannot remove the necessity of public example. The right of punishing belongs not to any one individual in particular, but to the society in general, or the sovereign who represents that society. And a man may renounce his own portion of this right, but he cannot give up that of others. End of chapter the 27th, part 3. Chapter 28 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 28th of the Benefit of Clergy. After trial and conviction, the judgment of the court regularly follows unless suspended or arrested by some intervening circumstance, of which the principal is the benefit of clergy, a title of no small curiosity as well as use, and concerning which I shall therefore inquire, 1. Into its original and the various mutations which this privilege of clergy has sustained, 2. To what persons it is to be allowed at this day, 3. In what cases, 4. The consequences of allowing it. 1. Clergy. The privilegium clericale, or in common speech, the benefit of clergy, had its original from the pious regard paid by Christian princes to the Church in its infant state, and the ill use which the popish ecclesiastics soon made of that pious regard. The exemptions which they granted to the Church were principally of two kinds. 1. Exemption of places consecrated to religious duties from criminal arrests, which was the foundation of sanctuaries. 2. Exemption of the persons of clergymen from criminal process before the secular judge in a few particular cases, which was the true original and meaning of the privilegium clericale. But the clergy, increasing in wealth, power, honor, number, and interest, began soon to set up for themselves, and that which they obtained by the favor of the civil government they now claimed as their inherent right, and as a right of the highest nature, indefeasible and jure divino. By their canons, therefore, and constitutions they endeavored at,
and where they met with easy princes obtained a vast extension of these exemptions, as well in regard to the crimes themselves, of which the list became quite universal, as in regard to the persons exempted, among whom were at length comprehended not only every little subordinate officer belonging to the church or clergy, but even many that were totally laymen. In England, however, although the usurpations of the Pope were very many and grievous, till Henry VIII entirely exterminated his supremacy, yet a total exemption of the clergy from secular jurisdiction could never be thoroughly effected, though often endeavored by the clergy, and therefore, though the ancient privilegium clericale was in some capital cases, yet it was not universally allowed, and in those particular cases the use was for the bishop or ordinary to demand his clerks to be remitted out of the king's courts as soon as they were indicted, concerning the allowance of which demand there was for many years a great uncertainty, till at length it was finally settled in the reign of Henry VI that the prisoner should be first arraigned, and might either then claim his benefit of clergy by way of declinatory plea, or, after conviction, by way of arresting judgment. This latter way is most usually practiced, as it is more to the satisfaction of the court to have the crime previously ascertained by confession or the verdict of a jury, and also it is more advantageous to the prisoner himself, who may possibly be acquitted, and so need not the benefit of his clergy at all. Originally the law was held that no man should be admitted to the privilege of clergy but such as had the habitum et tonsorum clericalem, but in process of time a much wider and more comprehensive criterion was established. Everyone that could read, a mark of great learning in those days of ignorance and her sister superstition, being accounted a clerk or clericus, and allowed the benefit of clerkship, though neither initiated in holy orders nor trimmed with the clerical tonsure. But when learning, by means of the invention of printing and other concurrent causes, began to be more generally disseminated than formerly, and reading was no longer a competent proof of clerkship or being in holy orders, it was found that as many laymen as divines were admitted to the privilegium clericale, and therefore, by statute 4 Henry VII, c. 13, a distinction was once more drawn between mere lay scholars and clerks that were really in orders, and though it was thought reasonable still to mitigate the severity of the law with regard to the former, yet they were not put upon the same footing with actual clergy, being subjected to a slight degree of punishment and not allowed to claim the clerical privilege more than once. Accordingly, the statute directs that no person once admitted to the benefit of clergy shall be admitted thereto a second time unless he produces his orders, and in order to distinguish their persons, all laymen who are allowed this privilege shall be burnt with a hot iron in the brawn of the left thumb. This distinction between learned laymen and real clerks in orders was abolished for a time by the statutes 28 Henry VIII c. 1 and 32 Henry VIII c. 3, but is held to have been virtually restored by statute 1 Edward VI c. 12, which statute also enacts that lords of parliament and peers of the realm may have the benefit of their peerage equivalent to that of clergy for the first offense, although they cannot read, and without being burnt in the hand, for all offences then clergiable to commoners, and also for the crimes of housebreaking, highway robbery, horse stealing, and robbing of churches. After this burning, the laity, and before it the real clergy, were discharged from the sentence of the law in the king's courts and delivered over to the ordinary to be dealt with according to the ecclesiastical canons. Whereupon the ordinary, not satisfied with the proofs adduced in the profane secular court, set himself formally to work to make a purgation of the offender by a new canonical trial, although he had been previously convicted by his country, or perhaps by his own confession. This trial was held before the bishop in person or his deputy, and by a jury of 12 clerks, and there first the party himself was required to make oath of his own innocence. Next, there was to be the oath of 12 compurgators, who swore they believed he spoke the truth. Then witnesses were to be examined upon oath, but on behalf of the prisoner only. And lastly, the jury were to bring in their verdict upon oath, which usually acquitted the prisoner. Otherwise, if a clerk, he was degraded or put to penance. A learned judge in the beginning of the last century remarks with much indignation the vast complication of perjury and subornation of perjury in this solemn farce of a mock trial, the witnesses, compurgators, and the jury being all of them partakers in the guilt. The delinquent party also, though convicted before on the clearest evidence and conscious of his own offence, yet was permitted and almost compelled to swear himself not guilty, nor was the good bishop himself, under whose countenance this scene of wickedness was daily transacted, by any means exempt from a share of it. And yet by this purgation the party was restored to his credit, his liberty, his lands, and his capacity of purchasing afresh, and was entirely made a new and innocent man. This scandalous prostitution of oaths and the forms of justice in the almost constant acquittal of felonious clerks by purgation was the occasion that, upon very heinous and notorious circumstances of guilt, the temporal courts would not trust the ordinary with the trial of the offender, but delivered over to him the convicted clerk, obsque purgatione facienda, in which situation the clerk convict could not make purgation, but was to continue in prison during life, and was incapable of acquiring any personal property or receiving the profits of his lands unless the king should please to pardon him. Both these courses were in some degree exceptionable, the latter being perhaps too rigid, as the former was productive of the most abandoned perjury. As therefore these mock trials took their rise from factious and popish tenets, tending to exempt one part of the nation from the general municipal law, it became high time, when the Reformation was thoroughly established, to abolish so vain and impious a ceremony. Accordingly, the statute 18 Elizabeth C7 enacts that for the avoiding of such perjuries and abuses, after the offender has been allowed his clergy, he shall not be delivered to the ordinary as formerly, but upon such allowance and burning in the hand, he shall forthwith be enlarged and delivered out of prison, with proviso that the judge may, if he thinks fit, continue the offender in jail for any time not exceeding a year. And thus the law continued for above a century unaltered, except only that the statute 21 James I C6 allowed that women convicted of simple larcenies under the value of 10 shillings should not properly have the benefit of clergy, for they were not called upon to read, but be burned in the hand, and whipped, stocked, or imprisoned for any time not exceeding a year. And a similar indulgence by the statutes 3 and 4 William and Mary C9 and 4 and 5 William and Mary C24 was extended to women guilty of any clergyable felony whatsoever, who were allowed once to claim the benefit of the statute, in like manner as men might claim the benefit of clergy, and to be discharged upon being burned in the hand and imprisoned for any time not exceeding a year. All women, all peers, and all male commoners who could read, were therefore discharged in such felonies, absolutely if clerks in orders, and for the first offence upon burning in the hand if lay; yet all liable, excepting peers, if the judge saw occasion, to imprisonment not exceeding a year. And those men who could not read, if under the degree of peerage, were hanged. Afterwards, indeed, it was considered that education and learning were no extenuations of guilt, but quite the reverse, and that if the punishment of death for simple felony was too severe for those who had been liberally instructed, it was, a fortiori, too severe for the ignorant also. And thereupon, by Statute 5 and C6, it was enacted that the benefit of clergy should be granted to all those who were entitled to ask it without requiring them to read by way of conditional merit. And experience having shown that so very universal a lenity was frequently inconvenient and an encouragement to commit the lower degrees of felony, and that though capital punishments were too rigorous for these inferior offenses, yet no punishment at all, or next to none, as branding or whipping, was as much too gentle, it was enacted by the same statute 5 and C6 that when any person is convicted of any theft or larceny and burnt in the hand for the same, he shall also be committed to the house of correction or public workhouse to be there kept to hard labor for any time not less than 6 months and not exceeding 2 years, with a power of inflicting a double confinement in case of the party's escape from the first. And it is also enacted by the statutes 4 George I C11 and 6 George I C23 that when any person shall be convicted of any larceny, either grand or petite, or any felonious stealing or taking of money or goods and chattels either from the person or the house of any other, or in any other manner, and who by the law shall be entitled to the benefit of clergy, and liable only to the penalties of burning in the hand or whipping, the court in their discretion, instead of such burning in the hand or whipping, may direct such offenders to be transported to America for 7 years, and if they return or are seen at large in this kingdom within that time, it shall be felony without benefit of clergy. In this state does the benefit of clergy at present stand, very considerably different from its original institution, the wisdom of the English legislature having, in the course of a long and laborious process, extracted by a noble alchemy rich medicines out of poisonous ingredients, and converted by gradual mutations what was at first an unreasonable exemption of particular popish ecclesiastics into a merciful mitigation of the general law with respect to capital punishment. From the whole of this detail we may collect that however in times of ignorance and superstition that monster in true policy which may for a while subsist, of a body of men residing in the bowels of a state and yet independent of its laws, yet when learning and rational religion have a little enlightened men's minds, society can no longer endure an absurdity so gross as must destroy its very fundamentals. For by the original contract of government, the price of protection by the united force of individuals is that of obedience to the united will of the community. This united will is declared in the laws of the land, and that united force is exerted in their due and universal execution. 2. I am next to inquire to what persons the benefit of clergy is to be allowed at this day, and this must be chiefly collected from what has been observed in the preceding article. For upon the whole we may pronounce that all clerks in orders are, without any branding, and of course without any transportation, for that is only substituted in lieu of the other, to be admitted to this privilege and immediately discharged, or at most only confined for 1 year, and this is as often as they offend. Again, all lords of parliament and peers of the realm, by statute 1 Edward VI C12, shall be discharged in all clergiable and other felonies provided for by the act, without any burning in the hand, in the same manner as real clerks convict. But this is only for the first offense. Lastly, all the commons of the realm not in orders, whether male or female, shall for the first offense be discharged of the punishment of felonies within the benefit of clergy upon being burnt in the hand and suffering a discretionary imprisonment, or, in the case of larceny, upon being transported for 7 years if the court shall think proper. It hath been said that Jews and other infidels and heretics were not capable of the benefit of clergy till after the statute 5 and C6, as being under a legal incapacity for orders. but I much question whether this was ever ruled for law since the reintroduction of the Jews into England in the time of Oliver Cromwell. For if that were the case, the Jews are still in the same predicament which every day's experience will contradict. The statute of Queen Anne having certainly made no alteration in this respect, it only dispensing with the necessity of reading in those persons who, in case they could read, were before the act entitled to the benefit of their clergy. 3. The third point to be considered is, for what crimes the privilegium clericale or benefit of clergy is to be allowed. And it is to be observed that neither in high treason nor in petite larceny, nor in any mere misdemeanors it was indulged at the common law, and therefore we may lay it down for a rule that it was allowable only in petite treasons and felonies, which for the most part became legally entitled to this indulgence by the statute de Clero 25 Edward III St. 3 C4, which provides that clerks convict for treasons or felonies touching other persons than the king himself or his royal majesty shall have the privilege of Holy Church. But yet it was not allowable in all felonies whatsoever, for in some it was denied even by the common law, viz., insidiatio viarum, or lying in wait for one on the highway, depopulatio agrorum, or destroying and ravaging a country, and combustio domorum, or arson, that is, the burning of houses, all which are a kind of hostile acts and in some degree border on treason. And farther, all these identical crimes, together with petite treason and very many other acts of felony, are ousted of clergy by particular acts of Parliament, which have in general been mentioned under the particular offences to which they belong, and therefore need not be here recapitulated. Of all which statutes for excluding clergy, I shall only observe that they are nothing else but the restoring of the law to the same rigor of capital punishment in the first offense that it exerted before the privilegium clericale was at all indulged, and which it still exerts upon a second offense in almost all kinds of felonies unless committed by clerks actually in orders. We may also remark that by the marine law, as declared in Statute 28 Henry VIII c. 15, the benefit of clergy is not allowed in any case whatsoever, and therefore, when offences are committed within the Admiralty jurisdiction, which would be clergyable if committed by land, the constant course is to acquit and discharge the prisoner. And lastly, under this head of inquiry, we may observe the following rules. 1. That in all felonies, whether new created or by common law, clergy is now allowable unless taken away by express words of an act of Parliament. 2. That where clergy is taken away from the principal, it is not of course taken away from the accessory unless he be also particularly included in the words of the statute. 3. That when the benefit of clergy is taken away from the offense, as in case of murder, buggery, robbery, rape, and burglary, a principal in the second degree, aiding and abetting the crime, is as well excluded from his clergy as he that is principal in the first degree. But, 4. That where it is only taken away from the person committing the offense, as in the case of stabbing or committing larceny in a dwelling house or privately from the person, his aiders and abettors are not excluded, through the tenderness of the law which hath determined that such statutes be taken literally. 4. Lastly, we are to inquire what the consequences are to the party of allowing him this benefit of clergy. I speak not of the branding, imprisonment, or transportation, which are rather concomitant conditions than consequences of receiving this indulgence. The consequences are such as affect his present interest and future credit and capacity, as having been once a felon, but now purged from that guilt by the privilege of clergy, which operates as a kind of statute pardon. And we may observe, 1. That by his conviction he forfeits all his goods to the king, which being once vested in the crown shall not afterwards be restored to the offender. 2.
that after conviction, until he receives the judgment of law by branding or the like, or else is pardoned by the king, he is to all intents and purposes a felon and subject to all the disabilities and other incidents of a felon. 3. That after burning or pardon, he is discharged forever of that and all other felonies before committed within the benefit of clergy, but not of felonies from which such benefit is excluded, and this by statutes 8 Elizabeth c. 4 and 18 Elizabeth c. 7. 4. That by the burning or pardon of it, he is restored to all capacities and credits and the possession of his lands as if he had never been convicted. 5. That what is said with regard to the advantages of commoners and laymen subsequent to the burning in the hand is equally applicable to all peers and clergymen, although never branded at all, for they have the same privileges without any burning which others are entitled to after it. End of chapter the 28th. Chapter 29, Part 1 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 29th of Judgment and Its Consequences, Part 1. We are now to consider the next stage of criminal prosecution after trial and conviction are passed in such crimes and misdemeanors as are either too high or too low to be included within the benefit of clergy, which is that of judgment. For when, upon a capital charge, the jury have brought in their verdict guilty in the presence of the prisoner, he is either immediately or at a convenient time soon after asked by the court if he has anything to offer why judgment should not be awarded against him. And in case the defendant be found guilty of a misdemeanor, the trial of which may and does usually happen in his absence after he has once appeared, a copyist is awarded and issued to bring him in to receive his judgment, and if he absconds, he may be prosecuted even to outlawry. But whenever he appears in person upon either a capital or inferior conviction, he may at this period, as well as at his arraignment, offer any exceptions to the indictment in arrest or stay of judgment. As for want of sufficient certainty in setting forth either the person, the time, the place, or the offense. And if the objections be valid, the whole proceedings shall be set aside, but the party may be indicted again. And we may take notice, 1. That none of the statutes of Geophils for the amendment of errors extend to indictments or proceedings in criminal cases, and therefore a defective indictment is not aided by a verdict as defective pleadings in civil cases are. 2. That in favor of life great strictness has at all times been observed in every point of an indictment. Sir Matthew Hale indeed complains that this strictness has grown to be a blemish and inconvenience in the law and the administration thereof, for that more offenders escape by the over-easy ear given to exceptions in indictments than by their own innocence, and many times gross murders, burglaries, robberies, and other heinous and crying offenses remain unpunished by these unseemly niceties, to the reproach of the law, to the shame of the government, to the encouragement of villainy, and to the dishonor of God. And yet, notwithstanding this laudable zeal, no man was more tender of life than this truly excellent judge. A pardon also, as has been before said, may be pleaded in arrest of judgment, and it has the same advantage when pleaded here as when pleaded upon arraignment, viz., the saving the attainter, and of course the corruption of blood, which nothing can restore but Parliament when a pardon is not pleaded till after sentence. And certainly, upon all accounts, when a man hath obtained a pardon, he is in the right to plead it as soon as possible. Praying the benefit of clergy may also be ranked among the motions in arrest of judgment, of which we spoke largely in the preceding chapter. If all these resources fail, the court must pronounce that judgment which the law hath annexed to the crime, and which hath been constantly mentioned, together with the crime itself, in some or other of the former chapters. Of these, some are capital, which extend to the life of the offender, and consist generally in being hanged by the neck until dead, though in very atrocious crimes other circumstances of terror, pain, or disgrace are superadded, as in treasons of all kinds, being drawn or dragged to the place of execution, in high treason affecting the king's person or government, in bowing alive, beheading, and quartering, and in murder a public dissection. And in case of any treason committed by a female, the judgment is to be burned alive. But the humanity of the English nation has authorized by a tacit consent an almost general mitigation of such part of these judgments as favor of torture or cruelty, a sledge or hurdle being usually allowed to such traitors as are condemned to be drawn. And there are very few instances, and those accidental or by negligence, of any persons being emboweled or burned till previously deprived of sensation by strangling. Some punishments consist in exile or banishment by abjuration of the realm or transportation to the American colonies, others in loss of liberty by perpetual or temporary imprisonment. Some extend to confiscation by forfeiture of lands or movables, or both, or of the profits of the lands for life. Others induce a disability of holding offices or employments, being heirs, executors, and the like. Some, though rarely, occasion a mutilation or dismembering by cutting off the hand or ears. Others fix a lasting stigma on the offender by slitting the nostril or branding in the hand or face. Some are merely pecuniary, by stated or discretionary fines. And lastly, there are others that consist principally in their ignominy, though most of them are mixed with some degree of corporal pain. And these are inflicted chiefly for crimes which arise from indigence, or which render even opulence disgraceful, such as whipping, hard labor in the house of correction, the pillory, the stocks, and the ducking stool. Disgusting as this catalogue may seem, it will afford pleasure to an English reader and do honor to the English law to compare it with that shocking apparatus of death and torment to be met with in the criminal codes of almost every other nation in Europe. And it is moreover one of the glories of our English law that the nature, though not always the quantity or degree, of punishment is ascertained for every offense, and that it is not left in the breast of any judge, nor even of a jury, to alter that judgment which the law has beforehand ordained for every subject alike, without respect of persons. For if judgments were to be the private opinions of the judge, men would then be slaves to their magistrates, and would live in society without knowing exactly the conditions and obligations which it lays them under. And besides, as this prevents oppression on the one hand, so on the other it stifles all hopes of impunity or mitigation, with which an offender might flatter himself if his punishment depended on the humor or discretion of the court. Whereas where an established penalty is annexed to crimes, the criminal may read their certain consequence in that law, which ought to be the unvaried rule, as it is the inflexible judge of his actions. The discretionary fines and discretionary length of imprisonment which our courts are enabled to impose may seem an exception to this rule. But the general nature of the punishment, viz., by fine or imprisonment, is in these cases fixed and determinate, though the duration and quantity of each must frequently vary from the aggravations or otherwise of the offense, the quality and condition of the parties, and from innumerable other circumstances. The quantum in particular of pecuniary fines neither can nor ought to be ascertained by any invariable law. The value of money itself changes from 1,000 causes, and at all events what is ruin to one man's fortune may be matter of indifference to another's. Thus the law of the 12 tables at Rome fined every person that struck another 25 denarii, This, in the more opulent days of the empire, grew to be a punishment of so little consideration that Ulus Gellius tells a story of one Lucius Neratius who made it his diversion to give a blow to whomever he pleased and then tender them the legal forfeiture. Our statute law has not therefore often ascertained the quantity of fines, nor the common law ever, it directing such an offense to be punished by fine in general without specifying the certain sum, which is fully sufficient when we consider that however unlimited the power of the court may seem, it is far from being wholly arbitrary, but its discretion is regulated by law. For the Bill of Rights has particularly declared that excessive fines ought not to be imposed, nor cruel and unusual punishments inflicted, which had a respect to some unprecedented proceedings in the Court of King's Bench in the reign of King James II, and the same statute farther declares that all grants and promises of fines and forfeitures of particular persons before convictions are illegal and void. Now the Bill of Rights was only declaratory throughout of the old constitutional law of the land, and accordingly we find it expressly holden long before that all such previous grants are void, since thereby many times undue means and more violent prosecution would be used for private lucre than the quiet and just proceeding of law would permit. The reasonableness of fines in criminal cases has also been usually regulated by the determination of Magna Carta concerning amercements for behavior in matters of civil right. Liber homo non amercitur pro parvo delicto, nisi secundum modum ipsis delicti, et pro magno delicto, secundum magnitudinem delicti, salvo contenimento suo, et mercator eodem modo, salva mercandisa sua, et villanus eodom modo emercitur, salvo venagio suo. A rule that obtained even in Henry II's time, and means only that no man shall have a larger amercement imposed upon him than his circumstance or personal estate will bear, saving to the landholder his contenement or land, to the trader his merchandise, and to the countryman his wainage or team and instruments of husbandry. In order to ascertain which, the Great Charter also directs that the amercement which was always inflicted in general terms, sit in misericordia, shall be set ponator, or reduced to a certainty by the oath of a jury. This method of liquidating the amercement to a precise sum is usually done in the court leet and court baron by afferers, or jurors sworn to affer, that is, tax and moderate the general amercement according to the particular circumstances of the offense and the offender. In imitation of which, in courts superior to these, the ancient practice was to inquire by a jury when a fine was imposed upon any man, quantum inde regi dare valeat per annum, salva sustentatione sua, et uxores, et liberorum suarum. And since the disuse of such inquest, it is never usual to assess a larger fine than a man is able to pay without touching the implements of his livelihood, but to inflict corporal punishment or a stated imprisonment, which is better than an excessive fine, for that amounts to imprisonment for life. And this is the reason why fines in the king's court are frequently denominated ransoms, because the penalty must otherwise fall upon a man's person unless it be redeemed or ransomed by a pecuniary fine, according to the ancient maxim, qui non habet in crumena luat in corpore. Yet where any statute speaks both of fine and ransom, it is holden that the ransom shall be treble to the fine at least. When sentence of death, the most terrible and highest judgment in the laws of England, is pronounced, the immediate inseparable consequence by the common law is attainder. For when it is now clear beyond all dispute that the criminal is no longer fit to live upon the earth, but is to be exterminated as a monster and a bane to human society, the law sets a note of infamy upon him, puts him out of its protection, and takes no farther care of him than barely to see him executed. He is then called a taint, a tincus, stained, or blackened. He is no longer of any credit or reputation. He cannot be a witness in any court, neither is he capable of performing the functions of another man, for by an anticipation of his punishment he is already dead in law. This is after judgment, for there is a great difference between a man convicted and attainted, though they are frequently through inaccuracy confounded together. After conviction only, a man is liable to none of these disabilities, for there is still in contemplation of law a possibility of his innocence. Something may be offered in arrest of judgment, the indictment may be erroneous, which will render his guilt uncertain, and thereupon the present conviction may be quashed. He may obtain a pardon, or be allowed the benefit of clergy, both which suppose some latent sparks of merit which plead the extenuation of his fault. But when judgment is once pronounced, both law and fact conspire to prove him completely guilty, and there is not the remotest possibility left of anything to be said in his favor. Upon judgment, therefore, of death, and not before, the attainder of a criminal commences, or upon such circumstances as are equivalent to judgment of death, as judgment of outlawry on a capital crime, pronounced for absconding or fleeing from justice, which tacitly confesses the guilt. And therefore, either upon judgment of outlawry or of death for treason or felony, a man shall be said to be attainted. End of chapter the 29th, part 1.
Chapter 29, Part 2 of the Commentaries on the Laws of England, Book the Fourth of Public Wrongs by William Blackstone. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Roy Haines. Chapter the 29th of Judgment and Its Consequences, Part 2. The consequences of attainder are forfeiture and corruption of blood. 1. Forfeiture is twofold, of real and personal estates. First, as to real estates. By attainder and high treason, a man forfeits to the king all his lands and tenements of inheritance, whether fee simple or fee tail, and all his rights of entry on lands and tenements which he had at the time of the offense committed, or any time afterwards, to be forever vested in the crown, and also the profits of all lands and tenements which he had in his own right for life or years, so long as such interest shall subsist. This forfeiture relates backwards to the time of the treason committed, so as to avoid all intermediate sales and encumbrances, but not those before the fact. And therefore a wife's jointure is not forfeitable for the treason of her husband, because settled upon her previous to the treason committed. But her dower is forfeited by the express provision of Statute 5 and 6 Edward VI c. 11. And yet the husband shall be tenant by the courtesy of the wife's lands, if the wife be attainted of treason, for that is not prohibited by the statute. But though after attainder the forfeiture relates back to the time of the treason committed, yet it does not take effect unless an attainder be had, of which it is one of the fruits. And therefore, if a traitor dies before judgment pronounced, or is killed in open rebellion, or is hanged by martial law, it works no forfeiture of his lands, for he never was attainted of treason. The natural justice of forfeiture or confiscation of property for treason is founded in this consideration, that he who hath thus violated the fundamental principles of government, and broken his part of the original contract between king and people, hath abandoned his connections with society, and hath no longer any right to those advantages which before belonged to him purely as a member of the community, among which social advantages the right of transferring or transmitting property to others is one of the chief. Such forfeitures, moreover, whereby his posterity must suffer as well as himself, will help to restrain a man not only by the sense of his duty and dread of personal punishment, but also by his passions and natural affections, and will interest every dependent and relation he has to keep him from offending, according to that beautiful sentiment of Cicero, Nec vero me fugit quam sit acerbum, parentem celera filiorium poenis lui, sed hoc praeclare ligibus comparatum est, ut caritas liberorum amicores parentes republicae rederet. And therefore Aulus Coccelius, a Roman lawyer in the time of the Triumvirate, used to boast that he had two reasons for despising the power of tyrants, his old age and his want of children, for children are pledges to the prince of the father's obedience. Yet many nations have thought that this posthumous punishment favors of hardship to the innocent, especially for crimes that do not strike at the very root and foundation of society, as treason against the government expressly does. And therefore, though confiscations were very frequent in the times of the earlier emperors, yet Arcadius and Honorius, in every other instance but that of treason, thought it more just, ibi esse poenam, ubi et noxa est, and ordered that peccata suos teneant auctores, netulterius progrediatur metus, quam reparator delictum. And Justinian also made a law to restrain the punishment of relations, which directs the forfeiture to go, except in the case of crimen majestatis, to the next of kin to the delinquent. On the other hand, the Macedonian laws extended even the capital punishment of treason, not only to the children, but to all the relations of the delinquent, and of course their estates must also be forfeited, as no man was left to inherit them. And in Germany, by the famous Golden Bull, copied almost verbatim from Justinian's code, the lives of the sons of such as conspire to kill an elector are spared, as it is expressed by the emperor's particular bounty, but they are deprived of all their effects and rights of succession, and are rendered incapable of any honor ecclesiastical or civil, to the end that, being always poor and necessitous, they may forever be accompanied by the infamy of their father, may languish in continual indigence, and may find, says this merciless edict, their punishment in living and their relief in dying. With us in England, forfeiture of lands and tenements to the crown for treason is by no means derived from the feudal policy, as has been already observed, but was antecedent to the establishment of that system in this island, being transmitted from our Saxon ancestors and forming a part of the ancient Scandinavian constitution. But in some treasons relating to the coin, which, as we formerly observed, seems rather a species of the crimen falsi than the crimen laesae majestatis, it is provided by the several modern statutes which constitute the offense that it shall work no forfeiture of lands. And in order to abolish such hereditary punishment entirely, it was enacted by statute 7 N. C. 21 that after the decease of the late pretender, no attainder for treason should extend to the disinheriting of any heir, nor to the prejudice of any person other than the traitor himself. By which the law of forfeitures for high treason would by this time have been at an end, had not a subsequent statute intervened to give them a longer duration. The history of this matter is somewhat singular and worthy of observation. At the time of the Union, the crime of treason in Scotland was, by the Scots law, in many respects different from that of treason in England, and particularly in its consequence of forfeitures of entailed estates, which was more peculiarly English. Yet it seemed necessary that a crime so nearly affecting government should, both in its essence and consequences, be put upon the same footing in both parts of the United Kingdoms. In new modeling these laws, the Scotch nation and the English House of Commons struggle hard, partly to maintain and partly to acquire a total immunity from forfeiture and corruption of blood, which the House of Lords has firmly resisted. At length a compromise was agreed to which is established by this statute, viz., that the same crimes and no other should be treason in Scotland that are so in England, and that the English forfeitures and corruption of blood should take place in Scotland till the death of the then Pretender, and then cease throughout the whole of Great Britain. The Lords artfully proposing this temporary clause, in hopes, it is said, that the prudence of succeeding Parliaments would make it perpetual. This has partly been done by the Statute 17 George II. c. 39, made in the year preceding the late rebellion, the operation of these indemnifying clauses being thereby still farther suspended till the death of the sons of the Pretender. In petit treason and felony, the offender also forfeits all his chattel interests absolutely, and the profits of all estates of freehold during life, and after his death all his lands and tenements in fee simple, but not those in tail, to the crown for a very short period of time. For the king shall have them for a year and a day, and may commit therein what waste he pleases, which is called the king's year, day, and waste. Formerly, the king had only a liberty of committing waste on the lands of felons by pulling down their houses, extirpating their gardens, plowing their meadows, and cutting down their woods. And a punishment of similar spirit appears to have obtained in the Oriental countries from the decrees of Nebuchadnezzar and Cyrus in the books of Daniel and Ezra, which besides the pain of death inflicted on the delinquents there specified, ordain that their houses shall be made a dunghill. But this tending greatly to the prejudice of the public, it was agreed in the reign of Henry I. in this kingdom that the king should have the profits of the land for 1 year and a day in lieu of the destruction he was otherwise at liberty to commit, and therefore Magna Carta provides that the king shall only hold such lands for a year and a day, and then restore them to the lord of the fee without any mention made of waste. But the Statute 17 Edward II de Praerogativa Regis seems to suppose that the king shall have his year, day, and waste, and not the year and a day instead of waste, which Sir Edward Coke and the author of the Mirror before him very justly look upon as an encroachment, though a very ancient one, of the royal prerogative. This year, day, and waste are now usually compounded for, but otherwise they regularly belong to the crown, and, after their expiration, the land would naturally have descended to the heir, as in Gavelkind tenure it still does, did not its feudal quality intercept such descent and give it by way of escheat to the lord. These forfeitures for felony do also arise upon attainder, and therefore a fellow de se forfeits no lands of inheritance or freehold, for he is never attainted as a felon. They likewise relate back to the time of the offense committed, as well as forfeitures for treason, so as to avoid all intermediate charges and conveyances. This may be hard upon such as have unwarily engaged with the offender, but the cruelty and reproach must lie on the part, not of the law, but of the criminal, who has thus knowingly and dishonestly involved others in his own calamities. These are all the forfeitures of real estates created by the common law as consequential upon attainders by judgment of death or outlawry. I here omit the particular forfeitures created by the statutes of praemunire and others, because I look upon them rather as a part of the judgment and penalty inflicted by the respective statutes than as consequences of such judgment, as in treason and felony they are. But I shall just mention under this division of real estates the forfeiture of the profits of lands during life, which extends to two other instances besides those already spoken of, misprision of treason, and striking in Westminster Hall, or drawing a weapon upon a judge there sitting the King's Courts of Justice. The forfeiture of goods and chattels accrues in every one of the higher kinds of offense, in high treason or misprision thereof, petit treason, felonies of all sorts whether clergyable or not, self-murder or felony de se, petty larceny, standing mute, and the above-mentioned offense of striking in Westminster Hall. For flight also on an accusation of treason, felony, or even petite larceny, whether the party be found guilty or acquitted, if the jury find the flight, the party shall forfeit his goods and chattels, for the very flight is an offense carrying with it a strong presumption of guilt, and is at least an endeavor to elude and stifle the course of justice prescribed by law. But the jury very seldom find the flight, forfeiture being looked upon, since the vast increase of personal property of late years, as rather too large a penalty for an offense to which a man is prompted by the natural love of liberty. There is a remarkable difference or two between the forfeiture of lands and of goods and chattels. 1. Lands are forfeited upon attainder and not before. Goods and chattels are forfeited by conviction, because in many of the cases where goods are forfeited, there never is any attainder, which happens only where judgment of death or outlawry is given. Therefore, in those cases, the forfeiture must be upon conviction or not at all, and being necessarily upon conviction in those, it is so ordered in all other cases, for the law loves uniformity. 2. In outlawries for treason or felony, lands are forfeited only by the judgment, but the goods and chattels are forfeited by a man's being first put in the exigent without staying till he is quinto exactus or finally outlawed, for the secreting himself so long from the justice is construed a flight in law. 3. The forfeiture of lands has relation to the time of the fact committed, so as to avoid all subsequent sales and encumbrances, but the forfeiture of goods and chattels has no relation backwards, so that those only which a man has at the time of conviction shall be forfeited. Therefore, a traitor or felon may bona fide sell any of his chattels, real or personal, for the sustenance of himself and family between the fact and conviction, for personal property is of so fluctuating a nature that it passes through many hands in a short time, and no buyer could be safe if he were liable to return the goods which he had fairly bought, provided any of the prior vendors had committed a treason or felony. Yet if they be collusively and not bona fide parted with, merely to defraud the crown, the law, and particularly the statute 13 Elizabeth c. 5, will reach them, for they are all the while truly and substantially the goods of the offender, and as he, if acquitted, might recover them himself, as not parted with for a good consideration, so, in case he happens to be convicted, the law will recover them for the king. 2. Another immediate consequence of attainder is the corruption of blood, both upwards and downwards, so that an attainted person can neither inherit lands or other hereditaments from his ancestors, nor retain those he is already in possession of, nor transmit them by descent to any heir, but the same shall escheat to the lord of the fee, subject to the king's superior right of forfeiture, and the person attainted shall also obstruct all descents to his posterity, wherever they are obliged to derive a title through him to a remoter ancestor. This is one of those notions which our laws have adopted from the feudal constitutions at the time of the Norman conquest, as appears from its being unknown in those tenures which are indisputably Saxon or Gavelkind, wherein though by treason, according to the ancient Saxon laws, the land is forfeited to the king, yet no corruption of blood, no impediment of descents ensues, and on judgment of mere felony no escheat accrues to the Lord. And therefore, as every other oppressive mark of feudal tenure is now happily worn away in these kingdoms, it is to be hoped that this corruption of blood, with all its connected consequences, not only of present escheat, but of future incapacities of inheritance, even to the 20th generation, may in process of time be abolished by act of Parliament, as it stands upon a very different footing from the forfeiture of lands for high treason affecting the king's person or government. And indeed, the legislature has, from time to time, appeared very inclinable to give away so equitable a provision by enacting that, in treasons respecting the papal supremacy and counterfeiting the public coin, and in many of the new-made felonies created since the reign of Henry VIII by Act of Parliament, corruption of blood shall be saved. But as in some of the acts for creating felonies, and those not of the most atrocious kind, this saving was neglected or forgotten to be made, it seems to be highly reasonable and expedient to antiquate the whole of this doctrine by one undistinguishing law, especially as by the aforementioned statute of 7 Ann c. 21, the operation of which is postponed by statute 17 George II c. 39, after the death of the sons of the late pretender, no attainder for treason will extend to the disinheriting any heir, nor the prejudice of any person other than the offender himself, which virtually abolishes all corruption of blood for treason, though, unless the legislature should interpose, it will still continue for many sorts of felony. End of chapter the 29th, part 2.